Are they the first ones here? This is them?
Good morning. This is Dalia Romero, Spanish interpreter on the line, already sworn in today.
Okay. Judge Shoemaker here.
Good morning, Your Honor.
All right. We need the public defender and state attorney's names on the record.
Brenda Eugene on behalf of the State Attorney's Office.
Letitia George on behalf of the Office of the Public Defender.
Okay. What is your name?
José Alberto Ortiz Sierra.
Jose Alberto Ortiz Sierra.
I'm not sure if you've been appointed.
Okay, we're going to appoint the public defender's office for you. And there is probable cause for battery, domestic violence. I was going to set this at pretrial release, no contact. Oh, we have a victim. What is your name?
Hi, I'm Luz Escamparle. I'm his aunt.
Yours mom?
Aunt. The aunt.
The aunt. So you're the victim in the case?
Well, yeah, you want to call it that.
Yeah, that's what I have to call you for a while
Yes.
anyway. Okay, and what would you like to say, ma'am?
I need to have contact with him. He's a psychiatric patient and he's got multiple medical appointments. I usually help my mother, who is the one that he lives with.
Okay,
And I take him to different places for his doctor appointments. I have one coming up on the 20th.
okay,
He's never been aggressive towards me in his 41 years. He just shoved me yesterday. He was kind of very upset. He has psychosis, bipolarism, and schizophrenia. So it's the first time he got this way. The appointment that we have coming up is for his psych evaluation. Maybe he needs different meds. So,
okay. So you're not in fear of him?
no.
No? All right. And he's going to reside with you?
He lives with my mom. No, he doesn't live with me.
Okay. He's going to reside with the mother.
So it's the grandma and his mom that he lives with. It's my sister.
Okay, state what I was going to do is release him on pretrial release with, at this point, no hostile contact with the victim.
No objection.
Okay, so he can reside wherever he'd like to.
Okay.
If you want him to reside with you, you can, but otherwise he can live with his mother wherever.
Yeah, he lives with his mom and
Okay.
my mother. So, and I
Well-
live in a different place. So
All right, we'll
I
order
only
no
have
hostile
with
contact.
appointments.
Mental health, pretrial release.
No, he's already got medical appointments?
We have one for the 20th coming up, and then he's a patient at Lakeside.
He is.
It's been for years. So,
Okay. All right, we'll order him to continue seeing his doctors. The condition of his release. So we'll order mental health pretrial release. If he does not qualify, then we'll do straight up pretrial release. Okay? All right, thank you.
thank you.
All right, your name, sir?
Eduardo Pavón González. Sí.
Eduardo Pavon Gonzalez.
Okay, you have an out-of-county warrant. There's currently no bond. So at this point, I'll just appoint the public defender here until they get you transport. I don't know how long you're taking to transport. Do they know any? Don't know? Okay, so we'll just appoint the public defender for now. There's no bond. And that's all the interpreters? Okay, thank you, interpreter.
You're welcome, Your Honor. Thank you.
Bye. All right, so in all these
So this
cases,
here,
in all these
Paul
cases,
Clark,
what's that?
Paul Clark is mental health.
Is that our next one, clerk? Yes, mental health reset.
Yes, Your Honor, we reset him for today because there was an offer on the case to see if he would be able to appear in court to resolve the case. However, since he is still mental health, we'll waive the appearance.
All right, so you're going to waive
Yes,
today?
yes, Your Honor.
All right. All right, so that'll just go to the division, I reckon, at this point.
I'm not sure if a bond was set yesterday or if there's already a bond, Your Honor.
250,
Okay, thank you.
that'll be stayed. All right. In all these cases today, I have found probable cause, or there was already probable cause determined by a warrant. And I will be appointing the public defenders unless stated otherwise. If the public defender has an objection to probable cause on something, certainly bring it to my attention. I can relook at it.
Yes, Your Honor, thank you.
And when we have victims, there'll be no contact unless stated otherwise. Okay,
Ray Lamar,
yes.
he refused court.
He doesn't want to visit us, okay.
Your Honor, he was just supposed to come to court just to, speak on his two fads from yesterday that weren't addressed, but Judge Gibson took no action on his other fad due to the competency that he has.
Yes, Your Honor, so I would just ask that you take no action. He has been deemed incompetent by the court.
Okay, so we'll take no action on this today.
And those are on both cases,
Yes.
correct? Okay.
So are these going to be reset here?
No, Your Honor, he was already seen yesterday. A bond was set on his new law offense, and I believe these are out on bond cases.
Okay. It'll be stayed.
(2021) MO 777 AO and 2021 MO 1041 AO.
Oh, am I supposed to be scanning?
41 AO.
Nobody reminded me. Come on now. Once you get 60, you can, you know. Okay, what's your name, sir?
Shaquille Tucker.
Okay, Mr. Tucker. You have charges of sexual battery with a deadly weapon, kidnapping, false imprisonment, battery, domestic violence. And let's see. Warrant here. And the bonds are currently no bond on count 1 and 2, 3,000 on count 3, and no bond on count 4, which is the battery domestic violence, which I have to set a bond on that one. Is there a victim here?
No, Your Honor.
No.
It's a PB.
Both of them.
All right, so I will order no contact with that victim, no return to the residence, and we'll set a $5,000 bond on that charge. Public defender is appointed. All right, anything else from either side?
Your Honor, with regard to counts 1 and 2, as they are punishable by life, I would ask defendant be held no bond.
Right. Those are stayed.
And are you taking any action on the out on bond, Your Honor?
Defendant out on bond and the 20, yeah, that bond will be revoked and go to no bond at this time.
On all 3 cases?
Yes.
Okay, thank you.
All right, what is your name?
Crystal Bridges.
So violation of probation, there's no bond. Public defender is appointed.
There is a victim,
Okay.
victim, Your Honor.
All right, what is your name?
Alicia Williams.
All right, and this is a battery, domestic, and resisting without violence of the other charges. And what would you like to say?
I'm gonna have to have contact with her. I'm psychotic. I'm suicidal, and I got schizophrenic. I'm diagnosed with all that. She's my payee, and she's my wife. She never touched me. It just was a misunderstanding. I was saying I had COVID, and I grabbed her, and she pushed me off her, and they said it was battery.
All right, so it sounds like you're not in fear of her?
No.
No? Okay.
But-
Anything from state or defense?
Can I say one more thing?
Go ahead.
I went to the hospital and they said they can fax you over my Baker acting paper because they only arrested her because I had a scratch on my face. And this happened when I was Baker acted. So they need a fax number and a judge name so they can fax it over.
Okay, anything from state or defense?
I have no questions, Your Honor. I would just ask for a non-hostile contact order, given the victim's testimony.
Your Honor, I have no position on this case. However, there is a violation of probation, and the defendant is a violent felony offender of special concern. So I believe she has to be held for at least 5 days.
Right. Well, there's no bond on the VOP. That'll stay till that judge sees her. And then on these charges, on the battery, domestic violence, it'll be a $500 bond, no hostile contact, and the resisting will be a $500 bond.
So I can't have contact and she's my payee?
No hostile contact.
Okay. Okay.
That's based upon the facts and your testimony, okay?
Yes, sir.
Okay, but she can't get out till the probation judge sees her.
Okay, thank you.
Okay. Because I'm not scanning.
I'm looking straight ahead. Oh my, okay.
All right, what is your name?
Michelle Lynn Casares Valdez.
Okay, this appears to be 21 CF 12615AO. And let's see. This is a warrant on an aggravated assault charge, it looks like, and we'll appoint the public defender's office.
And I believe there is a victim, Your Honor.
There's what?
A victim?
A victim.
Yes, Your Honor.
Okay. All right, what is your name?
Armando Martinez.
State, I don't have the facts. I don't know, is that your victim?
Yeah.
I just have the warrant, I don't have the affidavit.
One moment.
appearance and enter denial.
Yes, Your Honor. The victim is Armando Martinez Rojas.
All right. Is that your name, sir?
Yes.
Okay. And what did you want to say?
I say I don't want to put a charge on her.
You don't what?
I don't want to put a charge on her.
You don't want to press charges?
No.
Okay. Anything from the state or defense?
Nothing from the state, Your Honor.
Would you like contact?
Yes.
No further questions, Your Honor. Your Honor, given the testimony by the victim, I would just ask for a no hostile contact order.
State, you have anything?
Your Honor, I would ask for no contact. The allegation is that the defendant came up behind the victim with a knife, placed it on the left side of his neck, and stated, "I will kill you." And at that time, the victim was in fear for his life.
Do you know if there's been any prior incidents between the two?
None that I can find in Orange County, Your Honor, but if you give me time, I can see if there are any outside of the county.
Yes, Your Honor. I see on February 24th of this year, she was arrested for battery, domestic violence, same victim.
All right, I'm going to set bond at $2,500, but I am going to order no contact with the victim, separate residence, no weapons.
Your Honor, can there be a one-time return with law enforcement to gather any belongings?
Yes, you may return one time only with law enforcement to pick up her personal items. Okay, what is your name, sir?
Joshua Mondesir.
All right, this should be, let's see. Case number 2021 CF 13240AO. This is a battery, domestic strangulation, and tampering with witnesses to hinder communication. Do you want the public defender appointed?
Yes.
Yes? Are you employed right now?
Yes, I'm employed.
While you're in jail, you're employed?
Oh, no.
No. Okay.
No, I still have my job if I get out. That's what I'm saying.
All right, at this point, I'll go ahead and appoint the public defender's office.
He does qualify for pretrial release, Your Honor. I would just ask for pretrial release.
And what's the state's position?
Your Honor, if there can also be a monetary bond, this was not a one-off. He struck the victim, strangled, walked away, came back, struck the victim again. So I would at least ask for a monetary bond if you are going to go with pretrial release.
That was
What about any prior domestic between the two of them?
I'm looking, Your Honor. I apologize. The two that I was able to find, Your Honor, are not with the same victim.
What's that?
The two prior incidents of domestic violence that I was able to find are not with the same victim.
Okay. All right, so on count one, there will be a $2,500 bond, no contact with the victim, separate residence, no weapons. And count two will have a $100 bond.
Was that straight bond, Your Honor, or with pretrial?
Straight bond.
Okay, thank you.
Your name?
Whitaker Smith.
Okay, this should be 2021 CF 13236AO. Battery, domestic strangulation, and battery domestic. And let's see, what is your name?
Contessa Smith.
Okay, and what would you like to say?
I don't want him returning to the residence.
Okay. Has law enforcement been called before out there?
Not at this particular location. It's been about 5 years since a law enforcement situation. But I will be going to the courthouse and filing an injunction for him to stay away from me and my daughter completely for good this time.
Okay, any questions, state or defense?
Yes, sir. I would just like.
No. No questions from defense.
Nothing from the state, Your Honor.
Okay, so on the battery domestic, that will be a $5,000 bond, no contact with the victim, separate residence, no weapons. And count two will be an additional $500 bond, same conditions. And then there's some other things, right? Or not?
Your Honor, can there be a one-time return with law enforcement to gather any belongings?
Yes, he may return to the residence only with a law enforcement officer to pick up his personal items.
Your Honor, He has a mother and a brother that I spoke to his mother this morning. I would gladly pack up his vehicle for his mother and his brother to come get his belongings. I don't want him returning to the
He'll
location.
only show up with a law enforcement officer. Otherwise, he's in violation. You can pack it up and you can have her come get it, and if it's all gone, it's all gone. It's just his personal items.
Okay.
It's not furniture and all that kind of stuff. Are those his only charges? Okay, I'm confusing him with someone else already. Okay. Public defender's appointed, yes. All right, what is your name?
Jeffrey Stevens.
Stevens?
Yes, sir.
Okay, I'm assuming while you're in custody, you do not have a job that's paying you?
You said, do I have a job?
It's paying you while you're in jail?
I mean, I have a job, but will they pay me while I'm in jail? I don't think so, because I'm not working, but I
Right.
have a job.
Okay, so you don't have any income while you're in jail?
No, sir.
Okay, I will appoint the public defender's office. All right, this is aggravated assault with a deadly weapon, domestic and false imprisonment. And make sure I got the case number, 21 CF 12300AO. And this was an arrest warrant. Okay. And there's not a victim here. Anything from the state as far as bonds?
I leave it at the court's discretion, Your Honor.
He's a high risk. And he has active warrants out of Georgia. So I'll set count one at $25,000, no contact with the victim, no weapons, no return to the scene, and 500 on the false imprisonment. Okay, your name? Childs, let's see, this should be case number 21MM6835AO. Battery, domestic violence, I don't see a victim here. This was an arrest warrant, so there's probable cause. Anything from the state?
Nothing, Your Honor.
I don't have an arrest affidavit. So do you have, you gonna print one? Okay. Thank you. All right, this is a high risk with 10 prior felonies and 8 misdemeanors. So I'm going to set your bond at $5,000, no contact with the victim, no return to the scene. And we appointed the PD? We will. Yes, no weapons, separate residence.
Your Honor, one-time return with law.
Yes, may return one time with law enforcement only to pick up your personal items.
You appointed us, correct, Your Honor? I didn't-
Yes, PD's appointed on all cases unless I state otherwise.
Okay, thank you.
Make it easier.
Reginald Morris,
Yes,
mental health, but the victim is here.
so Morris is not here?
No, he's mental health, Your Honor.
Okay, so we're going to have to reset him?
Will he be? No, Your Honor, I'll waive the appearance.
Okay, so public defender is appointed. All right, what is your name?
Takevia Jackson.
Speak up.
Takevia Jackson.
Jackson. Okay, what did you want to say?
I don't want to press charges.
Okay. Anything else?
No, sir.
Can't hear you.
No, sir.
I just have one question. Would you like contact with Mr. Morris?
Yes, that's fine.
Your Honor, I would just ask for a no hostile contact order, given the victim's testimony.
Your Honor, if I could ask a question?
Sure.
Good morning, ma'am. Has something like this happened before?
No, ma'am.
Are you afraid of him? No. Okay. No, I have no further questions, Your Honor.
It's a high-risk assessment, 5 felonies, 9 misdemeanors, failures to appear. He's got violent history. All right, on battery domestic, I'm going to set a $5,000 bond. At this point, I'm going to order no contact, separate residence, no weapons, no return, and $500 on the criminal mischief.
I'm not sure if they live together, but the one-time return, Your Honor, with law.
Yes, one-time return with law enforcement to pick up personal items. Okay, thank you, ma'am. What is your name?
Christian Quinones.
Davila?
Hmm?
Okay, 21MM 7105AO, battery domestic violence. The public defender appointed.
And there's a victim.
All right, what is your name, ma'am?
Anaya.
What is it?
Anaya.
Okay, what would you like to say today?
I don't want to press charges. This was all a big misunderstanding.
I had $1 for every time I heard a misunderstanding, or even a penny.
I just,
All right, has there been any prior problems between you two? No? You got to speak up.
No.
State, do you show anything prior?
I do not, Your Honor.
All right.
Your
All right.
Honor, I would asked for a no hostile contact, given his history, doesn't appear he has any. And the victim not wanting to press charges.
And does he qualify for pretrial?
He does, Your Honor.
He does?
Yes.
All right, so we'll release you on pretrial release. We'll order no hostile contact with her, so nothing violent or hostile with you, but he can return home or whatever the two of you decide.
I just have a question. His dad is downstairs and I have to translate all this stuff for him because he doesn't know any English. So, is he, like, what's gonna happen?
Does he need an interpreter?
No, his dad, not him, his dad.
Oh, his dad.
Yeah.
So what are you asking me?
Like, what's gonna happen, like, now? Like, do we wait for him? Do we leave?
Yeah, he'll be released. I don't know how long that takes. And probably 2 to 4 hours is a guess.
So would it be okay for us to, like, wait downstairs or, like, do?
I would assume so, unless there's a COVID issue going on.
No, I'm just asking because I have to translate all this stuff for his dad. His dad doesn't know any English.
Okay. So yeah, apparently it's okay for you to wait there. You got pretty much, if they tell you no, then you can't, but you should be able to.
How will we know when he's,
I can
like,
give you a call once he's released.
okay,
Okay?
okay.
All right.
Does he have a bond that I have to pay?
No,
No?
no money.
Okay.
All right, what is your name?
Stanley Roche.
Okay, your charge, or your case number is 2021 MM 7109AO, battery domestic violence. And what is your name, sir?
Obed Lobun.
What is it?
Obed Lobun.
All right, and what did you want to say?
I want to press charges.
You do or do not?
Yes, I do.
You do, okay. Are you in fear of him?
I'm sorry?
Are you in fear of him?
Yes, because he could choke me.
Okay.
Would I be able to speak to him?
Public defender is appointed. Anything from the public defender?
It's my main
No,
residence.
no, Your Honor. He does qualify for pretrial release. I would ask for pretrial release.
Anything from the state? Other than no hostile conduct, obviously, or no contact? All right.
Nothing from the state, Your Honor.
Okay, I'm going to release him through pretrial release. No contact with the victim, no return to the scene, except one time with law enforcement to pick up any personal items he may have. No weapons.
Still a little too early. Let's get him.
Okay.
So no, there's no bond.
All right, your name?
Ethan Rodriguez.
Kristen Rodriguez?
Yes, sir.
All right. 2021 MM 7107AO, battery domestic violence. And we'll appoint the public defender for you today. You can always hire a private lawyer if you choose to.
There is a victim here.
What do you say?
And what is your name?
Mano Kudre.
What is your name again?
Mano Kudre.
Okay. And what did you like to say, ma'am?
I would not like to press any charges. This has been an all big misunderstanding. I would just like him to come home.
Any prior incidents?
No, sir.
And State, do you have anything you want to say or add?
No, Your Honor.
Your Honor, I would just ask for no hostile contact order.
All right, so you're not in fear?
No, sir.
All right, so I'll release him through pretrial release, which means you don't have to post any money. We'll order him to have no hostile contact with you. So he can have contact, stay with you, just nothing violent or hostile.
He has never laid a hand on me. He's a paramedic. He does only good. He only
Okay.
helps.
Well, just so we understand.
Yes, sir.
Okay, anything else? Okay.
Yeah, no, I mixed them up. I'll tell you later.
All right, your name?
John Delapia.
2021. No, this is, what is this case number? Oh, it's Pinellas County. That's what threw me off. Okay. This is an out-of-county warrant. Bond was set at $15,013. Violation of probation. We'll appoint the public defender here to help you.
Morris.
Which one?
And that's all we have for you.
Okay. No hostile contact.
No contact.
Okay, just want to make sure.
All right, your name?
Calvin Arazo.
What is it?
Arazo. Erazo. Kelvin.
So what is your first name?
Kelvin. Kelvin.
Okay, Roser. This is another out-of-county warrant. Looks like Lake County, there's currently no bond for tampering, for harassing a witness. We'll go ahead and appoint the public defender to help you while you're here. And they should transport you out as soon as they can.
That's one.
Your name? All right, so this is out-of-county warrants out of Seminole County. There's currently no bond. We'll appoint the public defender while you're here to help you. And they should pick you up as soon as they can get you.
And are you taking any action on her out on bond, Your Honor?
Is out on bond here?
Yes.
Was she out on bond at the time of these offenses?
I don't know the dates of the,
Yeah.
Usually they take no action because we can't tell which occurred.
What's that?
Usually they take no action because we can't tell.
I was going to see if the state knew anything.
Your Honor, I can tell you that for the offense here, she was arrested April 21st, but no, I don't have any information on the out-of-county warrant.
Okay, so we'll take no action on those at this point. Of course, the assigned judge can go in and revoke the bonds if he or she chooses to. Okay, your name?
Zara Dow.
Okay. Appears to be 2021 CF 13460AO, violation of probation. There's currently no bond, and then there's a theft charge, and which I will set a $1,000 bond, no return to the scene of the theft. And then there's contributing to a delinquency of a minor. Will be an additional $100. Public defenders appointed.
Your Honor, can you give the case number for the new case, please?
The new cases are, let's see, 21 MM 7111AO.
Thank you.
Okay. All right, your name?
Barbara Johnson.
Johnson. All right, looks like Division 19, 2020 CF 11348AO, violation of probation. There's currently no bond. Disorderly conduct, $250 bond. Public defenders appointed. And let's see. Disorderly conduct is a 21 MO 1159 AO. Your name?
Mike and St. Joseph.
Mr. Joseph. Okay. We have a violation of probation. There's currently no bond. Looks like out of Polk County. Is that right?
Orange County.
Orange County, okay. That's Division 19, 2018 CF 9752AO. Public defender is appointed. And that's all for you at this time. All right, your name?
Ronnie David Luster.
All right, Mr. Lester. Division 19, 2019 CF 12430AO, violation of probation. It's currently no bond. Public defender will be appointed. And that's all for you. All right, your name?
Anthony Scott.
All right, Mr. Scott, your Division 22, 21 CF 1224AO. It's a violation of probation. And for some reason, Judge LeBlanc did set a warrant, or a bond on the warrant, so that bond is $5,000. So we'll release you on a bond of $5,000. You're not to possess any weapons. And there's a, all right, that's all for you. Okay, your name? What is it?
Tommy Ward.
Tommy Ward?
Yes.
Division 12, 20 CF, 2020 CF, 10822AO, violation of probation. And the judge also set a bond on your case of $5,000. That's for failing completing the batter's intervention program, it looks like. Okay, that's Division 12. Public defender will be appointed. And that's all for you. That's it for the morning. We have a 33-day motion.
Yes, Your Honor.
Okay. All right. So the 33-day motion on Bradford State.
Case number 21 CF 12010, granted notice of non-filing. Granted notice of non-filing.
You're non-filing.
Yes, Your Honor.
Okay, so this will be granted.
Yes, Your Honor.
Put it right on top of it. All right, what is today? Ready? Hello? All right, attorneys need your name on the record.
Brenda Eugene, on behalf of the State Attorney's Office.
Letitia George on behalf of the Office of the Public Defender.
This is not Ms. Stevens.
The interpreter?
The interpreter is on the line, yes.
Is this Portuguese interpreter?
The interpreter is on the line, yes.
Portuguese?
Portuguese, yes.
Okay. And that's the top one here. Okay, we have, let's see, 2021 MM 7093AO. And this is Benjamin De Silva Valentine.
Então, a gente tem o caso 2021O do senhor Benjamin da Silva Valentino.
Sim.
Yes.
You're charged with trespass on property after warning.
Está sendo acusado de ter transpassado em propriedade, mesmo depois de ter sido orientado a não fazer.
I will appoint the Public Defender's Office to represent you.
Eu vou apontar o escritório da Defensoria Pública para representar o senhor.
All right, and this already has a bond set of $500. It's probable cause. What, anything from the Public Defender?
No, Your Honor, there's no offer today to resolve.
Okay. So the
Então, existe.
Public Defender will get a hold of him?
Yes, Your Honor.
Okay.
Your Honor, can we have the condition of no return to the scene?
Yes, no return to the scene. Of course, no contact with victims.
Então, existe o valor de $500 de pagamento de fiança com causa provável e o escritório de Defensoria Pública vai entrar em contato com o senhor. Eu poderia, senhor juiz, fazer o pedido de condição de não voltar mais para a cena nem contactar a vítima, sim.
Okay, so they can take him back now?
Você pode levar ele de volta.
All right, thank you, interpreter.
Thanks so much for using our services. Have a great afternoon.
All right,
Bye.
bye.
Good afternoon, Your Honor. This is Laura Arroyo, State Certified Interpreter and previously sworn today.
Okay, this is Judge Shoemaker, and let's see, our first one is Nelson Guzman Rodriguez.
Sí, te escucho.
Connection is established, Your Honor.
And that looks like there's two cases. 2021 CT 4193 and 21 CT 1736. And how much income do you have, sir? What is your name, first of all?
Okay, mi nombre es Nelson. Okay, mi nombre es Nelson Guzmán Rodríguez.
My name is Nelson Gomez Rodriguez.
No, Guzmán.
Sorry, Guzman.
Okay. And do you have income? Do you have a job and make money right now?
Yes, sí.
Yes.
How much money do you make?
Como 1,200 semanales.
About 1,200 a week.
Are you being paid while you're in jail?
Mientras estoy aquí adentro, no. El único ingreso que tuve fue el último cobro, pero no vino con las horas completas, so solamente tengo para pagar el bond.
The last payment I received was for the last time I was working, and it wasn't for the full complete hours. So the amount that I got was enough just to pay the bond.
All right, I'm going to go ahead and appoint the public defender's office for you. The bond on the failure to appear is $2,000. And on the suspended license charge, it's $500.
Y el bond sería de 300, ¿verdad?
Bond would be 300.
Bond is $2,000 and $500, so it's probably about $300 to a bondsman, if that's what you're asking.
Did you say 300, Your Honor?
Yes, that's probably what a bondsman would charge to bond him out.
Okay.
Okay.
Okay. All right, what is your name?
Esvin Leonel Jiménez Miranda. Esvin Leonel Jiménez Miranda.
Esmi Leonel Jiménez Miranda.
Sí.
All right, and are you being paid while you're in jail?
¿Ingreso de qué?
Payment from what?
Any income? Do you have any income while you're here in jail?
¿La del bono dices? ¿La del bono qué dices?
Are you referring to the bond?
No. Are you receiving any money from any source, from your employment, Social Security, or anything like that right now, while you're in jail?
No. No.
No?
No. Okay, so I'm going to appoint the public defender's office. And let's see. You have new charges: driving under the influence of alcohol, and driving while license suspended with knowledge. And it appears you're out on bond for those same offenses. So those cases you're out on bond, you're going to get a no bond. And I'll stay your bonds on your new cases. And order you not to drive a vehicle without a valid license. All right, that's all for you, sir. All right.
Your Honor, may I have the case number, please?
For the last one,
I was asking if you could please give me the case number that, for the gentleman we just did?
It's two case numbers, it's 21 CT 1737 AW and 21 CT 1738.
Sorry, 17?
38.
Thank you.
1737 1738.
Thank you.
okay, what is your name, sir?
Ramón Ernesto Rodríguez Vargas. Ramón Ernesto Rodríguez Vargas.
Ramón Ernesto Rodríguez Baldos.
So do you need the public defender appointed for your charges?
¿Perdón? ¿Perdón?
Sorry?
Do you
No
need
le
a
escuché
public
bien.
defender appointed to represent you?
Sí.
Yes.
Okay, so we're going to appoint the public defender's office. All right, so the new charges are criminal conspiracy and criminal enterprise, in which there's bond set of $11,000. It's based on an arrest affidavit, arrest warrant. Now, state, was he out on bond?
Let me double check, Your Honor.
I don't think he was.
Yes, Your Honor. He was out on bond. He posted bond August 18th. He was arrested August 16th.
Say that again?
He was arrested August 16th. He posted bond August 18th.
He was arrested on August 16th. He bonded on August 17th. And then he had an arrest warrant. It says between September, so he must have been out on
It
bond.
was, Your Honor,
It says between September 22nd, and it was released on this on August, so he must have been out. Everybody agree?
prior to, Your Honor. And
Some of it may have,
stating that on August 16th in the warrant, the deputy was patrolling when he witnessed a white pickup truck. That seems to be the same day he was arrested for August 16th of 2021. So they have more than one date. They have one for on June 1st, 2021. He witnessed one crime committed, the officer, Deputy Williams, and then on August 13th, and then again on August 16th. But it appears he was not arrested until August 16th.
and the warrant says September 22nd. Honor between September 22nd. So I'm not going to take any action on those because I don't know, State, unless you have confusing. You can.
Okay.
That's case he's out on bond is 2021 CF 13244AO. The new one is a 2021 CF 13244. That's the same one. It's the same. Oh, okay, that's the one he's out on. All right, so the new case is a 13244AO. He was out on the 2021 CF 9669AO. Or possibly, we don't know. So your office, State, can file a motion to vote the bond if you feel it's appropriate. Okay.
I apologize, Your Honor. So what is the bond on the new case?
Bonds are stayed.
Thank you.
Is that the end of the interpreters?
Yes.
Yes, okay, thank you, interpreter.
You're welcome, Your Honor. The interpreter will disconnect.
All right, what is your name?
Dorothy Stevens.
Stevens. All right, you have a battery charge resisting without violence. Your bonds are set at 500 and 100. And we'll appoint the public defender for you. And we'll order no contact with a victim. And no return to the scene of the incident, which is the Dunkin' Donuts on North Orange Avenue.
That's it. May I say something, Judge?
You ought to talk to your attorney before you do, but
Where's my attorney?
she's right there. So these are just this group here. Okay.
Your Honor, my client stating that, all she can afford right now is $100. Would you be willing to reduce the bond?
Anything from the state on reduction of the bond?
I would ask that it remain as set, Your Honor.
Where does she live? What's your address or residence?
I've been living at the Coalition.
For how long?
I got here to town from Washington D.C. on my birthday on Sunday.
All right, I'm going to leave the bonds as set. She doesn't really have any place here.
Ricefield is medical.
Okay, so that's an in-jail arraignment. Public defender's appointed. Anything from the public defender on that?
I'll waive the appearance and enter a plea of not guilty, Your Honor.
Okay, so we'll set that for a pretrial, I reckon.
That's case number 21 MM 6633, Division 63, pretrial conference, October 28th, 1 p.m., courtroom 12C.
Ferguson, he's medical.
Ferguson. I have Corselli. Corselli. Jumping to Ferguson. Where's he jumping? He's jumping on me.
Glasses on.
Trying to jump on it. Okay, what's your name, sir?
Anthony Corso.
All right, you have the public defender appointed.
Of course, so.
Looks like a petty theft charge.
Yes, Your Honor, we're going to enter a plea of not guilty.
Okay, so that'll be set for pretrial. When and where?
That's Division 82. Pretrial conference will be November 1st at 10:30 a.m., courtroom 10B.
All right.
Sorry.
Villa Garcia is next. All right, what's your name?
Ruben Davila Garcia.
One more time.
Ruben Davila Garcia.
Okay. Public defender has been appointed. Looks like a charge of exposure of sexual organs.
I'll enter a plea of not guilty, Your Honor.
Okay, set for pretrial.
That's case number 21 MM 6400, Division 83. Pretrial conference is October 18th, 8:30 a.m., courtroom 6C.
Next is Ferguson.
He's medical, Your Honor, Ferguson.
He's what?
Medical.
Medical, okay. Public defender case?
Yes, Your Honor. I'll waive the appearance and enter a plea of not guilty.
That's case number 21 MM 7036, Division 84. Pretrial conference is November 15th, 9 a.m., courtroom 4B.
Jimmy Hadley?
She said we didn't need him.
Meadows.
Medical?
Didn't need him.
He's what? Hadley?
Hadley is in the hospital, Your Honor.
Okay,
Expire.
there's no attorney. We go ahead and appoint the public defender now to make sure he's got some representation for him.
Yes, Your Honor. I'll waive and enter a plea of not guilty.
Okay,
Division 80, that's case number 2021 MM 5840. Pretrial conference November 18th, 9 a.m., courtroom 9C.
Meadows?
It stated that Meadows was released, ROR.
Yep, it says ROR September 27th, Division 63, public defender case. Okay, so that means he already got an arraignment date, right? Richardson,
He's medical. Richardson.
public defender case, unlawful possession of identification,
Yes, we'll waive and enter a plea of not guilty.
okay? Pretrial,
Case number 2021 MM 6787, Division 84. Pretrial conference November 15th, 9 a.m., courtroom 4B.
yeah, Pruitt already bonded, it looks like. All right, what's your name?
Nell Antonio Wilson.
What is that? What is your name again?
Renell Antonio Wilson.
Wilson?
Yes, sir.
What's that one? Oh, okay. That one.
Yeah, where was he from?
This is our, all right, Toga, right? All right, so he's already been to IAs and,
I was like, who is this?
right, we're just doing attorney? You need an
Yes.
attorney appointed?
Yes, Your Honor. There was no attorney appointed, and he's been over in the jail for over 30 days, so we would just ask that you appoint the PD to represent him. Yeah.
All right, is that good, Mr. Wilson? So they can represent you and try to get you out?
Yes, sir.
Okay?
Yes.
Yes?
Yes.
Yes, okay, so public defender's appointed, and they'll be representing you now and taking care of your case. All right, what is your name?
Oh, Cardell.
Cordell, okay, let's see here. Possession of drug paraphernalia, it's Division 80. This is 2021 MM 7101AO. Do you need a public defender appointed?
No, Your Honor.
Your Honor, at this time, the state announces a no bill.
Okay, so you'll be released as to this case. They're not going to charge you with anything, all right? I don't know if anything else is holding you, but this case you'll be released on.
He does, he has holds for Osceola County.
All right, so Osceola County has a hold on you. They'll take you down there.
Osceola.
Yes. All right. All right, your name?
Franklin Cruel.
Okay. All right, you have Division 63, 2021 MM 7100 AO, new charge of petty theft. And it appears you're out on bond on a DUI, Osceola County.
Your Honor, I would just ask that if you are inclined to revoke, that you revoke in double as opposed to holding him at no bond. He has a very limited criminal history.
Hard for me to hear.
If you are inclined to revoke his out on bond, I would ask that you revoke in double as opposed to holding him at no bond due to his very limited criminal history.
What's the state's position?
No objection.
And have we appointed the public defender yet? Do you want the public defender?
Yes, Your Honor.
All right. Okay. All right, so we'll appoint the public defender's office. Okay, I'm going to revoke your bond on the 21 CT 115. And what was that bond?
DUI, Your Honor.
Um, What I'm going to do is set your bond at $2,500 on both cases, $2,500, so it's going to be a total of $5,000. I'm going to order you not to return on the theft case. To the Home Depot on South Orange Blossom Trail. Okay.
Morning, sir.
It's $2,500 each. Okay, what is your name?
Michael James Elder, sir.
All right, you have new charges of assault and resisting on Division 81, 2021 MM473AA. And it says you're out on bond for a suspended license.
Yes, sir, for driving, sir. Yes, sir.
Your Honor, I would ask again that if you are inclined to revoke, you revoke in double. Based on the facts of this case, it appears my client was under the influence at the time, and the officers were trying to Marchman Act him. So I just ask that you take that into consideration, and if you are inclined to revoke, you revoke in double. Also, it does not appear that we are appointed on his out on bond.
Can I get bonds for my bond for the charges?
It does not appear what?
I don't think we were appointed on the driving while license suspended. So if you do revoke, Your Honor, I would just ask that you appoint us so that someone's representing him while he's being held here on no bond status.
All right, so you want the public defender on the suspended license charge?
I get a bond. I want like a bond.
He's asking about an attorney. Do you want an attorney on your out on bond?
Out on bond. Oh, I'm sorry, sir. I just want to get a bond. Yes, sir. I would want an attorney. Yes, sir.
Do you want the public defender appointed on your suspended license charge?
Yes, sir. If I can get a bond, yes, sir.
Well, it's not if you get a bond. Do you want one?
Yes, sir. Yes, sir. I'm sorry. It's got 4 daughters. I got to take care of them, take them to school and stuff. I'm sorry. I just need to get a bond, please.
Well, you guys, 11 prior felonies, 19 misdemeanors, failures to appear.
That was a long time ago, sir. I've been doing real good. Please just give me a bond. I beg you. I got a little daughter. I gotta take care of. I will come to court. I always do. Pretty please. I just need a bond. I beg you.
State, what's your position?
Sir?
I never met a court.
I have no objection, Your Honor.
Thank you. I never met court. Where's it going? I still love my kids.
Okay, I'm going to stay your $500 bonds on your assault charge and your
Thank you.
obstruction. And and you're out on bond, it was 2,500.
Yes, sir. Sorry.
I'm going to double that to 5,000.
Thank you, sir.
Public defender's appointed. Stayed the other bond.
Thank you.
You said five?
5,000?
Yeah.
Any conditions of release, Your Honor?
What's that?
Are there any conditions of release?
Do you want some conditions?
On the out on bond, no driving with a,
Without a valid license?
yes.
Okay. If he does, it violates the law anyway.
Yes, sir.
So no driving, sir, without a valid license.
Yes, sir.
As if I need to tell you that, but, okay. Okay, what is your name?
Angela Maria Hocroft.
Ocroft?
Yes, sir.
Okay, trespass, failure to leave property, Division 61, case number 2021 MM 474AA.
Yes, Your Honor, there was an offer to resolve the trespass today from the state in adjudication of guilt, credit time served, and no return to the racetrack located at 1102 Hermit Smith Road. I did go over all the rights Ms. Hawcraft would be given up if she accepted the state's offer. She understands those rights and would like to resolve the case today.
Yeah, based on her history and the fact she keeps going back there, probably the minimum I would do is 30 days.
So wait, Your Honor,
Okay, Your Honor, we would just ask that you set a bond amount.
What's that?
We would just ask that you set a bond amount.
Bond is set at 500? And no return?
And you appointed us, correct, Your Honor?
Yes, I will appoint you. I'll appoint you on all the cases unless stated otherwise. Your name?
Alejandro Quijo.
Okay. Appoint the public defender for you. This is a battery charge, Division 85, 2021 MM 7106AO. Based on the facts of this case, I'm inclined to increase your bond. Anything from state or defense? Based upon your prior criminal history, several prior sexual offenses.
Your Honor, I would just argue that if you look in the arrest affidavit, the victim does state she does not want to press charges, if I'm not mistaken. So I just ask that you take that into consideration. before increasing.
The victim, in this case?
Your Honor, that is not what it says. It says that she does wish to press charges
I
since she,
misread it, I'm sorry. I misread it.
she did not give the subject permission to touch her arm.
Yeah.
Okay, sorry. That was reading it differently.
Your Honor, may I say something?
So, Your Honor, that was all I had.
I'm going to set your bond at $2,500. I'm going to order no contact with the victim and no return to the Walgreens on 408 East Michigan Street. Okay. All right, that's all for him.
Okay. Whatever.
I have Coleman's Burger,
Holmes Burger. Behavior.
behavior.
Yes.
So we'll appoint the public defender's office.
I'll waive the appearance, Your Honor.
All right, now is he out on bond?
He is.
He is, Your Honor.
Your Honor, I would just argue that if you are inclined to revoke, you revoke in double. It appears his out on bond is a nonviolent offense, a drug possession charge.
Okay, on his new theft charge, I'm going to stay that bond at 500, order him not to return to Millennia Boulevard, Macy's. I think that's a Millennia Mall, I believe.
Yeah, sure.
So no return to the Millennia Mall, no contact. Well, just no return there. He's got 2 prior felonies, failure to appear. I'm going to revoke the bond. It's going to go to no bond on the 21 MM 7095AO.
You mean 2021 CL 5776?
$5776 AO. Did I say the other one?
Yes.
Okay. I'm just seeing if you're awake. All right. What's your name, sir?
Travis Riggett, sir.
Okay. Public defenders appointed, petty theft. Bond is set at $250.
Wondering if I can, sir, get a ROR. And I've came back to court every time from the other ones.
Your Honor, I just ask that you take into consideration that,
I can't hear you.
I'd ask that you take into consideration that, my client is homeless. I believe that's why he's asking for the ROR, Your Honor.
He walked out with a case of beer.
Yeah. That was the only,
Don't talk about.
Hold on, sir. 2 felonies, 4 misdemeanors. State?
Your Honor, I would ask that you leave the bond as set. He walked out with a case of beer. He was not stealing food or any necessity. He was stealing beer.
I'll stay his bond at 500, no return to the Wawa located at 4100 East Colonial Drive. What is your name?
Emmanuel Bartholomew Strickland.
You're going to trespass on property after warning.
Okay.
Public defender is appointed.
Your Honor, there was an offer from the state of an adjudication of guilt. Credit time served and no return to, is it the Robinson, right? Located at 63 East Pine Street. I did speak to Mr. Strickland. We went over all the rights he would be giving up. He understands those rights and would like to accept the state's offer here today.
He's got 14 prior misdemeanors. Same kind of stuff, just keeps doing it. So I believe 30 days is probably where I would go with this.
Excuse me, Your Honor. My birthday is October 11th, and I was not aware that I was trespassed from this coffee shop. And I do have family coming from Connecticut to visit for my birthday. That will be my minor child, my son, my mother, my grandmother. I was wondering if we can please go ahead with the state's offer here.
No, sir.
He said no. Accept the state's. I really wanted to stay out for my birthday.
Probably should have thought about that earlier.
Your Honor, I would just ask that you.
Yeah, I didn't notice that I was trespassed, Your Honor, and I really am sorry. I won't return to the Robinson. I've been an every single day customer there, and it's my favorite coffee shop. So I couldn't imagine how I was trespassed because I spend money there every morning. And I'm regular customer. They all the workers actually know me.
Well, they had a copy of a written trespass dated October 3rd with your name on it.
Yes, I was given a trespass from sitting on the steps 1 block over in front of the art store. I wasn't trespassed from the actual Robinson coffee shop.
All right. Well, sir, I'm not going to do anything else with your case, so.
Did you say the bond, Your Honor?
Yeah, bond's $2,000, no return to the location, 63 East Pine Street, looks like.
Yes, Your Honor.
May I accept the offer for 30 days?
I'm not sure on his competence, I don't know.
No, me either, Your
Seems a
Honor.
little off. Okay, your name, sir?
Travis Ban.
Travis Ben?
Yes, sir.
Okay, you have, let's see here, we'll appoint a public defender. You have a bond on a case you failed to appear on, Division 82, 2021 MM 2655AW. And that's all we have here. That looks like it. So your bond's $250. All right, should take care of it. All right, your name?
Monte Blue.
Lou. All right, you have Division 84, 2016 MM 8079AO. You have 2 failures to appear, bond of $500 and $100. We'll appoint the Public Defender's Office.
Your Honor?
Your Honor, I would actually not appoint us. But
Not to appoint you?
no, the state.
Oh, okay, state has something?
At this time, Your Honor, the state enters a null pros for both counts.
Okay, so you'll be released as to these as to this case and these charges. I don't know if he has anything else, does he?
No, he doesn't have anything else.
No, so you'll be released. These charges are dismissed.
Okay,
Okay?
thank you, sir.
Don't thank me, thank her. All right, your name?
Eddie E. Cruz.
Cruz. Okay, first of all, you have a Division 84, failure to appear, bond of $2,000, and that's 2021 MM 6061AO. And then it says there's out on bond on a refusal to submit to breath test, Osceola, 2021 CT 1669. Failed to appear for arraignment on 9/22. So state, do you want me to revoke that bond?
Yes, Your Honor.
All right. So on the 2021 CT 1669, that bond will be revoked and go to no bond at this time.
Does he have an attorney on that case?
Attorney, if not, the public defender is appointed.
Yes, that's.
He's appointed. PD. Okay, next.
Your Honor, with regard to the new case, can it be no contact with the victim?
On which one?
The 21 MM 6061 Division 84 case, it's an assault.
Yes, no contact with the victim. There's supposed to be a order in all cases, no contact with victims. Okay, your name?
Asia Levi.
Okay, you have a failure to appear, bond set of $2,000. That's in Division 63, case number 2019 MM 6241BO. And we'll appoint the Public Defender's Office. And this says no PTR or RR. Okay. What is your name?
Gary Kenny.
Mr. Tenney. All right, you have a charge of disorderly conduct, Division 84, 21 MO 1158 AW, it looks like.
And Your Honor, I believe the state's offering a withhold of adjudication that is not served to resolve the case today.
I don't think so. 24 felonies, 33 misdemeanors, 63 unknowns. No. And I'm going to revoke his bond. And the 21 MO 1158 AW, no, the 2021 CF 7080 AO. That'll go to no bond. Disorderly conduct is $250. And that'll be stayed. Public defender's appointed.
Okay, Your Honor, you say I revoked the bond?
Yes, sir.
Which bond is that?
Ones you were out on bond on.
The trafficking case.
Okay, I see Bowen's bonded.
Owen's bonded.
Okay.
Oh, you talking to me?
Lewis bonded.
Okay, Lewis bonded. The one I had PC issue, but okay. So that brings up, who's next? Arroyo, Velasquez?
Yes, Your Honor. Firman Arroyo Velasquez.
Okay, it's Division 84 is one case with 2021 MM 7073AO. Petty theft charge. We'll appoint a public defender. And we'll stay that bond at $500, no return. To the gas station at 1755 East Econolatchee Trail. And he's out on bond for another trespassing. That bond's going to be revoked and go to no bond. And then there's a, is there also a criminal mischief? That bond will be stated $1,000. And no return to that address, 1425 Selma Avenue. Public defenders appointed.
Your Honor, can you give the case number for the criminal mischief, please?
That should be the 21 CF 13242 AO, Division 20.
Thank you.
Mm-hmm. All right, your name?
Jarvis Antonio Burton, sir.
Burton. Okay, you have new charges, several drug charges. Looks like trafficking in opium, paraphernalia charge, cocaine with intent to sell, amphetamines with intent to sell. Those bonds are 500,000, 100, 150, and 150.
Yes, these are the same officers that gave me
And
$62 ticket last.
hold on, sir.
Knew me.
6th, and you were out on bond on 2021 CF 7003AO. So that will RR be revoked, and that'll go to no bond. And you have an attorney on that case, Leon Cheek. I know he's a conflict lawyer, so I'll appoint the public defender on the
We'll
new
do a
one.
conflict, Your Honor, and
You'll
they-
probably conflict off, but, okay.
Yep.
That's it.
Yes, plus 500,000.
All right, what is your name?
Anthony Butler.
All right, Mr. Butler. Go ahead and appoint the public defender. It looks like Division 11. It looks like case number 2020 CF 1107. And let's see. This was a warrant, it looks like. Is that correct, State? This was an arrest warrant?
Yes, Your Honor.
Okay. We'll stay the bonds. Public defenders appointed. Division 11. All right, what is your name?
What's your name?
Saeed Carter.
Carter. Division 10, case number 2021 CF 7678. It's a warrant here for grand theft. No contact with the victim. And let's see. Grand theft and possibly, it looks like a worthless check, defrauding charge. Bonds were set at $5,000 on each count. No contact with the victim. And then there's a drug charge in Division 17, 2021 CF 13237. Methamphetamines, ecstasy, MDA. Let's see. And that bond will be stated at $1,000. Public defender will represent you. All right, your name?
Hello, my name is Corey Dotson.
Mr. Dotson. Okay, your case is Division 10, 2021 CF 13235AO. Grand theft, third degree motor vehicle. Bond is set at $1,000. You're to have no contact with the victim. Public defender is appointed. Okay.
I was told I could request an ROR.
Not at this time, sir.
Your Honor, he does qualify for pretrial release. I would just ask for pretrial release. Doesn't appear that he has any convictions, 0 failures to appear.
State, you have a position?
I have no objection, Your Honor.
You what?
I have no objection. He does not have any criminal
Okay.
history.
It'll be ROR, no contact with the victim.
Okay.
PTR, you mean?
Yes, I was asking.
Pretrial release.
Okay, pretrial release. Okay, your name?
George Egorns.
Okay, you have Division 22 case, 2021 CF 13238AO. And possession of cocaine and drug paraphernalia, bonds of $1,000 and $500. Public defender will be appointed. All right, next. Your name, sir?
Reginald Goss.
Reginald Goss. Okay, let's see. Possession of cocaine. The bond is set at $1,000. This is Division 15, 2021 CF 13239AO. Public defender will be appointed. All right, your name?
Clifton Jermaine Hall.
Hall.
Yes, sir.
Okay, we will appoint a public defender. This new case is in Division 10, 2021 CF 13174AO. Failure to report
Excuse me, sir.
as a sexual offender. And that bond is set at $1,000 per the arrest warrant. And then it appears you're out on bond for the same offense. And that is 2021 CF 2322AO. That bond will be revoked and go to no bond until you see your circuit judge. It's not? Yeah, you're messing me up. 2322, yeah? He has another one? That's it? It'll be a long day, isn't it?
Okay, yes.
Uh-huh.
They said
Sure I know my name anymore.
registered Monday.
One day there'll be a robot in here doing this. There'll be robots everywhere. Sad part about it, they'll be better than all of us, too.
Maybe.
Yes, you revoked your out on bond, failure to register.
We'll be their slaves,
Picked up a new law.
unfortunately. It's the way it's looking.
Call the number.
They start updating their own software, and take over the world. All right, your name?
Christopher Hampton.
All right, Mr. Hampton.
I don't even know what I'm being charged with because I had no drugs on me whatsoever.
Okay, hold on, sir, hold on. You're, point the public defender for you. Let's see, what, you have an arrest warrant, is all I can tell you, so I don't know much about it either, other than there's a warrant. Bond of $1,500, possession of MDMA, and that says on October 2nd of 2021. That's as much as I know, and it's 2021 CF 13221AO. And that bond is $1,500. You're not to possess any drugs or alcohol. It says may be modified by me. So we'll look at that in a minute, but it looks like you're out on bond. Basically the same charge in 2021 CF 11511AO.
I get no court letters, no nothing.
So that bond's going to be revoked, go to no bond. And I'll stay your other bond of $1,500. Public defender is appointed.
Your Honor, given that it's a nonviolent offense and his very limited criminal history, I would ask that as opposed to revoking and holding him at no bond, you revoke and double.
Okay, State, what do you say?
I object, Your Honor. It's the same offense. I object, Your Honor. It's the same offense.
Okay, so it will
What with nothing?
will stay revoked.
I didn't have nothing in my possession.
Sir, that's not for today.
No, once I got in trouble the first time was the last time I ever got in trouble. That was
Okay.
it.
Well, your
I
attorney
didn't
will,
get in
your
trouble again since
your
the
attorney
last
will have to
time.
help you with that. Those are two separate cases, right, State?
I'm looking at that right now, Your Honor.
Make sure, because when they're pretty adamant, sometimes things mess up. Sometimes there's double reports, and sometimes there's all kinds of things that happen.
Your Honor, the affidavit in the present case, 21 CF 13221, Is from October 2nd, 2021.
It occurred after the out on bond, Your Honor.
What's that?
It occurred after the out on bond.
Yeah.
So you could,
Yeah,
Okay.
that was from August.
yeah.
Okay.
Okay. Is that him? Already gave him already. All right.
Samuel Hunter,
Yes.
his behavior.
He's what?
Behavior.
He's bad behavior.
Yes.
All right, we'll appoint the public defender's office.
I'll waive the appearance, Your Honor.
Okay. So on the petty theft prior convictions, looks like it's in felony court division 14, 2021 CF 1329AO. That bond will go to stay at $1,000 and no return to the Home Depot on Millennia Plaza Way. And it appears he was out on theft at the time in 2021 MM 4908AO, I think.
Notice to appear.
Says date of arrest NA. So was he not out?
Notice to
It was
appear.
a summons.
It was a summons,
So he wasn't,
so he was not. So we'll take no action on that. He has another one. Oh, the failures to appear, 500 and 100 will be stayed. And that is a 2021 MM 923AO Division 61.
Your Honor, if we could have no contact and no return to the scene.
Yes, no contact, no return to the scene on the trespassing on those cases and the criminal mischief. Contact with victims, no return to the scene. Okay, what is your name?
David Antonio Jackson.
Jackson. Okay, let's see. Division 17, 2021 CF 13226AO. Petty theft with prior convictions, it looks like at the Florida Mall. Public defenders appointed. And that was Division 17. And then there's a Division 10. Petty theft, Florida Mall. 2021 CF 13229AO. Let's see here. These are both on October 6th. So we're going to order you not to return to the Florida Mall. And stay the bonds. Public defenders appointed.
1,000. He's just staying it.
Okay.
Very good.
All right, your name?
Natasha Jean, sir.
Jean?
Yes, sir.
All right, Division 12, 2021 CF 4298AO. You have failures to appear, no bond on 3 counts.
So I'm done.
And public defenders appointed if they're not already? They are? Okay. And that was Division 12, 2021 CF 4298AO. All right, your name?
Ali Key.
Ali Key?
Yes, sir.
All right. This is one of 2 cases. The first one's Division 22, 2017 CF 4766AO. You got 3 counts of failure to appear on no bond. Public defenders appointed if they aren't already. And then you have a capias, possession of cocaine, drug paraphernalia, and petty theft. It's a capias, failures to appear. Those are no bond. Or is that the same one? Is that the same?
All the same.
Is it the same one? 4766AO. Let me see. Yes, that was the same one, those three. And then you have a, yes, and then there's one more. Failure to appear on a robbery case, it looks like. Division 20, 2018 CF 1725AO. There is no bond. Public defender will be appointed if they haven't been already. Okay.
Thank you.
Okay, what is your name?
Knight, Alan Knight.
Okay, Mr. Knight. Public defenders appointed, if not already, and let's see here. All right, so it looks like you have a couple cases, Division 81, 2020 MM 581 AA, it's $2,000 bond. It's like probably a failure to appear, it looks like. And then Division 19, 2021 CF 1323AO, $1,000 bond on a possession of drugs without a prescription. And then you're out on bond on 2021 MM 427AA. Petty theft charge. Looks like you're out on bond, so that'll be revoked and go to no bond.
Your Honor, I would ask that you double. It looks like that's.
Looks like what?
The only thing I see that he has been convicted of was from 2016. So I would ask that, and he has some mental health issues, so I would just ask that if you are inclined to revoke, you revoke and double, as opposed to holding him at no bond.
State.
Your Honor, I would object, Your Honor, only because he was out on bond on the petty theft. He then picked up a felony offense, Your Honor, and violated his conditions of release. So no, Your Honor, I would ask that you revoke.
Yes, I will revoke. Stay the other ones. Okay. All right, your name? What is it?
Jason McLam.
All right, this is failure to appear. It says Division 12, 2019 CF 2260AO. There's no bond. And let's see. Public defenders appointed if they aren't already?
Yes.
Yes? Okay. All right, Division 12.
Myers, he's in the hospital.
Hospital, we'll appoint the public defender. There's an arrest warrant, so there's probable cause.
I'll waive the appearance, Your Honor.
All right. $1,500 is what they set the bond at, so I will stay that. Okay. Your name?
Charles Frederick Nelson.
Nelson, let's see here. All right, new cases, Division 10, it appears, 2021 CF 13200AO, burglary of a structure, petty theft, possession of meth, and battery. And let's see. Number 6. And he has other charges, but he was not out on bond. He was ROR'd.
Yes, yeah.
All right, so I'm going to revoke the RORs on the 2021 CF 166AO and the 2021 CF 7511AO. Those will go to no bond. And the new charges, this is a burglary, but I see a battery. Is it a burglary with a battery there in state, or is it separate?
Separate.
It's separate, Your
It's
Honor.
separate, Your Honor.
Okay. So I'll stay those bonds at 1,000, 250, 1,500. No return to the scene, no contact with the victims. That's at the Tractor Supply, it looks like, on Colonial Drive. Public defender is appointed, if not already. All right, your name?
Alonzo Noble.
Noble. All right, you have a Division 20, couple cases it looks like. The first one is Division 20, 2021 CF 13228AO. Petty theft, prior conviction. Has a bond set at $1,000. Will order you not to return to the Florida Mall. And you have a Division 15, 2021 CF 13227AO. Petty thefts. Bonds at $1,000. Again, no return to the Florida Mall, no contact with the victims. It's in each case, no contact with victims, no return to the Florida Mall. Okay. All right, your name?
Marco Portolatine.
Okay, there was a warrant issued, it looks like, for you, trafficking in fentanyl, sale and delivery of fentanyl. This is case 21 CF 13245, Division 22, bonds of $100,000 and $7,500. Public defenders appointed. Your name?
Vera Felix.
So what is your first name?
Felix.
Okay, Felix Rivera. All right, let's see. You have Division 19, 2021 CF 13196AO, burglary of a conveyance. And that same incident, Division 12, 2021 CF 13195 AO, attempted burglary of a conveyance. So I'll stay the bonds in each one of those cases. Order you not to return to that subdivision, which is the Econ River Estate subdivision. No return there, no contact with victims.
3,500 and 1,000.
Okay.
Thank you, Your Honor.
All right, your name?
Reina,
What is it?
Reina María Sandoval Cruz.
Okay, let's see. This is Division 22, 2021 CF 13233AO. Public defender will be appointed. And this is charge of possession of cocaine with intent to sell or deliver. There's weapons alleged. Possession of fentanyl, grand theft, third degree firearm, possession of a controlled substance, possession of drug paraphernalia. And the bond on the possession of cocaine with intent to sell with a weapon is $15,000. And the rest are set at $150. Well, count 2, 3, and 4. Count 5 is $100. And let me see here. So we're going to order you not to possess any weapons or firearms or any ammunition. And not to return to the 9826 Downey Cove Drive.
I can't return there.
What's that?
I can't return there.
Do you need to?
That's my place to stay.
That's where you live?
Mm-hmm.
Yes?
Yes.
State? You care if she returns home?
No, Your Honor, I have no objection to her returning home.
Okay, so we'll strike that and just stay the bonds and order you not to possess any weapons or firearms or ammunition. And then there's another charge, Division 83, 2021 MM7103AO, providing false identification to law enforcement. That bond is $500. Public defenders appointed. All right, anything else, State?
No, Your Honor.
Nope. Okay.
Serrano Hospital.
Serrano's Hospital?
Yes.
Okay, we'll appoint a public defender.
I'll waive the appearance, Your Honor.
Okay, and we'll stay the bonds at 1,000 and 500. And that was, I think there's 2 cases.
Yes.
So that was on the Division 15, 2021 CF 13198AO. And then there is the Division 12, 2021 CF 11880AO, possession of cocaine, $100. Then PD's appointed. Is that all of them? Looks like it, yep. Okay, your name?
Sarah.
Sierra? Sarah? How do you say it?
Sarah, S-E-R-R-A.
Okay. All right, so you have a new case in Division 14. There was a warrant signed for your arrest. So probable cause was established for it's Division 14, 21 CF 13161AO, throwing a deadly missile into a building. The bond was set at $5,000. Tampering with a witness, $1,000. Aggravated stalking after a court order, no bond. Criminal mischief, $500. So the aggravated stalking, we need to address. Is there a victim here on that?
Yesenia Garcia, Your Honor.
What?
Yesenia Garcia is the victim, and it is the same victim as the previous case, which is 2021 CF 12550.
Right, and he was out on bond on that?
Yes, Your Honor.
Written threats to kill or do bodily harm. So that bond will be revoked and go to no bond. We'll order no contact with the victim. And on the new aggravated stalking, I'm going to set that bond at $50,000. No contact with the victim. We'll stay your other bonds. No contact, no, let me see. No contact with the victim, victim's family, no return to the scene per the warrant. Okay?
Your Honor, I would also ask for no weapons, no firearms.
Yes, no weapons or firearms, no, I'll take care of it, okay.
And Your Honor, I just want to make sure, are we appointed on the out on bond? Or does he have, because I can't find, I just want to make sure he has an attorney since it's revoked.
Right, I'll appoint you on both if you're not appointed,
Okay, thank you.
if there's no attorney. Okay. Your name?
Danny Williams.
Okay. I have a case in Division 20, 2021 CF 1321680. I don't have a document saying he was out on bond, but according to the arrest affidavit, he might have been out on bond.
I believe these are add-on charges, Your
Yeah,
Honor.
these are add-on charges.
So these are added on to the other charge?
Yes.
So he was not out on bond,
No, Your Honor.
He's still currently in jail.
currently in jail. So these are just added on. And the bonds were set at $5,000 and $150. I'll order him not to possess any weapons or firearms or ammunition. Anything else, State?
No, Your Honor.
Nope. Okay. Public defenders appointed, if not already. Okay. We're going to recall Meadows.
Medical, Your Honor.
This is an arraignment for Meadows.
Public defenders appointed.
I'll waive the appearance and enter a plea of not guilty.
I thought he was released.
Says ROR 927.
Hi there. Thank you for your patience. I had some fires to put out this morning, so I figured it would give you all some time to convey offers and make sure people understood what was going on. Great, thank you. So we're gonna get through these hopefully rather quickly. The jail has asked that I move a couple people up to the front so we can go ahead and take care of those. I'd like to first say though, good morning to everybody. I'm Judge John Savage. The majority of you are here for arraignment. If it is your arraignment, what I'm gonna do is call your name. I'm gonna ask you to come up to the microphone, the one over there closest to the wall. I'm gonna tell you what the charges are that the state attorney's office filed against you and what the penalties could be for those types of charges. I'm gonna tell you what the maximum penalties are. So remember, it could go from 0 up to the maximum. It doesn't have to be that maximum. It's just that range. Once I've given you that information, I'm gonna ask you how you wish to plea. You may respond to either guilty or not guilty. I hope y'all are paying attention because I'm not gonna say this again. When I ask you how you wish to plea, you may respond guilty or not guilty. Whatever choice you make is fine. You don't have to explain. Just tell me your decision and we'll go from there. We are being recorded. You have the right to remain silent. Anything that you say can be used against you. even if it is about something that's not going on in here today. So if you have a felony that's pending that's related to the case today, or if you have a VOP, or you have any questions that somehow tie into the reason why you're here today, even if we resolve the case today in here, it could affect those other cases too. So please make sure that you speak with your attorney to find that information out before you make any statements. You have the right to an attorney. If you cannot afford to hire a lawyer, I will appoint one if you qualify. Appearances from the state.
Cynthia Carrasco and Sofia Viriel Sanchez for the state.
And?
Judy Lois.
I'm sorry.
Thank you. And for the public defenders? Thank you. All right, let's start with page 15. Should be case number 21 MM 2383 State v. Wiggins. Fabian Wiggins. Good morning. Can you please say your name for me? Thank you. Mr. Wiggins, you are here for arraignment. The state filed 2 charges against you, resisting without violence and trespass. Those are both first-degree misdemeanors. Each one is punishable by up to a year in jail, a year of probation, and $1,000 in fines. Mr. Wiggins, you already have the public defender. How does the defense plea?
Not guilty, Your Honor.
All right, Mr. Wiggins, we're going to enter you a plea of not guilty. Thank you. You're welcome. State versus Dylan Prosser, page 9, 21 MM 294. Good morning. Please say your name. Thank you. Mr. Prosser, you're here for arraignment. The state filed a charge against you for criminal mischief. The damage valued more than $200, which makes it a first-degree misdemeanor. It's punishable by up to a year in jail, a year of probation, and $1,000 in fines. You are already represented by the public defender. How does the defense plea?
Not guilty, Your Honor.
All right, Mr. Prosser, we're going to enter you a not guilty. Thank you.
November the 17th in courtroom 5B.
State versus Providence Green. Good morning. Can you please say your name for me? Thank you. Ms. Green, you're here for arraignment. The state filed 2 charges. The first one is trespass as a first-degree misdemeanor, punishable by up to a year in jail, a year of probation, and $1,000 in fines. The second charge is disorderly conduct. It's a second-degree misdemeanor, punishable by up to 60 days in jail, 6 months of probation, and a $500 fine. You are already represented by the public defender. How does the defense plea?
Not guilty.
Ms. Green, we're going to enter you a not guilty plea. Thank you, ma'am.
Pre-trial November the 17th in 5B.
Those were the move-ups as requested by the jail.
Yes, Your Honor.
Alexis Broadway. Good morning. Please say your name.
Alexis Broadway.
Thank you. You're here for arraignment today. The state filed a charge against you for providing false ID to law enforcement. That's punishable by up to a year in jail, a year of probation, and $1,000 in fines. Those are the worst things that could happen. How does the defense plea?
Not guilty.
All right, Ms. Broadway, we're going to enter you a plea of not guilty. Thank you.
Pre-trial November the 9th.
Louis Cayola, 21 CT 1116. Good morning. Please say your name. Thank you. Mr. Cayola, you are here for arraignment. It looks like the charge filed is a violation of probation. Give me 1 second to just look and see what probation filed. It looks like this may have been a county probation, maybe supervised with state probation. It looks like you were on state parole. Oh, I see. Give me a second then. All right, so I read that. Now let me look at what the violation affidavit says, or actually what the sentence says. All right, so it looks like, Mr. Kiola, what the state filed through probation is that because you got into trouble in your parole conditions and you were arrested for an alleged violation of parole, that violated your probation. I'm just letting you know what they said. Okay, state, any position on this? I'm not the judge I didn't sign that warrant, so I don't know what the state's eventual position is on the violation of probation.
Your Honor, we are showing that he has a new law violation.
Okay, well, what I just read, what I just said was that the one condition on his affidavit of violation is that he violated parole. There's nothing in our judgment and sentence that said abide by all conditions of your New York parole. So the New York parole allegedly was violated by alarms on his home monitor, his electronic monitor, and not answering his phone. That violates his parole. What violates our probation? That's my question to you, but that's for you all to prosecute. I'm not the judge who found PC for this arrest. So I'm not going to readdress PC at this point. But if you have an offer, he can either accept it or reject it and fight it whichever way he chooses to fight it.
Your Honor, we'd like to admit the offer provided from the state was admitted 20 days in court costs.
Okay, please understand that I can only ask questions about what's on the affidavit. I can't ask him other questions because he's not in violation of other conditions. So I have to ask him, do you admit that you violated the conditions of your parole? Which is then going to get him into trouble in his parole case.
I've already discussed that.
Okay, so Mr. Kiola, do you understand that? Because if you say, yes, I admit I violated my parole, all New York has to do is get a copy of this recording and enter it against you in that case. And I don't know what you're on parole for, but I'm assuming it's a big deal. So, are you sure you want to plead guilty to the violation of probation?
Yes.
Okay. I'm going to give you the rope you're asking for. You know what happens when you get too much rope. Okay.
Your Honor, for the record, defense has gone over those options with the defendant.
All right. Please raise your right hand. Do you swear to tell the truth, so help you God?
Yes.
Thank you. Please lower your hand. Mr. Kiola, did you review an admission form with the public defender?
Yes.
Do you understand the rights that are in that form?
Yes.
Did you sign it, sir?
Yes.
Do you have any questions?
No.
Do you need any more time to speak with your lawyer?
No.
Do you feel like anybody forced you to make the decision you're making?
No.
Are you acting under the influences of any types of medications, drugs, or alcohol?
No.
If you are not a U.S. citizen entering a plea is a basis to have you deported. Do you understand?
Yes.
Are you willing today to waive your rights and go against your lawyer's advice and enter this plea to resolve the VOP for the driving charge?
Yes.
How do you plea?
Yes.
Do you admit that while you were on probation in 21 CT 1116, you violated the conditions of your parole for the case that you are on parole out of New York? Yes. And did you know that you were supposed to follow the conditions of your parole and remain law-abiding with regard to your violation of probation? I'm sorry, with regard to this probation? Yes. Do you believe that you could have chosen to not violate the conditions of that parole? And do you believe that did you decide for yourself that entering into this admission is in your best interest? This is what you want to do? Yes. Okay. And you had enough time to think about it and to talk to your lawyer about your options? Yes. Okay. So I find that you are alert, that you are intelligent, that you understand, that your plea is freely and voluntarily entered, and that I have a sufficient factual basis and I will accept it. It'll be an adjudication of guilt, revoke and term probation, 20 days in the county jail with credit for 11 days time served. Any conditions now not complete are hereby waived. Now, I'm asking the clerk. It says $500 cash bond. That can't be right. That's what I thought. Okay. You have 30 days to appeal. All appeals have to be in writing, and if you cannot afford a lawyer, I will appoint one if you qualify. Good luck, sir. Waive it. Okay, state. Here you go. He just handed it to you for you to pass it off. So, Scott Cotton. Good morning, sir. Please say your name. Scott Cotton. Thank you. Mr. Cotton, you're here for arraignment. You have 19 CT 3436, which is a violation of probation. And then you have 21 MM 1087, which is a new charge for petty theft. The petty theft is the reason for the violation of probation. So the petty theft is punishable by up to 60 days in jail, 6 months probation, and a $500 fine. You do have the public defender representing you in both of these cases. Let me ask the state attorney, rather the public defender, how you want to move forward.
Thank you, Your Honor. And in the second case, I'm sorry, in the field plea 19 CT 3436, it appears that he's represented by private counsel.
No, it was scratched out and the clerk wrote public defender over the top. Let me see why. It may be that it said private counsel, but that was a bleed over from the underlying charge and the clerk didn't take it out, but he is appointed the public defender.
Yes, Your Honor. Deny and...
Not guilty. All right, we're going to enter you a denial in one and not guilty in the other. Thank you.
Guilty status, November the 5th in 5B. Pre-trial, November the 17th, 5B.
Pablo Santos Gonzalez Ramos. Todo eso.
English.
I know. I just say because and they're multiple parts. Good morning, sir. Please say your name for me. Mr. Gonzalez, you're here for arraignment. The charge is possession of paraphernalia. Worst case scenario, a year of jail, a year of probation, $1,000 in fines. How does the defense plead?
Your Honor, there was a diversion offer, and I went over the packet with Mr. Gonzalez, and I found the certificate verifying he went over the diversion.
Okay, state.
Your Honor, I'm showing a different offer. I don't know if public defender had a new offer later in the afternoon, yesterday later in the afternoon.
This offer was conveyed to me from APD Caraballo, and I believe it came from Ms. Scarborough.
One moment, Your Honor.
Okay.
Your Honor, like I said, I have a different offer, an adjudication of guilt, credit time served, and court cost.
That's for you all, I guess, to iron out. That's the offer she's willing to accept today. I don't have the details. If you want me to pass it and come back, and you can maybe send her the email that you're relying on.
Yes, Your Honor.
right.
Thank you, Your Honor.
All right. So, Mr. Gonzalez, have a seat, and they'll bring you back up once they figure out where they crossed wires. Justin Keeler. Hi, good morning. Please say your name for me. Thank you. So, Mr. Keeler, you're here for arraignment. The state filed a charge against you for petty theft, which is punishable by up to 60 days in jail, 6 months probation, and a $500 fine. And you are already represented by the public defender. Defense?
Not guilty, Your Honor.
All right, Mr. Keeler, we're going to enter you a not guilty. Thank you.
Pretrial November the 9th and 4A.
Jorge Otero Marin. Good morning. I'm good, thank you. Please say your name. Mr. Otero, you're here for arraignment. The state filed a charge against you for no valid license, punishable by up to 60 days in jail, 6 months probation, and a $500 fine. Defense?
Not guilty.
Mr. Otero, we're going to enter you a not guilty. Thank you.
Pretrial
Yep, we're going to say it right now for you.
November the 17th and 5B.
November 17 and 5B. You're welcome. Kyle Ricker. Good morning. Please say your name. Thank you. Mr. Ricker, you're here for arraignment. The state filed a charge against you for violation of probation. Worst case scenario is what the petty theft could have carried before, which is up to 60 days in jail. You are represented by the public defender. How does the defense wish to plead?
Maybe Your Honor, the offer we've been given is telling me to go to court costs.
And would Mr. Ricker like to take that?
Yes, Your Honor.
Okay. Sir, can you please raise your right hand for me? Do you swear to tell the truth, so help you God?
Yes, ma'am.
Thank you. Please lower your hand. The public defender has an admission form right there with your name on it. Is that a paper that you reviewed?
Yes, ma'am.
Did you read it front and back?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Do you understand the rights that are in the paper?
Yes, ma'am.
Do you have any questions?
No, ma'am.
Do you need any more time to speak with your lawyer?
Not at all.
Do you feel like anybody forced you to make this choice?
No, ma'am.
Are you acting under the influences of any medications, drugs, or alcohol?
No, ma'am.
If you are not a U.S. citizen, entering a plea is a reason to have you deported. Do you understand?
Yes, ma'am.
Are you willing today to waive your rights and enter this plea?
Yes, ma'am.
Do you admit, Mr. Ricker, that you didn't follow all the conditions of your probation the way that you were supposed to?
Yes, ma'am. The monetary part.
Well, and they wrote on here that you also failed to report in August. Do you want to fight that?
No.
And do you admit that you knew what the rules were and that you could have followed them?
Yes, ma'am.
So I find that you are alert, that you are intelligent, that you understand, that your plea is freely and voluntarily entered, that I have a sufficient factual basis, and I will accept it. It'll be an adjudication of guilt, revoking term, probation, 20 days in the county jail with credit for 14. Any conditions not finished are hereby waived, except for the money that you owe. The court balance is the money from before. It's not new money. It's $418.88, and you owe probation $250. So we're going to put that all together into one account, report to the clerk of court within 7 days of release to set up a payment plan. You're welcome. 30 days to appeal, all appeals in writing. If you cannot afford a lawyer, I'll appoint one if you qualify. Tony Rocker, also known as Tony Davis. Good morning. Please say your name.
Tony Davis.
Thank you. Ms. Davis, you are here for arraignment on a charge of violation of probation. Probation says you didn't do your hours, you didn't show proof of your treatments, your evals were done, but unsuccessfully discharged from batterer's intervention and didn't show proof of keeping up with your treatment and a positive drug test. So all those things are the reason why probation filed the affidavit. How does the defense wish to proceed? All right. Ms. Rocker, we're going to enter you a denial and set you for a status. Thank you. You too. November 4th? Which courtroom? 4A. 4A, with us. Ronald Serrano. Good morning. Please say your name, sir. Thank you. Mr. Serrano, you're here for arraignment. The charge is violation of probation. Probation filed an affidavit saying you didn't do any of your conditions. How does the defense wish, oh, I'm sorry, Mr. Serrano, you don't have a public defender at this time. Is there an offer from the state?
Yes, Your Honor, the offer is admit, revoke, and terminate adjudication of guilt, 20 days
County jail.
county jails, credit time served, and court costs.
Mr. Serrano, the state's offer is 20 days with credit for 15 and terminate your probation. What would you like to do, sir? All right, please raise your right hand. Do you swear to tell the truth, so help you God? Just say yes or no. Yes. Thank you. Please lower your hand. Sir, the public defender has an admission form that she's holding up for you. Is that the paper that you signed?
Yes, ma'am.
Did you read it?
Yes, ma'am.
Do you understand the rights that are in that paper?
Yes, ma'am.
Do you have any questions?
Yes, ma'am. No, ma'am.
No problem. Do you feel like anybody obligated you to make the choice you made?
No, ma'am.
Are you acting under the influences of any medications, drugs, or alcohol?
No, ma'am.
If you are not a U.S. citizen, entering a plea is a reason to have you deported. Do you understand that?
Yes, ma'am.
Are you willing today to waive your rights and enter this plea?
Yes, ma'am.
You do have the right to have a lawyer. If you can't afford to hire a lawyer, I'll appoint one if you qualify. By taking the plea today, you're giving that up. Are you okay with that?
Yes, ma'am.
Mr. Serrano, do you admit that you did not comply with your probation the way that you were supposed to?
Yes, ma'am.
Could you have done it? Did you have the ability to do probation? Or were you able to do it but just chose to not do it? Why not? Why?
Because I was on a violation. Oh, sorry.
No, before that.
I got a violation when I sent back to New Jersey.
Do you believe that in light of everything that you know, you think that entering in this plea is in your best interest?
Yes, ma'am.
The state has to show that you willfully violated your probation. Do you want to fight that?
No.
So I find that you are alert, that you're intelligent, that you understand, that your plea is freely and voluntarily entered, and that I have a sufficient factual basis and I will accept it. For the record, none of his conditions are done, so that's a substantial violation. It'll be an adjudication of guilt, revoke and term probation, 20 days in the county jail with credit for 15. All conditions not completed are hereby waived except for the money that you owe. Your balance from before is $527.60 and you owe probation $350.
My fiance just paid Tuesday after that.
Perfect. So whatever payments were made, you will get credit for. And the rest of it, you can make payments. Just report to the courthouse within 7 days of your release and you can set up a payment plan and you can chip it away a little bit at a time.
All right.
30 days to appeal, all appeals in writing. If you cannot afford a lawyer, I'll appoint one if you qualify. Good luck. Sherry Stone. Good morning. Please say your name. Thank you. Ms. Stone, you have two cases scheduled for today. Both are related to driving from, one is July 28th, one is September 24th. The July 28th one is expired license, more than 6 months, punishable by up to 60 days in jail, 6 months probation, $500 in fines. The one from September is driving on a suspended license, also punishable by up to 60 days in jail, 6 months probation, and a $500 fine. And you are represented by the public defender in both cases. Defense?
And 21 CT 2181, the expired driver's license case, Your Honor, the offer is adjudication of guilt, credit, tax, served, and court costs. She'd like to plead guilty to that. And 21 CT 2635, the drill is, she'd like to be not guilty.
All right. So the 2635 will be a not guilty and set for pretrial. November 9. 4A. In 4A. And then with regard to the expired DL, ma'am, please raise your right hand. Do you swear to tell the truth, so help you God?
Yes.
Thank you. Please lower your hand. Ms. Stone, the public defender is holding a plea form there with your name on it. Did you sign that?
Yes, ma'am.
Did you read it?
Yes, ma'am.
Do you understand the rights in that paper?
Yes, ma'am.
Do you have any questions?
I was already under my first appearance on the driving was suspended. Is that still hold?
I'm sorry, I couldn't understand that.
I was already on the driving was suspended on my first appearance. Is that still hold?
I don't see why not. I don't have anything to do with that, so I'm not sure. Let me take a look. Yep, that ROR is still there. I don't know what else you have open, but with these two cases, yes. Yep. Any other questions? Do you need any more time to speak with your attorney? Do you feel like anybody forced you to make the decision that you're making? Are you acting under the influences of any medications, drugs, or alcohol? If you are not a U.S. citizen, entering a plea is a reason to have you deported. Do you understand? Are you willing today to waive your rights and enter this plea? On July 28th, 2021, in Osceola County, Florida, were you driving with a license that had already been expired for more than 6 months? I find that you are alert, that you're intelligent, that you understand, that your plea is freely and voluntarily entered, and that I have a sufficient factual basis, and I will accept it. It'll be an adjudication of guilt, credit for 13 days, time served, court costs of $273, and a $100 public defender lien. You have 180 days to pay that off. You have 30 days to appeal. All appeals must be in writing, and if you cannot afford a lawyer, I'll appoint one if you qualify. Thank you. Good luck. Stevie Knight? Do they have the 930s in there yet?
Stevie Knight is quite troublesome, so I've asked him not to bring him if that's
Okay, so you're going to waive his appearance?
Yes, Your Honor.
Not a problem. So let's address State versus Stevie Knight, 20 CT 857. Defense has waived defendant's appearance. Let me just, all right, so today is set for a status. Defense just recently filed a motion that they have reasonable grounds to believe the defendant in this case may not be competent. Attached to that motion appears to be an evaluation report. How does the defense wish to proceed at this time?
We would request that the court provide us with a hearing for the eval within the 20 days.
Okay, State, do you have any position?
Yes, Your Honors, they request a second evaluation in this case, please.
Okay. So at this time, the motion for a court-appointed evaluation is hereby granted. The state is ordered to provide the order to my judicial assistant as soon as possible. The motion from the defense was filed after 12 p.m. yesterday. So let me take a look. So Ms. Nadal, I can either set him for the 26th and have him transported to the courtroom, or I can set him on the 28th and have him seen during jail arraignments.
I prefer the 28th, Your Honor.
Okay.
Because of behavior issues.
No problem. Let me just make a note. All right, so if I remember, I think I saw the eval that's in the file. Is that Dr. Skaczynski?
Yes, Your Honor.
All right, so who is usually pretty diligent about getting a follow-up eval at the jail?
Dr. Arias is probably our next best bet with coming to the jail.
Any objection from the state to appoint Dr. Arias?
No objection, Your Honor.
So we'll put that date on it. Just let Dr. Arias know that, you know, we recognize I guess when you schedule the appointment, we recognize that it's a short turnaround time to just do his best if he can. And if he can't, we'll jump off that bridge when we get there.
Yes, Your Honor. And for the hearing, would you like both doctors present?
It depends on the state and the defense's positions. It depends on whether or not you are all going to agree. If you agree that the court may rely upon the reports, then the doctors don't need to be present. If you disagree about the court relying on the reports, then the reports become hearsay and I need testimony. I need somebody to verify and have that evidence presented properly. So that's you know. If you are going to call the witness, please let me know ahead of time because they can appear by teams and we can hook it up to the jail, but Lisa's got to reserve the cart. I think that's how, I mean, I guess technically I can do it through here. Well, yeah, no, the cart is what connects to the video feed. My computer, I don't know. Just let me know. Just let me know. I get confused because the minute they tell me one thing, then it's changed and I don't remember.
Your Honor, you know how I feel about teams at the jail.
I know. Understood. Is Mr. Porter in there? All right. State versus Ishmael Alexander Porter, 20 CT 580, 20 TR 8814. Oh, yeah, just wherever you see a space, like a... Yeah, that's fine. Good morning, sir. All right, so we are here for a status defense.
Your Honor, Mr. Porter has been found competent at the 3-1 Orange County by Judge Ray Allen. Mr. Porter happened to be in the treatment center, which is why he failed to appear. But otherwise, he does seem to be getting treatment. At this time, we would ask Mr. Porter's release based on Rule 3.212D, as he hasn't found competent. But I do want to inquire with the court about Mr. Porter being found competent in this case. It appears that there has been no order, and this case has been going on since last November. So I don't know if the court would prefer for me to ask for an evidentiary so that we can get that sorted out, or if there's another suggestion from the court.
So far, what you said seems correct based on the notes that I'm reviewing in the file. There has not been a formal finding or adoption of a finding of incompetence. It can be handled one of two ways, similar to what I said last on the other case. If the parties stipulate and you give me a copy of Judge Allen's order where she made that ruling, I can adopt that ruling in these cases. If you disagree, then we would need to set it for an evidentiary hearing, and then you all can present whatever it is you feel you need to present, and we can move forward from there. Because remember, the determination of incompetence with purposes of keeping him incarcerated is one standard, and the determination of incompetence for the state's inability to proceed forward with the prosecution of the case is a different standard. So we've dealt with the releasing him from jail part of it before, but not the state's ability to lawfully move forward part of it before. So I'll ask the state attorney, how do you feel about adopting Judge Allen's order?
Your Honor, the state just requests a hearing for the judge to formally find him incompetent, and the state does not object to the reports. The state will stipulate to the reports being used.
Okay, so, and that's fine, but then why would we need another hearing? Like, why schedule it for an actual hearing if you're stipulating to the reports today? I can look at the file today and make a decision. If you're not going to fight it later, why fight it now?
Your Honor, the state objects to Mr. Porter being released ROR, but the state does not object to a conditional release.
That's fine. I'm talking about, okay, I'm sorry. Maybe I didn't ask the question properly. I apologize. There are two things that I'm being asked to do today. Number one is to consider his release. Number two is to find him incompetent to proceed based on Judge Allen's findings, so to adopt her ruling. I have to release him and it will be on conditional release. But do you want to also stipulate with regard to the finding, or do you want to have a hearing? Because if you will, at the hearing, then say, Judge, I'm okay with the reports, let's do it now and save a hearing.
One moment, Your Honor.
Sure.
And just so the court's aware, in the last motion, I did include Judge Alice order finding him incompetent.
Perfect. That was going to be my next question. Not everything gets titled correctly in benchmark, so sometimes it's hard to find.
Yes, Your Honor.
So without going deep dive, it's
It's probably towards the end.
no problem.
After a copy of the email.
Great. Let me hear what they have to say, and if I need to go find it, I will.
Thank you, Your Honor.
Sure. Thank you for telling me.
Your Honor?
Yes.
The state has no objection to the determination of incompetency today.
Understood. Thank you for that information. So, having said that, the court at this time is relying upon a filing of the public defender, which is located on line 89 of benchmark behind the confidential information note. About 20 pages in is the order upon which the court will now rely. It's Orange County, 9th Circuit, case number 20 CT 1055 AOR, State of Florida versus Ishmael Alexander Porter, signed by the Honorable Faye Allen on August 5th, no, I'm sorry, March 15th, 2021, wherein she found Mr. Porter not competent to proceed. This court will adopt that finding based on the evaluations, arguments, and findings of fact that Judge Allen made. And I will, in our case, also incorporate that he is now not competent to proceed and set him for a status. And the court will release Mr. Porter on conditional release. In our cases, Mr. Porter, you are ordered to keep in touch with your lawyer, to not drive without a valid license, to remain law-abiding, and to comply with all the recommendations and all the prescriptions of your doctor. Okay? And we're going to set a status hearing. We're going to tell you what that is now, but we're also going to send it to you. And I need you to make sure that you come back for the status hearing, okay? Let's do December 3rd, and the clerk is going to look up a time in just a minute.
Thank you, Your Honor. And can you please tell me if this is going to be non-pro to the March date?
I'm going to ask the state attorney if they have a position while I look at the file.
Your Honor, the state objects.
They are objecting to the non-protunct to March, but I will make the finding non-protunct to July 15, which is the date that the defense filed their motion.
Yes, Your Honor.
So July 15, 2021. And I'm sorry, I was going to look up one more thing. We have a primary and a secondary email from Mr. Porter, so we're going to use those unless they have changed. I have Porter Ishmael at Gmail and mswanda31602 at Gmail. Are those both still good for you? Fantastic, Mr. Porter. I hope that you do very well. Stay out of trouble, okay? Thank you. All right, is Rebecca Carroll there? Is she in custody?
Your Honor, I don't believe she's in custody. I believe that the statutory was for her to provide.
All right, I'll wait and see if she shows up. What about Alfredo Rios Mejia?
Your Honor, Mr. Mejia refused to come.
Okay, let me take a look at the file.
He also is ICP as of 3/10 this year.
Yeah, I remember. And what is it that the defense is, if anything, asking?
Well, it's just the first status hearing, and we didn't have anything formally to ask. I did file a motion for release, but if the court would entertain motion, an all-time motion, I would ask that the court release Mr. Rios based on Rule 3.212D.
State your response.
Your Honor.
I think at this point, he needs to be reevaluated. I don't know what the state's position is, but.
Yes, Your Honor, we asked for an updated evaluation at this time.
My concern is this, with the history of just in this case, Mr. Rios being non-compliant, refusing to participate, not hearing the court's requirements of his release, the fact that it appears on the surface that his condition is deteriorating, that he's not med compliant, that he's not under the treatment of any doctor. I have concerns for his well-being, his safety, and the well-being of the public if he's released without knowing if he's safe to be released at this time. Unfortunately, his continued non-compliance escalates each time that he comes forward, and he has failed to appear for court when he's out of jail several times. So I also have a concern that he is not going to be able to abide by any conditions that I set until I know he is or isn't in his present faculties. So the Ori Tennis motion is denied without prejudice at this time, and the state's motion, I'm sorry, you wanted another evaluation?
Yes, Your Honor.
When was the last time that we eval'd him? Let's take a look. I mean, it was ICP in March, so we've got until March to, I don't know, see if we can get him some help. He failed to appear after I let him out last time, and now he's back in jail. And refused to appear the time before that, failed to appear the time before that. Failed to appear the time before that. Okay, so I see an eval. In February, Dr. Skaczynski. And that's the eval we relied on in March. And I don't think we've had him evaluated since then.
Your Honor, the defense is subject to second evaluation. We just request that an acute test also be added to that, and that the administrator be Dr. Arias, because he's the most qualified and he speaks Spanish and will be the most.
Sure. I heard the second part. What was the first part?
I forgot which part.
Well, you said you would ask, and then you said something
For Dr. Arias to evaluate.
before that.
I do test.
Oh, you do object. Got it. I didn't hear that part. Okay. Understood, noted for the record. The court will appoint Dr. Arias to do an evaluation. This will be set for status. For now, November the 11th. Nope, November the 10th. 11th is Veterans Day, so we're doing jail arraignments. Nope, that's not right either. Hold on. Hold it. Hold up. Wait a minute. I should be doing jail arraignments on the 10th. I was pretty sure that was me. It says arraignments and motions, but I have jail arraignments on the, I would have had them on the 4th. Judge Epperson and I swapped, but the 4th would have been my day.
I have a copy of your calendar and it says.
Oh, Epperson's got on the 10th.
And Epperson on the 4th.
Gotcha. All right, so the 28th. We'll shoot for a couple of weeks and we'll see what Dr. Arias can do.
Okay, oh, this 28th.
October 28th. Yeah, no, I know. We'll try for that. If the state could please send up the order. 11 is fine. And that's just a status. Demetrio Arellano, is he in custody? No? Okay. Is Jeffrey Harvey there? Jeffrey Harvey, 21MM460. Hi, good morning. Can you please raise your right hand for me, Mr. Harvey? Do you swear to tell the truth, so help you God? Yes. Thank you. Please lower your hand and say your name. I was told that this is going to be set for a plea date. Mr. Harvey, did you sign a plea form?
Yes.
Did you read it?
Yes.
Do you understand the rights that are in that form?
Yes.
Do you have any questions?
No.
Do you need any more time to speak with the public defender?
No.
Do you feel like anybody forced you to make the decision you're making?
No.
Are you acting under the influences of any medications, drugs, or alcohol?
No.
If you are not a U.S. citizen, entering a plea would be used as a reason to have you deported. Do you understand that?
Yes.
And are you willing today to waive your rights and enter this plea?
Yes.
Now, my understanding, state or defense, correct me if I'm wrong, the negotiation was credit time served?
Yes, Your Honor.
All right. So, Mr. Harvey, how do you plead? Guilty. Did you, on September 9th of last year, 2020, try to take property out of Walmart without paying for it?
Yes.
State, could you show he was previously convicted of theft?
Yes, Your Honor.
So I find that you are alert, that you are intelligent, that you understand, that your plea is freely and voluntarily entered, and that I have a sufficient factual basis. I will accept it. State charged in the information that he was convicted in Lake County, April 2nd, 2020. Mr. Harvey, I will adjudicate you guilty, sentence you to 30 days in the county jail with credit for the 30 days you served, court costs of $273, and $100 public defender lien. You're going to have 180 days from your day of release to pay that off. Now, Mr. Harvey, this becomes number 2. If you get picked up for number 3, it's a felony. It doesn't matter how much the value of anything is. It could be a pack of gum. It could be a third petty theft, and that's a felony. So please don't do that. You have 30 days to appeal. All appeals have to be in writing. If you cannot afford a lawyer, I'll appoint one if you qualify. Thank you. Do we have Carl Isaac?
I believe it's supposed to appear in person, Your Honor.
Okay, thank you. Do we have Stephen Pierce?
Yes.
Morning. I have this set for a plea date certain. Can defense just confirm for me, please, what the offer was?
Yes, Your Honor. Adjudication of guilt, credit time served, and overturn and court costs.
Okay, that's what I have too. Mr. Pierce, please raise your right hand for me. Do you swear to tell the truth, so help you God?
Yes.
Thank you. Please lower your hand and say your name.
Stephen Pierce.
Mr. Pierce, the public defender has a plea form there with your name on it. Did you sign that?
Yes, ma'am, I did.
Did you read it?
Yes.
Do you understand what's in that paperwork?
Yes.
Do you have any questions?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you feel like anybody forced you to make this decision?
No, ma'am.
Are you acting under the influences of any medications, drugs, or alcohol?
No, ma'am.
If you are not a U.S. citizen, entering a plea is a reason to have you deported. Do you understand?
Yes, ma'am.
Are you willing today to waive your rights and enter this plea?
Yes, ma'am.
How do you plead?
Guilty.
On June 18th, 2021, in Osceola County, Florida, did you willfully enter or remain on the property of the Dollar Store, or the Family Dollar, I should say, at 2180 East Earlo Bronson Highway after you were told you were not allowed to be there anymore?
Yes, ma'am.
So I find that you are alert, that you are intelligent, that you understand, that your plea is freely and voluntarily entered, that I have a sufficient factual basis, and I will accept it. Pursuant to the negotiations, it'll be an adjudication of guilt, 46 days with credit for 46 days, $273 in court costs, $100 public defender lien, and no return to the Family Dollar. You're going to be ordered to report to the clerk of court within 7 days of your release so you can set up a payment plan, and you can make small payments every month until you finish. You have 30 days to appeal. You're welcome. All appeals must be in writing, and if you cannot afford a lawyer, I'll appoint one if you qualify. Good luck, sir. Please stay out of trouble. Do you have Carl Toda?
Yes.
All right. Good morning. Please say your name. Thank you. I have this case set for a plea date. Could the state tell me, please, what the offer is?
One moment, Your Honor.
Are you ladies now following along with the docket?
Yes, Your Honor, we are. We just have some issues earlier with the pages.
Okay. Well, I have him, my pages run differently, so I don't know how to tell you.
That Mr. Toto was an add-on and that he's probably not on their docket because he's not on mine. I found him in an email.
She's, Mariola is saying he's at the bottom of one of the pages. I don't know what that means, but.
I don't believe they received. Yeah, we don't have that.
Oh, okay. You got to remember too, a lot of these cases come to me really late the day before, and so the dockets are pre-printed. So he's case number 21MM2356. And remember too, when I look at my sheets, I have no idea who was an add-on and who was the original docket, so I'm just calling cases. Yeah, and okay, yeah, and I just do whatever they put under my nose. I do everything that's in front of me. What do you have?
Your Honor, we have an adjudication of guilt, credit time served, and court costs.
Both counts?
This is in case 21MM2356.
Correct. I have count 1 as a trespass, count 2 as a resisting.
Yes, Your Honor, for both counts.
Okay. Mr. Toto, would you like to take that offer? Yes. All right, please raise your right hand for me. Do you swear to tell the truth, so help you God? Yes. Thank you. Please lower your hand. Sir, the public defender is holding up a plea form. Did you sign that? Yes. Did you read it? Yes. Do you understand the rights that are in that form? Yes. Do you have any questions for me? Do you feel like anybody forced you to make this choice? No. Are you acting under the influences of any kinds of medications, drugs, or alcohol? No. If you are not a U.S. citizen entering a plea is a reason to have you deported. Do you understand? Yes. And you have the right to have a lawyer. If you can't afford to hire one, I'll appoint one if you qualify. By taking the plea today, you're giving that up. Are you okay with that? Yes, on August 24th, I'm sorry. They wrote that wrong. Instead of the date of event, they wrote your date of birth. On August, yeah, no, this is wrong. Hold on, let me go deeper. On August 29th, 2021, in Osceola County, Florida, did you willfully enter or remain on the property of the Rebel Gas Station on 2294 East Earl Bronson Highway after you were told you weren't allowed to be there anymore? And did you not do what the officer told you to do at the time? Okay. I find that you are alert, that you are intelligent, that you understand that your plea is freely and voluntarily entered, and that I have a sufficient factual basis and I will accept it. It'll be an adjudication of guilt, count 1 and count 2, credit for the 40 days, count 1, count 2 concurrent, court costs of $273 on count 1, $52.50 on count 2, and a $50 public defender application fee, which goes to the clerk. Mr. Toda, I'm going to put all of that into one account. Whenever you get out of the jail, you've got 7 days. Just come to the courthouse on the 2nd floor, and they can give you a payment plan, and you could just make little payments every month until you finish. All right. You have 30 days to appeal. All appeals have to be in writing. If you cannot afford a lawyer, I'll appoint one if you qualify. Don't go back to the Rebel gas station, okay? Thank you. Good luck. I know we may be early, and Mr. LaFever has Mike Morrison. Are they there?
Mr. LaFever is here, but Mr. Morrison is not.
Okay, so I have to wait for Mr. Morrison. What are we doing in Megan Valley's case? It says motion hearing. Is it a bond hearing?
It is, Your Honor. However, Ms. Valley also is set for PCC this afternoon, and after speaking with her, she would like to accept the offer and not be able to go over a plea form with her.
Is she there? Oh, okay. Do you want to review a plea form with her and I can take a break?
Yes, Your Honor.
All right. Before we do take a break, though, what does Mr. Pablo Gonzalez, what are we doing in Pablo Gonzalez? All right, so is he ready?
Yes.
Okay, so Ms. Valley can have a seat. Ms. Cateno can go over that form with her, and Mr. Pablo Gonzalez Ramos can come up. All right, Mr. Gonzalez, raise your right hand for me, please. Do you swear to tell the truth, so help you God?
Yes, Your Honor.
Thank you. Please lower your hand and say your name. Mr. Gonzalez, the public defender has a paper there with your name on it. Did you sign that?
Yes, Your Honor.
Did you read it?
Yes, Your Honor.
Do you understand the rights in the form?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
Do you need any more time to speak with your lawyer?
No, Your Honor.
Do you feel like anybody obligated you to make this decision?
No, Your Honor.
Are you acting under the influence of any kinds of medications, drugs, or alcohol?
No, Your Honor.
If you are not a U.S. citizen, entering a plea is a reason to have you deported. Do you understand?
Yes, Your Honor.
Are you willing to waive your rights and enter this plea to resolve your case?
Yes, Your Honor.
How do you plead?
Yes.
On October 16, 2020, in Osceola County, Florida, did you knowingly possess drug paraphernalia?
Yes, Your Honor.
So I find that you are alert, that you are intelligent, that you understand, that your plea is freely and voluntarily entered, and that I have a sufficient factual basis, and I will accept it. Pursuant to negotiations, it'll be an adjudication of guilt, credit time served, and court costs. Court costs are $388 and a $50 public defender application fee. Report to the courthouse within 7 days of your release, and you can set up a payment plan, and you can make little payments every month until you finish. You have 30 days to appeal. All appeals must be in writing, and if you cannot afford a lawyer, I'll appoint one if you qualify. Thank you. Good luck. All righty. Hi, good morning. What's your name? Thank you. Okay, Mr. Isaac, you can come on up to the podium. Ms. Nadal, I have Carl Isaac here in the courtroom. And he's set for plea.
Yes, Your Honor.
All right.
Unfortunately, you know, we are here.
That's fine.
Unfortunately, I would be there, and I did vote for Congress, but unfortunately, everybody else is occupied as well. I will tell you what the offer is, just.
Yeah, it was already, the plea form's already in the file.
You know, sometimes I'm so efficient, I scare myself.
Well, he was set for a virtual plea, but we were having technical issues.
Yes,
And so I told him to go ahead and come on in and let's just take care of it here.
Yes, Your Honor.
So we're good for that part of it. Obviously, he could see you. You could, know he's here. Can you see him?
No, Your Honor.
Okay. The camera's kind of on me, so, but she's there, she can hear what we're doing. So, Mr. Isaac, please raise your right hand. Do you promise to tell the truth, so help you God?
Yes, ma'am.
Thank you. Please lower your hand and say your name.
Anthony Isaac.
Appearance of counsel for the record.
Jessica Nadal.
Mr. Isaac, do you remember going over a plea form with your lawyer? It had all your rights written down on it.
Yes, ma'am.
And did you have as much time as you needed to go over that?
Yes, ma'am.
Do you feel like you understood those rights?
Yes, ma'am.
And do you have any questions about what we're doing?
No, ma'am.
Do you feel like you need more time to talk with your lawyer?
No, ma'am.
Do you feel like anybody forced you to make this choice?
No, ma'am.
Are you acting under the influences of any types of medications, drugs, or alcohol?
No, ma'am.
If you are not a U.S. citizen, entering a plea is a reason to have you deported. Do you understand?
Yes, ma'am.
And are you willing today to waive your rights and accept this plea so that you can resolve your case?
Yes, ma'am.
How do you plead?
Guilty.
All right. On April 17th of this year in Osceola County, Florida, did you go on the property of 4919 Sausalito Lane without being authorized, licensed, or invited to stay there? It says it's the property of Julie Garrett and that she wanted you to leave and you were not leaving.
Yes, ma'am.
Is that correct?
Yes, ma'am.
All right. So for the record, I find that you are alert, that you are intelligent, that you understand, that your plea is freely and voluntarily entered, and that I have a sufficient factual basis, and I will accept it. It'll be an adjudication of guilt pursuant to negotiations, credit time served, and a $100 fine, which is with court costs $318 plus a $100 public defender lien. And if you want, I can give you a payment plan.
Please.
Will that work?
Yes, ma'am.
If I do 25 a month starting in November, will that help?
Perfect.
Okay, great. We're going to give you that paperwork in a few minutes. Just don't go back to that property, okay?
I don't even stay on this side of town anymore.
That's the smartest move. You have 30 days to appeal. All appeals have to be in writing. If you cannot afford a lawyer, I'll appoint one if you qualify. Oh, 378. I apologize. No, $100 fine. It's 378. Sorry, I made a mistake. It's 378, but it's still a payment plan.
Yes, ma'am.
And the deputy's going to print you. Once you're done, just wait for your paperwork. Take the papers to the second floor to the cashier, and they'll set up your account. And then that way in November, you can make your payments. You can even pay online if you want to.
Okay.
You have 30 days to appeal. All appeals have to be in writing. If you cannot afford a lawyer, I'll appoint one if you qualify. Pretrial release is over. All right, good luck.
I have one question.
Yes.
As part of my plea agreement, I needed to change my address. Do I?
Yeah, we'll take that from you now. We'll do it now. Thank you so much.
That's all I need.
All right, have a good one. All right, we're going to take a real brief recess. We'll be right back.
Why you're frustrated, but unfortunately, I can't change that. And I just got some child support papers in jail here, like I got a whole last life.
Hey there.
Hello. Your Honor, in regards to the value, the state has informed me that they are unable to be opposite. They have not made contact with the legislative.
Yeah, and I was wondering that as well. Now, the notice of hearing with regard to your motion to set bond was sent out with plenty of time. So if we wait until 11, we can see if the victim shows up because of the bond hearing. And then if he wants to make an impact statement at that time, we might be able to proceed with the plea. But if he doesn't come in, we'll still go forward with the bond hearing, but I can't plea him until I know he was told that it was going to be a plea.
Yes, Your Honor.
So I guess we'll just wait till 11 on that one to see if he shows up. Now, is there anybody else there that we can address?
Your Honor, if you would recall, would you recall Alexis Broadway? She was the first person on the docket. She entered the plea not guilty, but she since reconsidered and would like to plead.
Yeah, no, that's not going to happen. The paperwork's already done, it's already filed, she had her opportunity.
I understand, Your Honor.
She's done, yep. Was there anybody who was maybe brought up, or is there anybody we can go get? Would corrections have any objection to retrieving a couple of extra people?
From this afternoon, Your Honor?
It could be anybody who you think might be ready. They told us they would be willing to go get whoever. I don't know.
I'll be with this, Your Honor.
All right, but remember, it can't be private cases. It has to be only PD cases or pro se.
Yes, Your Honor.
Or Mr. Arzola with his 40 cases.
Your Honor, it was 9 pages. I counted.
I know, it's crazy. Which is going to end up not being anything done today because of his pending felony. Can we find out who that is?
He's number 21, Your Honor.
Okay, thanks.
Your Honor, would you like to address Mr. Arizona?
It shows he's represented by Mr. Bano.
Just kidding, then.
Yeah. Psych. He's page 21, you said. Okay. Does he need an interpreter? Okay. I'm just making sure.
You good in English? Yeah. Okay, just make sure.
I have somebody here in the courtroom that I can address. He's pro se. This should be Mr. Demetrio Arellano. Good morning. How are you today? Good. Please say your name.
Demetrio.
Thank you. Give me 1 second to just switch. All right. Any updates for me, sir?
Yes.
Great. Let's take a look. So how much more did they say you need?
I want more.
One more?
Yeah, that's it.
Okay, awesome.
Today is my last one.
State, he attended 11 out of the 12 sessions, 12 out of the 12 of his groups. He's done relapse prevention. He basically is all but done, and he just has one group left before he is successfully completed with the program. The report says his participation is high, it's good, and that he is compliant. And that was, other than money, the only thing he has left to do. He has come back once a month, every month that I've given him for several months. Now, granted, it was a new term, but since he kind of put his head to it, he's been doing it, which is very good. Very good. Do you have any position right now with regard to continuing the prosecution for the violation of probation?
Your Honor, the state recommends the dismissal.
Okay. So, Mr. Arellano, in 19 CT 2858, I'm going to dismiss the violation, reinstate and terminate your probation. The only thing you have to do is just finish the one class and just keep making payments on the money that you owe. Other than that, probation's over. Stay out of trouble, have a nice life,
Okay.
wait for your papers.
All right, thank you.
Thank you. All right, Ms. Nadal, anybody there we can handle?
No, Your Honor, CO just called to ask with a few more clients. It should be done in a few minutes.
No worries. I'll move this over and wave at us when you're ready. I'm going to go off the record.
Yes, Your Honor.
Thank you. Hello.
Hi, I only have one person here.
That's fine.
Okay. I didn't know if you wanted.
Are they going to be bringing more, though?
Yes, Your Honor.
Awesome. All right. Sorry, just creating little piles here. Who do you have?
Josh Velos,
All right.
3 cases. Towards the end, Your Honor.
Thank you. All right, State versus Joshua Velos, 21 CT 1986, 21 CT 1987, 21 MM 1488. Good morning, sir. Please say your name.
Joshua Veloz.
Thank you. Counsel, what are we doing?
Your Honor, we filed a motion for ICP last night, yesterday afternoon. I did not attach an eval to it as we had trouble scheduling it, and the evaluation is actually scheduled for today at 4 o'clock. As soon as I get that evaluation report, I will obviously provide it to the court and the state. I just wanted to let the court know that at this time we're not ready to move forward given ICP concerns.
So you're asking for continuance?
Yes, Your Honor.
Okay. Any objection from the state?
No objection, Your Honor.
At this time, defense motion to continue is granted. Speedy trial will be waived. Pre-trial will be reset to November 9th, notwithstanding any other hearings that end up being scheduled. This will apply in all 3 cases.
Thank you, Your Honor.
Thank you.
Do you still have to file a PTC for this?
No, you don't have to for this, that's fine. Yeah, that'll be noted for the record, and the clerk will just put that on the clerk note. Since they're the in-jail ones, and they are going to be present, we should be okay.
Okay. Thank you.
Uh-huh. Let me know when you get somebody new.
Okay. Thank you, Your Honor.
All right, we are back. Defense, what can we address? I'm sorry, say that again? Okay, give me 1 second. Why did I just start putting these over here? I'm sorry, 1 sec. I was getting my pages confused, so hold on, Velasquez. so let me give you these so I don't lose them. Oh, wait, I'm sorry, hold on. I need that back. Real quick, I just want to check a note. Got it, thank you. Okay, I'm sorry, I'm like multitasking, trying to get a bunch of things done. Can you tell me again who you have there?
Luis Anthony Robles.
Thank you. Good morning, Mr. Robles.
Good morning.
Okay, defense, what is it that we're doing?
First time served out there, Your Honor.
Okay. Why is he not in this? Yeah, my docket sheet was showing something else. Got it. Thank you. All right, Mr. Robles, can you please raise your right hand for me? Do you swear to tell the truth, so help you God?
Yes, ma'am.
Thank you. Please lower your hand. Sir, the public defender has a plea form there with your name on it. Did you sign that?
Yes, ma'am.
Did you read it?
Yes, ma'am.
Do you understand the rights that are in that paper?
Yes, ma'am.
Do you have any questions?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you feel like anybody forced you to make this decision?
No, ma'am.
Are you acting under the influences of any kinds of medications, drugs, or alcohol?
No, ma'am.
If you are not a U.S. citizen, entering a plea would be used as a reason to have you deported. Do you understand that?
Yes, ma'am.
Are you willing today to waive your rights and enter this plea to resolve your case?
Yes, ma'am.
How do you plea?
No contest.
Okay. State, would you be able to show if we proceeded forward with trial that on April 1st, 2021 in Osceola County, Florida, this defendant was driving while his license was suspended, canceled, or revoked?
Yes, Your Honor.
Could you show that he had previously been convicted of suspended license with knowledge?
Yes, Your Honor.
Does the defense wish to dispute? Mr. Robles, I find that you are alert, that you're intelligent, that you understand that your plea is freely and voluntarily entered, and that I have a sufficient factual basis, and I will accept it. Let me just take a look at one more thing. It will be an adjudication of guilt pursuant to negotiations, 58 days in the county jail with credit for 58 days time served, $273 in court costs, and $100 public defender lien. You'll have 7 days to report to the Osceola County Courthouse upon your release and set up a monthly payment plan. You have 30 days to appeal. All appeals must be in writing, and if you cannot afford a lawyer, I will appoint one if you qualify. Good luck, sir.
Thank you.
You're welcome. Ms. Nadal, who do you have next? Okay.
Two cases, Your Honor, 21 MM 1551 and 21 MM 1931.
Yes.
Will one plea form be okay for both, or do you prefer two?
It should be okay with the one, as long as the clerk catches that and files it in each. All right. And what are the offers?
Both credit time served, Your Honor, with in 1921, sorry, 21 MM 1931, no return to law.
Okay. Good morning, Mr. Bucci.
Good morning, Your Honor.
Can you please raise your right hand for me? Do you swear to tell the truth, so help you God?
Yes, ma'am.
Thank you. Please lower your hand and say your name.
My name is Anthony John Bucci.
Mr. Bucci, the public defender should have a plea form there with your name on it with both your case numbers. Did you sign that form?
Yes, ma'am.
Did you read it?
Yes, ma'am.
Do you understand the rights in the paperwork?
Yes, Your Honor.
Do you have any questions?
No, ma'am.
Do you need any more time to speak with your lawyer?
No, ma'am.
Do you feel like anybody forced you to make this decision today?
No.
Are you acting under the influences of any kinds of medications, drugs, or alcohol?
No.
If you are not a U.S. citizen, entering a plea is a reason to have you deported. Do you understand that?
Yes, ma'am.
Are you willing today to waive your rights and enter this plea to resolve your charges?
Yes, ma'am.
How do you plead?
Guilty.
On June 8th, 2021, in Osceola County, Florida, did you willfully go on the property of the Sunoco gas station after you were told you weren't allowed to be there anymore?
He never gave me a warning. He just tried to call the cops. Mama gave me a warning, but I went in the store, someone bought me something. I was outside eating it, and I got caught.
So you were still on the property, though?
Yeah, I was on the property. I just tried to call the cops and do burger.
All right. Do you want to fight the trespass?
No.
And then on July 13 of this year in Osceola County, Florida, did you go on the property of Wawa gas station after you were told to leave?
Yes, ma'am.
So I find that you are alert. Well, let me ask the state in the second case, could you show that the premises were occupied by a human at the time? It says occupied structure.
Yes, Your Honor.
So I find that you are alert, you are intelligent, that you understand that your plea is freely and voluntarily entered, and that I have a sufficient factual basis and I will accept it. 21 MM 1551 will be pursuant to negotiations and adjudication of guilt, 72 days with credit for 72, court costs of $273, and $100 public defender lien. 21 MM 1931 pursuant to negotiations will be an adjudication of guilt, credit for 2 days, time served, $273 in court costs, and $100 public defender lien. No return in both cases to either of the locations. Report to the courthouse to the clerk of court within 7 days of release to set up a payment plan. You have 30 days to appeal. All appeals must be in writing, and if you cannot afford a lawyer, I will appoint one if you qualify. Good luck, Mr. Bucci.
Thank you, Your Honor.
You're welcome. All right. Michael Angel Salgado, 21 MM 1107. Good morning. Okay, defense, what are we doing for Mr. Salgado? Okay, let me take a look at the case. This is a charge of battery. Is the state ready to go?
One moment, Your Honor. Your Honor, I do have an issue with one of our witnesses.
Okay, for what day or what time?
From October 18 to October 23rd.
All right, we could set for trial October 26th. Can the state put on the record the last offer, please?
Yes, Your Honor, the last offer was adjudication of guilt, 60 days of county jail, followed by 6 months of probation, 30 hours community service, and court costs.
And is this an offer that your victim is aware of?
I made several attempts to contact the victim, and we were not able to contact the victim.
Okay. Is this something that you believe you can prove without the victim being present? In other words, you have a third party, an observer, somebody else who believes they will be able to show that, an unlawful touching?
Yes, Your Honor.
Okay. So, Mr. Salgado, state's offer 60 days followed by 6 months of probation. Obviously, you know you're not obligated to take that offer. You're not obligated to take any offer. That's coming from them based on what they've investigated and what they think they can prove. That has nothing to do with me personally because I don't know any details. I don't know any of the information yet, what they're going to say, if you want to say something, what you might say. If you choose to not take the offer and we go to trial, that's fine. But if the jury believes the state's evidence and they return a guilty verdict, then the sentencing is up to me based on what I think is fair after I heard everything too, and you could be looking at a year in jail. When I sentence you, I could also sentence you to a year concurrent, or consecutive to any other sentences that you're serving. So I know you're in custody for some other charges, so I wanted to make sure you understood all that. The offer from the state is something that you know exactly what to expect. Going to trial and leaving it up to the jury and then leaving it up to me is something you don't know what would happen. So I want to make sure you've kind of thought that through before you make up your mind one last time to either take the offer or go to trial. All right, what would you prefer to do? Okay, so at this time, the court will no longer take any negotiated pleas unless the offer materially changes. So we'll set for trial, and it'll be set for October 25th, which is outside the dates of your unavailability.
I'm sorry. Yeah, you're on a.
I thought you said till they were coming back the 23rd.
Right, but I thought you mentioned, I thought you said.
Did I say the 26th? I apologize. 26th is fine. I had a moment of dyslexia. Okay. You're welcome. So that was Mr. Salgado. Who else do you have? Good morning, sir. Can you move up just a tiny bit, please? Thank you. I couldn't see you. It was blocked by the that thing. All right. Defense, what does Mr. Moore want to do with regard to this case? State, are you otherwise ready for trial?
Yes, Your Honor.
How many witnesses does the state anticipate?
At least 4, Your Honor.
Okay. And any reason to believe that you have uncooperative witnesses?
Not at this time, Your Honor.
All right. And what was the state's last offer?
For count 1, it was an adjudication of guilt. 8 months OCJ, credit for time served. No contact with both victims, not return to the residence, and court costs. And then count 2 would be null costs.
Okay. Mr. Moore, the state's offer is 8 months in the county jail. You have credit for 119 days. So it would be 240 days minus the 119, minus any gain time that you might pick up if the jail says that you are entitled to it. I see that you're wearing white, so as a trustee in the past, that earned more gain time than the normal 5. I don't know if they're still doing it that way, but potentially your incarceration time could be over quickly. If you wanted to take the plea, they would ask for a plea on count 1 and they would dismiss count 2. Is that something that you want to consider, or would you rather go to trial and take your chances on both counts with the jury? Trial. You understand that if the jury returns 2 guilty verdicts, you could be looking at 365 days followed by 365 days. You could get 2 consecutive terms in jail. Do you understand that? Okay. Do you want to talk to your lawyer about that before I make you tell me your final decision? No? Okay. So we'll set. All right. Thank you.
Mr. Peter?
Has a private attorney. Is Mr. Morrison there?
Yes, Your Honor.
Okay. Thanks. All right, State versus Christopher Lefevre, 21 MM 1217, 21 MM 2391. Good morning.
Morning, Judge.
Appearance of counsel for the defendant.
Michael Morrison, on behalf of Mr. LaFever.
Thank you. Mr. LaFever, can you please say your name for me? Thank you. So we have a plea date on the docket for one and a motion hearing on the other. Mr. Morrison, can you just put for the record what it is that you are asking for the court to do today?
Yes, they're asking the court to accept his plea to the petty theft charge and then set bond in 21 and then 2391.
Okay, so let's go ahead and take care of the plea in the petty theft. Let me just switch pages here and try and find it. Mr. LaFever, can you please raise your right hand for me? Do you swear to tell the truth, so help you God?
Yes, ma'am.
Thank you. Please lower your hand and say your name again.
Christopher Michael LaFever.
Sir, your lawyer has filed a copy of a plea form that appears to have your name on it. Do you remember going over that paper with him?
Yes, ma'am, I do.
Do you remember signing it?
Yes, ma'am.
Do you understand the rights that are in that paper?
Yes, ma'am.
Do you have any questions?
No, ma'am.
Do you need any more time to speak with your lawyer?
No, ma'am, I don't.
Do you feel like anybody forced you to make this decision?
No, ma'am.
Are you acting under the influences of any types of medications, drugs, or alcohol?
No, ma'am.
If you are not a U.S. citizen, entering a plea is a reason to have you deported. Do you understand that?
Yes, ma'am, I do.
Are you willing today to waive your rights to this case and enter the plea to resolve your charges the way the state and your lawyer work them out?
Yes, ma'am, I do.
How do you plead?
Guilty.
On May 2nd, 2021 in Osceola County, Florida, did you try to take property out of Walmart without paying for it?
Yes, ma'am.
State, could you show the value of that property was greater than $100?
Yes, Your Honor.
So, Mr. LaFever, I find that you are alert, that you are intelligent, that you understand, that your plea is freely and voluntarily entered, and that I have a sufficient factual basis, and I will accept it. Was the merchandise recovered?
Yes, Your Honor.
Pursuant to negotiations, it'll be an adjudication of guilt, credit time served, $273 in court costs, and a $50 public defender application fee. Report to the clerk of court within 7 days of your release to set up a payment plan. No return to Walmart. 30 days to appeal, all appeals in writing, and if you cannot afford a lawyer, I will appoint one if you qualify. Now, with regard to the bond hearing, let me switch pages. And Benchmark's not letting me, so I have to go in manually. State, were you able to notify the underlying victim that Mr. LaFever was asking for the court to set bond in this case? May I have the case number, Your Honor? I couldn't find it on my sheet. 21 MM 2391. Mr. Morrison, do you practice in Orange County as well?
Yes, Judge.
The reason I ask is because as long as you've known me, and I've been on the bench down here 15 years now, I keep reminding the Orange County Circuit judges that when you see somebody at IA's on a misdemeanor charge from a warrant that came in as a zero bond, that they are obligated to consider setting a bond unless they can write out reasons why that there is great risk to setting a bond without a full hearing. I did not see any other cases that held Mr. LaFever. This was a warrant where the judge issuing the warrant had full authority to enter a temporary zero bond, but I believe that the IA judge was obligated to consider. Now, I don't know what was discussed. I wasn't there, so maybe there were things discussed, but as a friendly well, then again, I'm not asking you to get into another judge's face. It's fine. Never mind. Never mind. No good deed goes unpunished. I was just going to say, we need to remind them. But you probably don't want to do that. You don't want to burn any bridges.
I burned any bridge in my side, Judge. I'm happy to do another one.
No, it's fine. I'll go through my channels again.
Thank you, Judge.
Sure.
At this time, Your Honor, we have not been able to get in contact with the victim. I believe there were some issues with phone numbers, so we're trying to reach her, so she's not been made aware by our office regarding the bond hearing today.
And it's my understanding in preparing for the bond motion, just reviewing some of the items to make sure that I had an understanding of the positions of the parties, that the victim may have not had an issue with being around Mr. Lefevre at that moment, but that the allegations were there was a court order prohibiting him from having contact. It didn't sound to me like it was a forced violation on her part. It wasn't against her will necessarily. Regardless, that's not an element of the crime, but it just doesn't seem like she might be that helpful to you.
Yes, Your Honor.
My guess.
That is a strong possibility. This case is still in the investigation stage, so we haven't gotten all of the information. Like I said, we haven't been able to contact her at this point yet.
Okay. So let me ask the state attorney before we get into the meat and potatoes. Do you have an objection to the court setting a reasonable bond?
No objection to setting a reasonable bond, Your Honor, but however, since we have not been able to contact her, we just request there be no contact.
Sure. All right. So, Mr. Morrison, are you wanting to put your client on the record, thereby be putting him under oath?
No, Judge, we're asking to be set in accordance with the bond schedule as would have been done in IAs.
Well, you know that I have to follow the rules and say that we don't have a specific bond schedule. Those are suggestive bonds for us to consider, and that we are not to just blanket set bonds per some list, but maybe use that as our up or down position where appropriate.
Yes, Judge.
I don't have, and here's the one deficiency from my perspective, is because I'm not the IA judge, I don't have the benefit of PTR. So I'm gonna ask the state what I would have normally asked PTR, and that would be, what kind of history does Mr. Lefevre have? Do I need to be concerned with his ability to remain law-abiding or his ability to return to court when ordered? Does he have FTAs? Does he have previous convictions that would suggest he's violent or he's a danger to this victim?
One moment, Your Honor, and I'll check.
Mr. Lefevre, I'm going to ask you some questions. They're not about the details of this case. It's about your contacts with the community. All right, so please raise your right hand. Do you swear to tell the truth, so help you God? Thank you. Please lower your hand. Sir, how long have you lived in this area?
For 30 years.
Okay. Do you have family here?
Yes, ma'am, I do.
Do you have a job?
Yes, ma'am, I do.
Where do you work?
It's already construction.
I know. Okay. Do you know if that job's still available waiting for you?
Yes, ma'am, it is.
Have you ever willfully failed to appear for court?
I've never had one FTA.
Okay.
Your Honor, I don't see any failure to appear as there is some drug-related history for possession of methamphetamines, delivering, distributing. Some criminal traffic cases, possession of cannabis.
The underlying battery charge is closed, correct? The one that had the no contact provision?
Yes.
That he allegedly is accused of violating, that one was actually no info?
Yes, Your Honor.
Okay. And I'm sorry, I cut you off. What else were you going to say?
That's okay. I do not see anything other than quite a few drug cases that would show any kind of violence or anything like that.
Thank you. Anything else from the defense that you'd like for the court to consider in support of your motion?
No, Judge.
Well, Mr. Lefevre, you certainly are not a stranger to the Osceola County Courthouse. right, Mr. LaFever, at this time, in consideration of the information that the court has been provided, the court is going to grant your request to set bond. Your bond in this case will be set at $1,000. Pretrial release supervision if qualified, but regardless of the PTR qualification or not, the court is going to order no contact with the listed underlying victim until further order. Do not possess any weapons or firearms and remain law-abiding in general. And then I'm assuming we'll just set this for November pretrial and we'll go from there.
Yes, sir.
Oh, I apologize. The clerk is informing me that because the information, the charges have not yet been filed, it'll still be on demand. If the state decides to file charges, then pretrial will be set.
Yes, sir.
All right, thank you.
Thank you, Your Honor.
Nice to see, thank you, you too. Nice to see you, Mr. Morrison.
Nice to see you too.
Thanks. All right, Ms. Nadal, who else can we get?
We have to readjust Mr. Moore, Your Honor. Mr. Moore is requesting a Nelson hearing.
Okay, give me a second. I got off the page of his. All right, so this is, where did I put his paper? 21 MM 1581, State versus Kevin Moore. Mr. Moore, please raise your right hand. Do you swear to tell the truth, so help you God? Thank you. Please lower your hand. So what's going on with your attorney that she is now telling me that you are asking for a Nelson hearing? What has been ineffective that you believe in the representation? I'm sorry, sir, I can't hear you.
I don't mean any harm or disrespect towards anyone. I'm not an attorney, I don't know much about law, but for someone who doesn't know much about law, I believe that I have enough sense. If I was in her shoes, I would ask the person of the defendant some type of question up to this point, 119 days, and she's not one time showed any type of concern about this. I mean, that's fine, that's her point, but I also have to think about myself in this situation.
Okay.
Even asking if I did it, stuff like that, just simple questions that anybody, I think, would ask. And I could be wrong, but personally, I feel like if you're not even questioning me on this stuff here, and every time I talk to her, stuff like that, and it's with the state is wanting and things like that, personally, I understand what the state is doing, I understand their job and all that stuff, I know that, but I didn't do this mess, and I just want to get a fair trial, fair people in my corner, and that's it. I'm not feeling it, I'm not. So that's why.
So you're saying that your lawyer hasn't put in enough effort to try and help you with this case?
No, ma'am, I don't.
Is it because you feel your lawyer hasn't put in the level of effort you think should be put in it, or?
No, that has nothing to do with that. I said it again, she just hasn't talked to me about this, not one time about it. The only thing we heard talk about, actually, she talked about was what you guys want to do with me and with the situation. And I understand that, but, there's two sides to everyone's situation.
All right, I appreciate that. So who is counsel of record, Ms. Nadal? All right, so can you please address the complaint that's been raised?
Yes, Your Honor. Please give me one moment. I will get my notes and provide information. This case was originally assigned to a different public defender in June. I was assigned it in late June when that public defender left. I made contact with Mr. Moore initially on June 23rd, and we discussed all of his options
Mr. Moore, is there anything else that you want to say? So at this time, having considered the complaint of the defendant and having considered the response of the complaint by the defense attorney, the court does not find that there has been ineffective assistance of counsel. I think that there may just be a disagreement as to expectations. And so, Mr. Moore, if you decide that you wish to go forward without the public defender's office, I will remove them for you, but then it's going to be up to you to decide if you're going to talk to a private lawyer or if you're going to represent yourself. So, do you want me to remove them? It doesn't have to happen. That's your choice. I'm sorry, sir. I can't hear you.
I don't know, I'll throw with the punches, man, I'll just chill here and you guys ready to handle it out.
I'm sorry, sir. Because of the mask, I'm having a hard time hearing you. The mask is right at your top lip. Can you just lower the mask and speak to the microphone so I can hear you?
I'm willing to just do whatever you think, man, I don't know.
I can't make that decision for you. You have to tell me if you want to keep the public defenders or if you want me to fire them. See, the problem is that the law doesn't, if you get a court appointed, wait, let me talk. Can I talk? Sir, can I talk? The law doesn't let you have the lawyer, the court-appointed lawyer of your choice. So I can't give you a different lawyer from the public defender. It's their office that decides which lawyers represent which divisions, which people. If you don't want the public defender's office at all, that's a decision you can tell me and I'll remove them, but then you don't get another court-appointed lawyer. So you could talk to a private attorney or you could represent yourself. Those are the other options if you ask me to fire the public defenders, or you can ask me to leave them on your case. Well, but because you're complaining about them, I need a decision on whether you're going to fire them or not fire them. Well, you did hire them when you applied for a public defender. No, you don't have to apologize, but you got to remember that the lawyer decision is yours, not mine. So, do you want them fired or not? But you have to answer it because you're the one who brought it up. You refuse to answer. At this time, the public defender's office will remain and the case will be set for trial. You still want to take it to trial, Mr. Moore? Sir? All right. And so, we're going to set this for trial November 2nd. Thank you. Okay, who else do you have, Ms. Adol?
Your Honor, if I may?
Yes.
I did get in contact with the victim. He does not want to provide a victim impact statement, and he's okay with her claim to pay if she chooses.
All right. Thank you. State versus Megan Valley, 21 MM 1189. And I'm sorry, he was advised that this could potentially be a plea?
Yes, Your Honor.
And he did not want to make a statement?
He does not want to make a statement.
All right. You okay, Ms. Valley?
Yes, ma'am.
All right, so Ms. Nadal, what is the negotiated plea?
With one of adjudication, 12 months supervised probation, drug evaluation and treatment, random drug testing, and court costs.
You said drug eval?
Yes, Your Honor.
Okay, random drug testing and court costs. And then what happens to count 2?
I believe there's no cost, Your Honor.
Can the state confirm?
Yes, Your Honor.
Is there any restitution that needs to be considered?
No, Your Honor.
Okay. Ms. Valley, please raise your right hand. Do you swear to tell the truth, so help you God?
Yes.
Thank you. Please lower your hand and say your name.
Maggie Valley?
I will tell you that there has been an amended information. This was filed yesterday. Count 1, criminal mischief. Count 2, domestic violence battery. Count 1 is punishable by up to 60 days in jail, 6 months probation, $500 in fines. Count 2, up to a year of jail, a year of probation, $1,000 in fines, possible 26-week batterers program, and a $201 domestic violence surcharge. So I have a couple of questions. Because the amended information was just filed, defense would have to waive arraignment and the 24-hour period for that arraignment if we proceed forward on the amended information. Okay. Second question, does that then flip the plea to plea to count 2 and null pros count 1?
Yes, Your Honor.
Okay. Third question, why would I not impose batterers program? I need a reason for the record.
Your Honor, batterer's intervention was part of the negotiated offer that I sent to Ms. Nadal.
And I'm sorry, I didn't think I heard that, so if I didn't hear it, I apologize.
I did not say that because I believe that the last update did not include it, but I may have been mistaken. Please let me double check.
Okay.
And I will also double check.
It's here. I apologize. I missed it.
So Ms. Valley understands she's got to do the 26-week batterers program?
I will turn it over. Yes, Your Honor. I understand. So good.
Okay, so let me do the start again. Please raise your right hand. Do you swear to tell the truth, so help you God?
Yes, ma'am.
Thank you. Please lower your hand and say your name.
Maggie Valley?
Ms. Valley, the public defender should have a plea form with your name on it. Did you sign that?
Yes, ma'am.
Did you read it?
Yes, ma'am.
Do you understand the rights in the form?
Yes, ma'am.
Do you have any questions?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you feel like anybody forced you to make the decision you made?
No, ma'am.
Are you acting under the influences of any types of medications, drugs, or alcohol?
No, ma'am.
If you are not a U.S. citizen, entering a plea is a reason to have you deported. Do you understand that?
Yes, ma'am.
Are you willing today to waive your rights and enter this plea to resolve your case the way the state and your lawyer worked it out?
Yes, ma'am.
With regard to count 2, how do you plea?
Guilty?
On August 1st, 2020 in Osceola County, Florida, did you intentionally touch or strike Artur Zarahoff without permission?
Yes, ma'am.
And how is he related to you?
He was my boyfriend at the time.
Did you all live together as a family?
Yes, ma'am.
Okay. So I find that you are alert, that you are intelligent, that you understand, that your plea is freely and voluntarily entered, and that I have a sufficient factual basis, and I will accept it. It'll be a withhold of adjudication on count 2, credit for 38 days served, followed by 347 days of supervised probation. Probation technically starts as soon as you get out of the jail. So you may not have any contact with Mr. Zarahoff, and you must remain law-abiding and report to probation within 24 hours of your release.
Yes, ma'am.
You have to stay out of trouble. You have to take a drug evaluation within the first 60 days, show proof to probation, and follow through with any recommended treatment. You are subject to random drug testing, so probation can ask you to report for a drug test, and you must test negative to not violate your probation.
Yes, ma'am.
You have to enroll in the Batterers Intervention Program within the first 60 days and continue through with the weekly classes until finished. And you are to pay court costs of $268 plus a $201 domestic violence surcharge and a $100 public defender lien. Those payments will be $25 a month starting in March, because I want you to focus from now until then to do your other stuff.
Thank you, I really appreciate it, thank you.
You have 30 days to appeal this sentence. All appeals must be in writing, and if you cannot afford a lawyer, I will appoint one if you qualify. State, you have an announcement?
Yes, Your Honor, in 21 MM 1189, as to count 1, state announces an old process.
So they dropped the second charge, which was count 1.
Yes, ma'am.
All right, good luck.
Thank you.
You're welcome. All right, who else do we have? Nobody else was brought forward? Okay. All right, so we cannot pick up the video feed until IAs are over. Who has IAs today? Is there anybody they could go, get? Say again? Oh. All right, is there anybody on the docket that you know what we're doing and you want set for trial? And
I know that I think I can go online. Miss Tender was in training this week, so she will leave in the afternoon. I know that Obermeyer.
Timothy Obermeyer? Yeah.
21 CT 1771. He was found ICP in 20 CF 3358.
All right, hold on. I can't. 20 CF 3358.
Yes, Your Honor.
When was he found ICP?
Let me see if I can pull that up.
All right,
It's not mine. I was,
understood. Has a motion, I don't even know if a motion's been filed in our case.
neither do I, Your Honor, but I believe that this might show Epperson.
No, I don't see it. In 21 CT 1777, which is the case we have, there's been no motion filed yet. In 20 CF 3358, it's closed. I don't know why the clerk shows it as closed, because it says motion to adopt findings.
I think I see the discrepancy for some reason in our system. It's listed as in Epperson. But I will have that changed, Your Honor.
Okay, so May 21st of this year, Judge Young committed Mr. Obermeyer to DCF custody. He was found incompetent to proceed on May 20th, and then May 21st, Judge Young signed the order placing him in DCF custody, but he's still at our jail?
I believe, yes, Your Honor. According to this, it says that he's in custody here.
What are they waiting for to send him to state hospital?
I don't know, Your Honor. I have another client who's waiting to be sent to state hospital, and it's been quite a long time, so.
All right, and then we also have 20 MM 2755. Which Judge Epperson has been, all right, so 2755, Judge Epperson has been tracking the felony case. That number is set for status in December because of what the felony court decided. So Judge Epperson saw the order to state hospital and said, all right, I'll set it for a review in December. So if the public defender in 21 CT 1777 is asking for a continuance so that you can get your motions filed and then lined up with the other, I would grant that.
Yes, Your Honor, please.
State have any objection?
No objection, Your Honor.
All right, so we'll waive speedy trial, reset this to the, for now, December pretrial date, and then the defense can file whatever motions they have to file, and we can catch up to the other cases. He's not in custody on our case anyway. He is number 66. What do you mean, number 13? Oh, December 13. I thought you said he's number 13. I'm like, what does that mean? Okay.
And I'm sorry, which date we will?
December 13. Because that's a video pretrial date, right? No, what is it? I don't remember December 13th as a date. Yeah, it is. December 13th is a PD pretrial date. Yeah, now just put it for the 13th for now, because that'll probably end up being canceled anyway. All right. So that takes care of Mr. Obermeyer's case for this afternoon.
I have another veteran address, Malachi Loricious,
Yes.
21 CT 3283. He's being held in Orange County. I actually already have a transport order drafted that I can send to the court to have him transported. It was one where you asked if we could do a video plea, but unfortunately access to that has been limited and we will be unable to do that. So I will send the transport order to your office to get that signed, and he will accept the protection offer that the state has provided.
And competency is not an issue?
No, Your Honor, not at all.
So I can set him for a plea date certain. We could try for the 21st.
Okay.
And then just send over the transport order and we'll get him hopefully transported.
Yes, Your Honor.
We have jail arraignments again on the 21st. What time, Lisa? 10, we'll put it on the docket for 10:30 for a plea date, and the public defender is to provide the transport order for the Orange County transport. Great. Okay. Next.
And just to verify, I know you said it once, but I want to make sure that we don't need to file, anything we've addressed now, we don't have to file a PTC.
Correct. You're fine. PTC sheets are really to have it in case I need to do it without everybody being present, and with the defendants not showing up because we don't know where they're at, but in case of the people on the docket today, we know exactly where they're at. We know where they be.
Your Honor, I believe that's everything that I can address today.
Okay.
Do you want us to be here at 2:30 instead of 2?
No, I'm gonna be hopeful.
Okay.
I mean, it's an hour between 1 and 2 that she's got to do IAs. I'm hoping that,
Well, I just was suggesting it because we've done most of mine, so it'll be shorter, and Mr. Mullins has a VOP status at 3.
yeah, no. No, I would prefer 2.
Yes, Your Honor.
I'm sorry.
No, it's okay, I was just trying to make sure that we had everything going.
Okay, thank you. All right, so we will be, for purposes of the public defenders, we will be in recess until 2. We're gonna still talk about Miss Carol, who is the 10 o'clock. So I need to keep the record going.
Well, thank you, Your Honor, we'll see you at 2.
Thanks. All right, so State versus Rebecca Carroll, 21 MM 1552. This was set for a status because Ms. Carroll was obligated to show proof of an HIV test and an AIDS awareness class. And I told her that if she filed proof of those, she didn't need to appear. but if she didn't file them, she needed to show up to show me why. If they got filed, I was even willing to cancel the status hearing altogether. But I see nothing in benchmark. She was sentenced on July 1st. And at this time, I would note for the record, it's 11:20 and she's not here. Here's the problem. I don't think I can issue a capias because her case is sentenced. This is the reason why I don't like doing prostitution cases without probation, because they don't show up. So, legally, I don't think there's anything I can do. Sometimes just scaring them that they need to show up is a good enough incentive, but obviously didn't work for her this time. I don't think we can even D6 her license because there's no license connection to a prostitution charge. Excuse me? Yeah. All right. Okay. That's it. There's nothing we could do. No, they won't do that. That wouldn't be a proper sentence. All right, we're in recess till, I know that it says Mr. Yanchura at 1:30. If he shows up, he can just wait a little bit. I'm not gonna come back down here and sit in here for a half an hour while they're doing that. So we'll take care of it as soon as he gets here. As soon as I get back down here. We'll take care a few minutes before 2. Thank you. Have a nice lunch. We're in recess till 2. Good afternoon. Can you hear me over there at the jail?
Yes, ma'am. Are you doing the IEs?
I am. Yes, I am. Somebody's happy over there. I'm flashing back to my days when Judge Draper was still here and I showed up instead of Judge Draper and I would get like a round of applause. Y'all remember that? Remember the Draper days?
Yes.
I love Judge Draper. But I don't remember my password. Okay. All right, so good afternoon to everybody. I'm Judge Savage, and I had to think about that for a second. I am Judge Savage. You are here for first appearances. When I call your name, I need you to come up to the microphone, the one closest to the wall. I'm going to tell you the reason why you've been detained, whether or not there's probable cause for that detention, and I will tell you the conditions of your release, if any. If you were arrested on a warrant, another judge has already reviewed the alleged facts and decided that there was enough probable cause to issue the warrant, so I am not addressing probable cause again. If the judge set a bond in the warrant, the bond is going to stay what the judge who signed it put on there, except for if it's the type of charge where I am obligated to consider giving a bond, and then of course I will consider it. If you were arrested on an out-of-county warrant, I can't do anything with that bond to change it, so you're just going to have to either post it or be transported to the other county. I don't have court dates for you for those cases. For the cases that are assigned to Osceola County, if we know the court date, we will tell it to you. You will also get it in writing. If you have a lawyer, your lawyer will receive it. If you don't end up getting a lawyer, then the clerk of court will notify you, or you can call the clerk. Either way, please make sure you don't miss your court dates. If you're in custody, we'll transport you or we'll arrange for the video. But if you're out of custody, please make it to your next court date so you don't end up with a failure to appear. If we happen to say that your next court date is on demand, that means it hasn't been scheduled yet. So please keep in touch with the clerk so that you don't miss that. What else? we are being recorded. You have the right to remain silent. Anything that you say can be used against you. You do have the right to an attorney. If you cannot afford to hire a lawyer, I will appoint one if you qualify. Anybody who asks for the PD will provisionally be appointed the PD. But you must fill out the affidavit and be qualified. If that doesn't happen within the next 10 days, the PD will be removed. I'm not in the habit of making the public defenders do work for people who don't want them to do work with them or for them. So if you need a PD, fine. If you don't need a PD, fine. And basically, that is all I can think of. Case by case, we'll take it as it comes along. We'll jump off that bridge when we get there. Appearances from the state.
Lindsay Card for the state.
And for the public defenders?
For the court's information, there's two defendants that would like Spanish interpretation.
Thank you. And from pretrial release?
Officer Pat Hill on behalf of PTR.
Okay. Who are the two who need Spanish?
Alexander DeSantos, number 5 down on the docket, and then number 8 down on the docket, Hector Martinez Vasquez.
Okay, I have that one. I think mine might be numbered differently, but it's fine. I found them. Let me call for the interpreter. Are we expecting any victims?
I didn't see anyone in the hall on the third floor or on this floor.
Good morning, Your Honor. This is Laura Bretaña, Spanish interpreter, previously sworn.
Hi, Ms. Bretaña. It's Judge Savage. I'm doing first appearances. And so I'm connected to the jail. We have two defendants who need help with Spanish.
Okay.
All right, the first one I have is 20 CF 3449, Hector Martinez Vasquez. Good afternoon, sir. Please say your name.
Buenas tardes, señor. Por favor, diga su nombre. Héctor Martínez.
Mr. Martinez, you're here for first appearance.
Señor Martínez, usted se encuentra aquí para la vista de primera instancia.
Because you were arrested on a warrant for violation of probation.
Fue puesto bajo arresto por una orden de arresto por incumplimiento con el régimen de libertad vigilada.
Judge Carson set your bond at 0.
El juez Karsten impuso prisión preventiva.
And we are going to set you for your next court date.
Y vamos ahora a fijar la fecha de la próxima audiencia.
Do you need a public defender?
Señor, ¿usted necesita un abogado de oficio? No, it's fine.
Are you going to talk to a private lawyer?
¿Usted va a consultar con un abogado privado? No. Su señoría, él ya completó la solicitud del abogado de oficio.
So, do you want a public defender?
Así que entonces, señor, ¿usted desea un abogado de oficio? Yes.
All right, public defender's office will be appointed provisionally.
Muy bien, se designa provisionalmente a la oficina del abogado de oficio.
Next court date?
October 13, 8:30 a.m.
October 13 at 8:30.
La fecha de la próxima audiencia es el 13 de octubre a las 8:30 de la mañana.
Thank you.
Gracias. Thank you.
And then the next one is Alexander Dos Santos. Good afternoon, sir. Please say your name.
Buenas tardes, señor. Por favor, diga su nombre. Alexandre Dos Santos.
Sir, you were arrested for domestic battery.
Señor, usted fue puesto bajo arresto por agresión física por violencia doméstica.
Domestic violence, battery by strangulation.
Violencia doméstica, agresión física por estrangulación.
And tampering with a witness.
E interferir con un testigo.
Or in a court proceeding, a felony proceeding.
O en una audiencia de un delito.
Which really roughly translates to interfering with an ability to communicate with law.
Lo que significa que usted interfirió con la capacidad de comunicarse con las autoridades.
As written in this police report.
Según lee el informe policial.
I've read the affidavit and there is probable cause.
He leído el documento acusatorio y existen indicios de criminalidad.
PTR, any history?
Al Departamento de Libertad Provisional tiene el antecedentes.
He has no history, Your Honor.
No tiene antecedentes, su señoría.
Mr. Dos Santos, how long have you lived in Kissimmee?
Señor Dos Santos, ¿cuánto tiempo lleva usted viviendo en Kissimmee? Approximately 14 years.
Okay, bond will be set as follows.
La fianza se fija de la siguiente manera.
$1,000 count 1, $1,000 count 2, $1,000 count 3.
Cargo número 1, $1,000. Cargo número 2, $1,000. Cargo número 3, $1,000.
All with pretrial release supervision.
Todo esto con supervisión del programa de libertad provisional.
No contact whatsoever with listed victim.
Se le prohíbe todo tipo de contacto con las víctimas.
No return to any shared residence.
Se le prohíbe regresar a las viviendas compartidas.
One-time assist order permitted to retrieve personal belongings.
Se le permitirá regresar en una ocasión acompañado de las autoridades para recoger sus pertenencias.
No weapons or firearms.
Y se le prohíbe la tenencia de todo tipo de armas y armas de fuego.
Do you need a public defender, sir?
Señor, ¿usted necesita un abogado de oficio? Yes.
PD will be provisionally appointed.
Se designa el abogado de oficio provisionalmente.
Next court date on demand.
Se determinará cuál será la fecha de la próxima audiencia.
Thank you, sir.
Gracias, señor.
All right, that's all we have for Spanish.
Thank you, Your Honor.
Thank you. Clinton Johnson. Good afternoon, sir. Please say your name. Thank you. Mr. Johnson, you were arrested on a warrant out of Polk County. They didn't give us a whole lot of details. The bond is set at 0, so we're going to let them know we have you, and then they'll make arrangements to come and pick you up, okay? Thank you. Anthony Brown. No problem. I see him. Thank you. Good afternoon, sir. Please say your name. Thank you. Mr. Brown, you were arrested on a warrant signed by Judge Strobridge for domestic battery, aggravated battery. Judge Strobridge found probable cause. I read through the affidavit to see what the alleged circumstances were. I'll ask PTR if there's any other history that I should consider.
He does have history dating back to 1996, multiple robberies. He had one prior battery, which he was not convicted of, January of this year, and unknown who the victim was. He was only convicted of fraud and sentenced to jail time for that. He also had a robbery out of 2000 in Virginia.
Bond will be set at $5,000 with pretrial release. He does qualify as per the sheet. No contact with victim. Maintain a separate residence or continue maintaining a separate residence. No weapons or firearms. Do you need a public defender, Mr. Brown? PD will be appointed. Thank you. Next court date on demand. Thank you, sir. That's all you have to do. Isaiah Fort. Good afternoon. Please say your name. Thank you. Mr. Fort, you were arrested on a warrant signed by Judge Arendis for grand theft. She found probable cause. Your bond is set at $1,000 plus no return to the Ulta on Rolling Oaks Boulevard. And then it looks like you're out on bond in 21 CF 6606. I don't know if that's the right number. It's got a weird, like a weird combination of numbers, but it's OAO.
Yes, it's out of Orange County, 21 CF 6606, followed by 3 zeros AOS.
That's more zeros. Okay, that's the extra zeros. Threw me for a second. That bond will be revoked and set at 0. Do you need a public defender, Mr. Fort? Yes. PD will be appointed in both cases provisionally. Next court date for the Osceola case will be on demand. Oh, no, he has a date. Okay.
October 15, 8:45.
October 15 at 8:45. Oh, that's right, because they filed on it. You're right.
I'm sorry, can you repeat the date?
October 15, 8:45. You're welcome. Jose Montalvo. No problem. Good afternoon. Please say your name. Thank you. Mr. Montalvo, you were arrested on a warrant. The judge who issued the warrant found probable cause for possession of cocaine. Set your bond at $1,000. Do not possess any drugs or alcohol. Possess or consume drugs or alcohol.
Your Honor, who does qualify for direct PTO? Your Honor, is
I would not. Do you need a public defender, Mr. Montalvo? PD will be appointed provisionally. Next court date?
on demand.
On demand. Thank you.
Thank you.
Jeffrey Rivera. Thank you. Good afternoon, sir. Please say your name. Thank you. Mr. Rivera, you were arrested on a capias for failure to appear. Judge Epperson actually gave you a bond of $250. Do you need a public defender, sir?
Yes.
PD will be appointed provisionally. Next court date?
October 14th at 8:05 a.m. if still in jail, or November 2nd at 8:30 degrees.
So next week if you're still in jail, or November 2nd if you bond out. So you have two possible dates, okay? Thank you. Edwin Santiago. Good afternoon. Please say your name. Thank you. Mr. Santiago, you were arrested on a warrant for sale of cocaine within 1,000 feet of a school. Judge Strobridge set your bond at $5,000 plus ordered no return to the scene. Do not possess or consume drugs or alcohol. Do you need a public defender? PD will be appointed. Next court date? They'll let you, sure, there's an info file, isn't there? Did I see it? I don't know. Maybe not. Never mind. On demand, sorry. I'm just confused as to the court dates. I should just let the clerk say them. Sean Smith.
Your Honor, I do have issue with this.
Okay.
It appears he was in Orange County custody when, on the date of his failure to appear. He was transferred here on this, September the 6th, and his court date was September the 1st. So he was in custody in Orange County during that failure to appear.
Do you have that paperwork that you could submit that he was continuously incarcerated from the time that he FTA'd? Or from before?
Do you have some?
All right. So, Mr. Smith, you were arrested for a capias for failure to appear. Judge Epperson issued it and set you a $500 bond. If your public defender wants to submit that paperwork with a motion for release, you can do that. But if I don't have it right now to look at, I'm not going to consider it.
Your Honor, we set this for tomorrow, so the public defender can acquire the documents without a motion.
No, you can file a motion. Mr. Smith, do you need a public defender?
I feel like I put that motion myself because it's hard for me.
Okay. So he does not wish for a public defender. No problem, sir. Next court date?
Next court date, October 14th, if still in jail.
There is. It's 500. Next court date is when?
October 14th, if still in jail, or November 2nd, be released.
All right. And so for the record, what he was saying to me was he felt like he could represent himself. So at this point, that he has that right. So he could file his own motions. James Stoudemire. Thank you. Good afternoon, sir. Can you please say your name for me? Mr. Stoudemire, you were arrested on a warrant. Judge Strobridge issued this warrant for a charge of sale of cocaine within 1,000 feet of a child care facility. Your bond is $5,000 plus no return to the scene. Do not possess or consume any drugs or alcohol. Do you need a public defender, sir?
Yes.
PD will be appointed. Next court date? On demand. On demand, sir. Thank you. Yolanda Wiggins. Thank you. Good afternoon, ma'am. Please say your name. Thank you. Ms. Wiggins, you were arrested on a warrant. Judge Strobridge issued this warrant for a charge of sale of cocaine within 1,000 feet of a specified area. Your bond is set at $5,000 plus no return to the scene. Do not possess or consume any drugs or alcohol. Do you need a public defender, ma'am? Yes, ma'am. PD will be appointed. Thank you. Next court date? On demand. Aaron Yule. Thank you. Good afternoon, sir. Please say your name. Thank you, Mr. Yule. You were arrested on a warrant for violation of probation. Your bond is set at $0. I'm now being informed that you retained private counsel. Your next court date will be?
Okay, his attorney waived the arraignment, guilty arraignment, so they set it for February 1st.
Your attorney waived arraignment, and so your VOP status or VOP hearing is February 1st. Thank you. Hector Alvarez. Thank you. Good afternoon, sir. Please say your name. Thank you. So I was looking at this, I actually looked at it twice, and because the public defender just brought it up, I'll look at it a third time. You were arrested for grand theft, Mr. Alvarez, and so I would turn the public defender's attention to, it looks like paragraph 2. As he being the victim, was inside, heard his phone making a noise that alerts him that his scooter is moving. He then ran outside, observed an unknown subject whom he had seen at the motel before, pushing the scooter down the hallway. Peter chased after the subject and demanded for him to give his scooter back. So that's a removal with an intent to deprive. Ultimately, it may have happened an attempt a second time, but that's sufficient for probable cause. PTR, any other history?
Yes, Your Honor. He has a total of 37 arrests between the years 2008 and 2021. Duellises, multiple batteries, multiple grand thefts, burglaries, dealing in stolen property. He was just released from prison in April of this year, followed by 3 days later an arrest for battery, domestic, and kidnapping. Both charges were dropped. The most recent conviction was 2021, where he was sentenced to prison in February.
So your bond in this case is going to be set at $2,000 plus pretrial release, no contact with listed victim, no return to the motel where it says motel at the Saralago. I'm not sure exactly what name that is. Yeah, they've got it written weird, so no return to scene. Do you need a public defender to represent you? PD will be appointed. Next court date? Thank you. See, that's the instance where I don't understand the risk assessment sheet, where somebody has 37 prior contacts with the law, grand thefts, DSP, and then he qualifies for direct PTR. I mean, like, how does that happen?
The admin order really needs to be reviewed because it's based solely on the charge.
Right. We need something more along the lines of what they do with juvenile detentions. Think certain history scores certain detention points. And so if somebody scores a point of like 0 to 11, it's this, 12 to, whatever, it's this. If we had something along those lines, I think it would take into account convictions, not just contacts, but convictions, failures to appear, failures to abide by other court orders. Those types of things are what judges are obligated to think about.
I agree, and that's why I really like it when the judges ask for history, because that will help usually the judge make the determination that we're not necessarily asking for the direct, it's just we have to have it on there because of the admin order.
Got it. Devin Bartlett. But every time that comes up, Ms. Hill, they don't ask me my opinion. I join that committee. If you hear that coming around, let me know.
I will. I know they're going to be getting to work on it, so.
And Miss Jackson, or I should say, Major Jackson would definitely put me on that, so. Good afternoon, sir. Please say your name. Mr. Bartlett, you are here, you have two case numbers. One is a warrant for which you were arrested, and then the other is for a new law charge. The warrant alleges sale of cocaine within 1,000 feet of a specified area, and Judge Strobridge set your bond in that case at $5,000 plus no return, no possession or consumption of drugs or alcohol. The new charge is then possession of cocaine, which I read, and there is probable cause. PTR, any other history?
Yes, Your Honor, he does have history dating back to 2008, dealing in stolen property, marijuana possession, paraphernalia, FTAs, VOPs. The most recent was a VOP in 2019, which was terminated and revoked on August 2019.
Bond in the new charge will be set at $1,000 with pretrial release. Random drug testing, do not possess or consume illegal substances. Do you need a public defender, Mr. Bartlett? I'm sorry. Yeah, PD will be appointed provisionally. Thank you. Your next court date will be? On demand. Thank you. Nelissa DeRosa. Thank you. Good afternoon, ma'am. Please say your name. Thank you. Ms. DeRosa, you were arrested for assault on a law enforcement officer. There is probable cause. PTR, any other history?
She does have history dating back to 2015, ag assaults, battery, domestic conviction in 2019, trespass, public intoxication. She is out on bond for battery and obstruction of justice out of Polk County.
Bond in this case will be stated at $2,500. Do not possess or consume any alcohol. I'll ask PTR to just notify Polk County that she's in our custody.
Yes, we've done that already.
And do you need a public defender, Ms. DeRosa? Yes. PD will be appointed provisionally next court date. Thank you. Luis Garcia. Garcia bonded. Neoris Polanco. Thank you. Good afternoon, sir. Please say your name. Thank you. Mr. Polanco, you were arrested for domestic violence battery, and there is probable cause. PTR, any history?
He does have multiple priors dating back to 2016, marijuana, possession of cocaine. He was convicted of a battery in 2019, which was non-domestic. He had a battery domestic conviction, same victim, January of this year. It was dropped. He also had another one in March of this year, same victim, also dropped.
I'm sorry, I thought you first said battery conviction this January of this year, which was dropped.
I think she meant arrest. It was not a conviction.
Oh, I'm sorry, an arrest, yes.
Oh, okay, an arrest. Okay, yeah, so the police report does allege 2 previous domestics with the same victim, which were ultimately dropped.
Correct.
Okay, but no previous convictions for domestic with this victim.
Correct.
Correct.
Not a simple battery conviction, an unrelated victim.
Right.
Yes.
Gotcha. All right. Mr. Polanco, your bond in this case is going to be set at $2,000 with pretrial release, no contact whatsoever with the listed victim, no return to any shared residence. You may have a one-time assist order if you are retrieving personal belongings. Do not possess any weapons or firearms. Do you need a public defender?
Yes, ma'am.
PD will be appointed provisionally next court date. I'll let you know. Thank you.
Thank you.
You're welcome. Joshua Rodriguez.
He's still in hospital.
Yes, no problem. I'll just ask the jail to reset when available. For the record, he does have a bond. He's not being held without bond. So he has an option to bond, but he has the right to appear for first appearances. But let's not just keep rolling him day to day because the paperwork has to be prepared each day. When he's ready, we'll bring him in. Thank you. Alice Triplett.
She has refused at this time. She's still in medical after she's detoxing. We'd ask for a waiver and a bond to be set.
Okay. Because she's in medical, I will allow the waiver. I don't typically allow, I don't want to come answers because they don't really have an option, but medical is understandable, especially if she's detoxing, she may not be thinking clearly. So I'll give her the benefit of the doubt. I'll waive her appearance. She was arrested for simple battery and obstructing without violence. There is probable cause. PTR. I know that she's out on bond in 21 CF 2748 with Judge Karsten.
Yeah.
Any other history?
She does have extensive Florida history dating back to 2017. Convictions of possession of paraphernalia, ag assault with a weapon, disorderly intox, possession of paraphernalia. She also has history out of Virginia, Louisiana, New York, Pennsylvania, and Texas.
Bonds will be stayed, and then bond with PTR in 21 CF 2748 will be revoked and set at 0, and then Judge Karsten can reevaluate what he wants to do with that. Public defender is provisionally appointed because she's in medical and may need some assistance. Thank you. No, she doesn't qualify for PTR on our case, it's just bond on ours, and I'm revoking her bond with PTR on the other case.
And Your Honor, with the bond on this case, can we get no contact with the alleged victim?
Yes. So for clarification, on the new law, on the simple bat, it would be bond with no contact. She does not qualify for PTR supervision because of the legal constraint of the other case. But the other case is going to be revoked and set at 0. That's why I didn't say the no contact, just because she's not getting out.
Right.
But in case she gets out.
Just in case. Thank you, Your Honor.
Sure. No problem. And Luis Velasquez?
He's also in the hospital. We asked that he be reset or when he is available.
Yes, at the request of the public defender, because Mr. Velasquez is still in medical, the court will reset this and ask the jail to notify the clerk when Mr. Velasquez is available and ready to appear. In the meantime, though, I am going to say that he may not have any contact with the listed victim from the jail. That is his son, who's the listed victim in the booking report. But there is probable cause for aggravated battery domestic with a potential deadly weapon and a resisting without. Thank you. And public defender's office can be provisionally appointed while he's in medical. And then last but not least, Kevin Karras.
He is in the same situation as prior. He is detoxing in medical. We waive his appearance and ask for a bond.
Okay. It looks like it was reset already before because of medical. So at this time, the court will allow for the public defenders to waive Mr. Karras's appearance at first appearance. He was arrested for domestic violence battery. I read the affidavit. There is probable cause. Apparently, the alleged victim is his brother. Bond will be set at $1,000 with pretrial release if he qualifies. I don't have the qualification sheet since it was a reset, but if he qualifies, it'll be no contact, no drugs or alcohol, random drug testing, maintain a separate residence. Thank you. All right, and that will be, again, not reset. The next court date will be? On demand. I wanted to make sure that was said for the record. Thank you. All right, thanks. So what we'll do is I'll turn this off. When y'all are ready, you clear them out and you can bring all my 2 o'clocks in.
Okay.
Perfect. Thank you. Appreciate it. Yeah. Okay, well then it'll be all those conditions, but without PTR supervision. Thank you all very much.
Thank you. Thanks for filling in.
Hey, no problem. I wanted to make sure that I get my jail feeded too.
We appreciate you.
Were you talking about building conditions also?
Okay.
No, the last one, Mr. Karas.
Okay,
I just said the conditions will be the same, just without PTR supervision.
thank you.
Sure.
Thank you again.
All right. Pat, it was good to see you. I have IAs, I think, first week in November.
Good.
Hey. I'm good. Thanks. I'm gonna go get some water, and I'll be right back. So we're going to go on the record and address State versus Michael Yanchura, 19 CT 3557, appearance from the state.
Sofia Viriel Sanchez and Cynthia Carrasco.
Thank you. Good afternoon. Please say your name.
Michael Yanchura.
Thank you. Mr. Yanchura, I was hoping that this will be the last time that we were going to get together. And probation gave me an update that the last letter they had from Aspire was August 9th. But the last time you and I spoke in September, you told me that you would have everything. You should be done by today. Did you bring anything with you?
No, I completed all my classes. Aspire never scheduled. I'm supposed to do a some kind of like mid-treatment drug test, in which they never scheduled. So I took it, I think the day that I had court here last, and then from that I have to do an exiting drug test 30 days outside of the mid-drug test. So now they're making me wait until November 2nd to do my exit, which I've completed all my treatment, all the weeks, so it's really just sitting around waiting.
It's about that. That's, you need to do like a pre-drug test, and then a pre-entry drug test, and then a during drug test, and then a pre-exit.
I kept asking because they told me, and they just said that they'll schedule it, and then they wait until week 19 to do it.
To my knowledge, you've never had a positive drug test during this period. So, State, what is your position with regard to moving forward?
Your Honor, at this time, we do not object to a reset. A reset to a
dismissal. Are you wanting a reset? He's finished everything, except for the fact that they haven't given him the piece of paper because they're waiting 30 days for one last drug test. But he did all his classes. He's had negative drug tests for over a year.
Okay.
I'm just making sure that, because I've been on the case longer than you have, so just kind of keeping you up to date with all my notes.
All right, Your Honor, so at this time, State recommends a dismissal.
Mr. Yanchura, I'm going to dismiss the violation, reinstate and terminate your probation. You're all done. Please just make sure that you've done so much work. Just go do this last drug test, get the certificate. You never know why it might be important, especially if it ever has anything to do with your license again. You want to prove that it got done.
Yes.
But other than that, I'm going to cut you loose finally.
Yeah.
Best of luck to you. Please stay out of trouble.
For the paperwork, where do I need to send it in?
Just send a copy to the clerk with your case number over the top of it. Second floor, like you would file anything else. You don't have to give it to Sarah. You don't have to bring it to me. Just drop it off to the clerk's office with your case number on it, and you're good.
Okay.
Good luck.
All right, thank you.
All right. Lisa, here are 2 more PTC sheets. And I don't see the public defenders in the jail room yet. Thank you. Awesome. Appreciate it.
Your Honor, may I briefly address?
Sure, give me 1 second. understand this one. Nope, that's not right. No?
I think this is the.
Yep. Oh.
Oh, that's the one that I can find. Let me check that.
Hello, Your Honor.
Hi. All right, Mr. Seibel, what can I help you with?
Yes, thank you, Your Honor. Good afternoon.
Hi.
If we may briefly address the Quintero cases, I believe they're 21 MM 954 and 657.
These are ones that were set for pretrial yesterday?
Yes, Judge, and the issue, I just got notices of bench warrants for lack of PTC sheets. They were filed. I was able to confirm with the clerk that they were filed yesterday. They weren't processed for whatever reason, but they were filed, and I did receive confirmations yesterday after I filed them. I did file motions to withdraw in both of those cases, Judge, but I would just, I guess I'm here to ask or appeal to Your Honor if we could at least have maybe on Monday some type of status on that hearing, at which point Mr. Quintero can be present and or not for then Your Honor to make a decision.
So, Mr. Seibel, let me explain to you the way this happened so that you know why things get done the way why I ordered them the way I ordered them. That way you could hear my explanation. I am going to recall the warrant, but let me explain to you why it was entered.
Yes,
Okay? So, this morning, we had court. While there was a lull in some of the court, I continued working on the PTC sheets. I asked the clerks, is there anything in the e-portal? Before I start issuing warrants, is there anything in the e-portal that you all can see? Because I knew that last night people were filing as time was going by. And they told me, Judge, there's nothing in the outside portal. We pulled everything down that we saw that was in there. And I'm like, okay. So I kept going. Your PTC sheet is in there now. And the way the clerks have to enter it is the day it is e-filed, the stamp of the time you submit it is the time they have to say that it was e-filed. So it says date October 6th, but if you go all the way across, it says created by and then modified by. And those dates say today. So when I did this earlier, that wasn't there. When I looked at it and saw your motion to withdraw, your PTC sheet was not there. Even though you filed it yesterday at 5:09, when I looked, it wasn't there. So it got entered after I looked.
Right.
So that's, just wanted to let you know why it got ordered. We have to do only what we can do with what we see, and the system is messed up.
It appears that way. Unfortunately, it was
Okay.
not processed.
So I wanted to let you know that.
And I appreciate that, Judge, as long as you understand, and I appreciate you recognizing that it was filed. I apologize for that slight delay.
That's fine.
That's also why that delay was also part of why I filed a subsequent
No
motion.
problem.
So-
I understand what you're saying, and for that reason, I'm willing to say, no problem, with recall the warrants. But when Lisa Mariola and I are dealing with a system that allows for a recapture that looks like it's retroactive to when we looked at it, it's frustrating, because what does that mean? That means I gotta wait 5 days
Yeah.
for it to be found out in cyberland somewhere? It's frustrating. I'm not taking it out on you. I just wanted to explain to you.
You and me both, Judge.
You know what I mean? I want to do things consistently. I want to do things predictably so that you know what to do. You know how to advise your clients. I'm all for that. But for us, it's like, it's not there. What do we do with it when it's not there?
Right.
And then I go back and go, oh, it's there now. Oh, yeah, it was put in after.
Right, which I don't understand, because it's one of those things that, we get the notice that it's filed, and
Right.
I was out in a trial this morning, and my assistant sees the bench warrant, and
I
it's like,
understand.
wait, we know we filed it, so it's, I appreciate your honor.
But when you look at these, don't just look at the, like, if you want to confirm that it was filed, like, you go into benchmark, you'll see date, the name of the document, and then you'll see created by and modified by. If you see created by and modified by a day or two later, that means they didn't enter it
No,
until
it's-
the day or two later.
No, that was the issue, is when she checked prior to me 30 minutes ago, or I guess 45 minutes ago, it was showing pending still on our end,
Right.
so that's.
And when
why-
I looked at it this morning, it wasn't there. So I'll recall the warrants. So again, it's 21 MM 659.
May I pull up my phone, Your Honor?
Yes, and 21 MM 957. Recall the capiases. I can't send it Monday. I'm not here Monday or Tuesday next week. I can set it.
I'm just trying to be, just trying to expedite it, Judge.
I understand. I can set it for status October 15 at 11:15. Can you be here at 11:15?
I'm double checking, Judge.
Or I could do the 13th, the 14th, or the 15th at 11:15.
If we could do the 14th at 11:15.
Got it.
I'll be here. I'll make sure
Sounds
that he
good.
has
So
notice.
status October 14th, 11:15, and Mr. Quintero must appear.
I will let him know, Judge, and absolutely we'll give him that notice.
Awesome. Thank you. Sorry for the confusion.
No, thank you, Your Honor, for hearing the matter.
No problem.
You have a wonderful day.
You too. Okay, so, Kevin Arzola. Good afternoon, sir. Please say your name. Thank you. Mr. Arzola, I don't know where your lawyer's at. Have you talked to him?
Nope.
When was the last time you talked to him?
I got two different ones. I got police defendant and I got private one.
Mr. Bano,
No, he's
the private. Okay. He filed a paper today, and he said that you wanted to resolve this no vehicle registration case. The attaching the tag case, and then we were gonna talk about all the tickets you got, but he's not here. So I can't do anything about these cases without him being here. Now, the good news is you're not in custody on these cases anyway. You're on custody in other cases. But I can't plea you to this without your lawyer being here. So I'm going to set you for my cases another time and tell Mr. Bano to come. He should have, hopefully, I mean, I would have liked him to be here to talk to you, but sometimes they just file the paperwork, and he did file his paperwork. So I'm going to reset you for a plea date, and then hopefully he'll be able to talk to you before that plea date. We're going to reset you for October 21st, okay? And that's just the misdemeanor cases, and you're not being held in jail on the misdemeanor cases, okay?
Thank you.
All right, thanks. Yeah, that's fine. Is there a space at 10:45? Yeah. So here, you want to hold all these and so you don't have to reprint them all? No, I know, like because he's got 27 infractions. Jeffrey Bowles? Good afternoon, sir. Please say your name.
Jeffrey Bowles, good afternoon, Your Honor.
Thank you. Appearance of counsel for the defendant.
Michelle Patano for the defense, Your Honor.
Thank you. So what are we doing in this case?
Your Honor, I'd like to request a continuance in this case. Mr. Wiltz has an open felony.
Okay, let me take a look. Is the felony related?
It is the same victim, Your Honor.
Gotcha. It looks like it's a first-time defense continuance. Does the state have any objection?
No objection, Your Honor.
An appearance from the state, please.
Jody Lillinis for the state.
Thank you. One docket or two?
2, Your Honor.
All right, so we'll set it for the December pretrial, and I hope by then you all have worked it out. I have no objection if the felony judge wishes to incorporate this into the resolution of the related case, if they are interrelated, as long as the state and the defense are on the same page.
Yes, Your Honor.
Thank you, Your Honor.
All right. And that's a waiver of speedy trial.
Yes, Your Honor.
Alicia Davis. Ms. Nadal. You know how and why we started at 2 o'clock?
Yes, Your Honor, because I snuck in on the jail feed for initial appearances, and I heard a lovely voice that sounds very familiar.
Imagine. I did a non-hostile takeover.
You know, I thought at first, I'm like, oh, well, the feed, someone said, oh, do you know that eyes are 4A? And I'm like, oh, maybe because the feed's in there, and I'm like, let me double check. And then,
Hi, Ms. Davis. Good afternoon. Let me ask the public defender what we're going to do with your case, okay?
Okay.
Which PD represents Ms. Davis? Alicia Davis? Thank you.
Yes, Your Honor, I'd like to ask the state if there was an offer in this case.
I would guess it's going to be credit time served. It's an M2 and she's got 56 days. Ms. Davis, would you like to take that offer or do you want to go to trial? Oh, I'm sorry, the mic is off.
Your Honor, I just wanted to just put on the record that this is a county,
County ordinance violation, yes. Okay. It's fine. They normally will credit time served after a day in jail, so I don't know what happened. But if Ms. Davis is interested in that plea, I'll give her a chance to read her plea form and sign it.
Yes, Your Honor, Ms. Davis has an open DOP. I don't know how that affects this type of case.
Oh, okay. Do you know what that VOP is set for? That explains why it hasn't been resolved yet.
Yeah, they never called my name for court. I was sitting in the holding cell this morning.
Okay, give me a second. It looks like 19 CF 4089 She was set for status, supposed to be this morning at 9:30 with Judge Nix.
Yes, ma'am.
And you didn't get called?
No, I didn't.
Okay, give me a second. Well, unfortunately, Ms. Davis, there's not a whole lot I can do about that felony VOP. I don't have jurisdiction in that case. Even if I release you, which I can release you on my case, you won't go anywhere because you're still in custody on the VOP. So I would really press upon your public defender to find out what happened this morning and why her case wasn't called, because it should have been, and she's got a significant amount of time in on at least my charge. So I'm going to enter an order of releasing her ROR in 21 CO 11. She's maxed pretty much for me. And then I'm going to let the felony judge do what the felony judge needs to do. Okay, ma'am?
Yes, ma'am.
All right, so we'll reset this for approximately 30 days out, jail arraignments, but hopefully she'll be out of custody by then and she could just come on in and we can figure it out.
Well, me?
Yeah, I don't want to take your plea because I don't want this to be a reason why your violation of probation creates a problem for you. But I'm looking at the affidavit in that case, and it looks like it's more than just this. But I just don't want you to say, yes, I'm guilty of panhandling, and then they use it against you in the felony court. I understand what the public defender's strategy is. So they'll explain this all to you, okay?
Okay.
All right, you're welcome. Reset jail arraignments, November the 10th, in courtroom 5B. Yep. State, just for the record, I have to ask, do you have any objection to the ROR? In our case, she's got 56 days, it's an M2, 60 days max.
No, a state has no position, Your Honor.
Okay. Lawrence Hill. Okay, thank you. Lisa, here's one more sheet for you for pre-trial. Good afternoon, sir. Please say your name. The microphone is off. Please say your name, sir.
Lawrence Hill,
Thank you. Mr. Hill, what's your date of birth?
22675.
Thank you. I asked because we thought you were in Orange County, so I wasn't sure if we were talking to the right person. It looks like we are.
I was until 5 o'clock this morning.
Okay, thank you. Defense, what are we doing?
Your Honor, I'd like to request a continuance in this case. Mr. Hill has an open felony.
Is it related?
I believe it is.
State, any objection? It looks like it's a first-time defense continuance.
No objection, Your Honor.
One docket or two, defense?
I apologize, Your Honor.
One docket or two?
2, please.
All right, set for December pretrial with a waiver of speedy. Thank you. Eduardo Rivera Torres, 20 mm 2769. Good afternoon, sir. Please say your name. I'm sorry, the mic is off.
Rivera Torres.
Thank you. Counsel, what are we doing?
Yes, Your Honor. Mr. Rivera Torres would like to accept the state's offer.
And what is it, please?
It's
All right? Mr. Rivera, please raise your right hand for me.
Your Honor, I'm sorry, before you get started, I'm not sure if the victim would like to give a victim impact statement. We haven't been able to reach, for PTC purposes, of whether or not they want to give the victim impact.
Okay, so they were not aware that Mr. Rivera would be perhaps considering a plea today?
They are aware of the offer, however, they're not aware that he would be able to take the plea today.
Gotcha.
Except for status hearing.
So, I understand. I'm unable to take his plea today because the victim is not notified that he would be entering a plea, and the victim has the right to appear and make a statement if he or she wishes to do so. I can set it for a plea date certain if you'd like?
Yes, Your Honor.
Okay. I could set it for the 20, well, if it's credit time served, well, right now, let's do the 21st at 9:30. And then we'll go from there. Thank you. And the state is to notify the victim that he is changing a plea.
Thank you, Your Honor.
Antonin Scotsman. Good afternoon, sir. Please say your name. Thank you. Counsel?
Yes, Your Honor. Mr. Scotsman would like to talk to you, Your Honor.
Well, I need to know if Mr. Scotsman wants to take a plea or set for trial.
Want to set the trial? Take the plea.
What's the offer, state?
The offer is adjudication of guilt, 6 months of probation, an 8-hour driving class, and 25 hours community service.
The basic or the aggressive?
The aggressive, Your Honor.
Okay. And how many community service? 25?
25 hours.
Mr. Scotsman, what would you like to do, sir? Would you like to take the offer or would you like to set for trial?
Yeah, I was here for an offer, which I was told by the last attorney. And the last time we spoke, it was a court, so when I come out, I'm being something different.
I'm sorry, sir. I didn't understand. You're very soft-spoken, so I can't hear you.
Before, I needed to take a plea today, but when I came in, I heard something different than what we spoke about the last time and the last attorney.
Well, actually, no, the state's offer that I wrote down is 6 months probation, basic driver improvement, 25 hours of cost and court costs, and you said not guilty. That's the same offer they're making today. It's not different.
Yeah, Your Honor, because remember I told you that I was on probation.
Yeah, and you said you couldn't take it, and that's fine.
You said, man, you go back down south and take care of my case of Quebec. When I went down here and notified them that I violated probation with police charge, my lawyer contacted the lawyer here that they said on Thursday notice, then I'm supposed to get released at April, but I was told that if I set my case down here and took a charge and terminated my probation, then I'll get my time to get done here. And I did that, and that's why I was in jail tonight.
Yeah, but you've been in jail on probation. You're not in jail on this.
Yeah, because they told me that we would even get permanent if I took my time.
Yeah, no, well, I didn't tell you that. So the judge in Broward can't tell you that I'm going to give you a concurrent jail sentence. Well, the lawyer made a mistake then because I'm the only one who could decide that. And you and I have never talked about that. Concurrent sentences. It's never been a jail sentence. It's always been a probation offer. So it's up to you if you want to take it or not, but the state's offer is probation. It's been the same offer since day one. So do you want to take the probation or do you not want to take the probation? No? Okay, so you want to set it for trial or do you want a jail offer? Okay. State, do you have an alternate jail offer? You already finished your violation?
I'm still, my release date is December 28th.
Okay, got it.
A moment, Your Honor.
Yeah, well, the problem is you've got a 2020 no valid license in Broward, a 2020 reckless driving, a 2021 speeding, 84 and a 50, and then a previous 2021 no valid license in Osceola County. You were convicted in February, and this charge was in March.
Yes, ma'am, because I moved up here, I moved from Broward County to the probation up there. I was doing community service, and the community service they sent me to, I got to be here at 7 a.m. in the morning, not 7 o'clock.
Yeah, I know, but I can't get into the conditions of your probation. I'm just telling you, you don't have a very nice driving record. State, if you have an offer, that'd be great. If you don't, he can plead to the bench.
Your Honor, the jail offer will be adjudication of guilt, 10 days jail and court costs.
Concurrent or consecutive? Because 10 days concurrent isn't gonna do anything.
Consecutive.
I mean, if you think about it, right? If you think about whether or not if you're seeking penalty for this, you have to think about that he's just got finished saying he's gonna be in Broward County. He finishes his VOP sentence in December. So if you decided to offer 10 days concurrent, he's in jail till December anyway, so it doesn't matter. There's no penalty. But, so I mean, and I'm not trying to sway you, I'm trying to kind of let you see how it works.
Yes, Your Honor. It will be consecutive.
All right, so Mr. Scotsman, the state offers 10 days consecutive.
Yeah, I mean, since Wednesday, will that date start? Since I mean,
No, it'll start once you finish your sentence in Broward. Do you want a couple minutes to talk to your lawyer about that?
Not really, but would I be transferred back up here again?
No, I mean, well, actually, maybe, I don't know. They might do it that way. I don't know how they're gonna do that. They'll probably take you back to Broward, you finish your time there, and when you're done there, they'll bring you here to serve your 10 days. I don't think Broward County's gonna wanna pay for our 10 days.
So, can I get released from my time and then turn myself back up here?
No, that ain't gonna happen. No. Go ahead and have a seat and talk to your lawyer, and then you can let me know if you want to take either one of those pleas. It's up to you if you want to do that or not. You could always plead not, you could always set it for trial instead. Clinton Stubbs. Good afternoon, sir. Please say your name. I'm sorry, I gotta wait. The microphone is still off.
Clinton Stubbs.
Thank you. Counsel, what are we doing?
Your Honor, I'd like to request a continuance in this case as a felony VOP.
Okay, let me take a look. So, Mr. Stubbs had a continuance in May, and then for the following pretrial, he didn't appear. He got arrested on the warrant. I guess he filled out an affidavit for the public defender. And now he's in custody on what? On the VOP? Because he's not in custody on ours, right? Did he post his bond? No, he just got arrested in September. That's what it was. Okay. Hold on. State, what was your offer?
The offer, in this case, Your Honor, was an adjudication of guilt, a $50 fine, and a court cost.
Yeah, no, I don't think so. This is a Dwellis as a second or subsequent. Let me take a look real quick. I mean, just first glance, that doesn't sound suitable, but let me look, because it could be. Mr. Stubbs, hold on. I'm looking at 2020 CF 497, which is the case he has reopened for violation of probation. I'm looking at the first affidavit of violation, which was filed in July, signed in the end of the July, and it says, condition, failing to report, condition, failing to report, condition, failing to pay court costs. Doesn't say anything about a new law violation on that first page. Let me see if it's on the second. Nope, it's not on the second page either. Then there is an amended violation of probation, and it still talks about failure to report. Then there's an addendum to the violation. Which still just talks about not reporting and not showing proof of community service hours. Absconding, in other words, not being able to be located. And then there's a second amended violation that still talks about failing to report and community service hours and changing residences. I don't see anything in these affidavits that say anything about committing a new law violation. So if he pleads to the Dwillis, that's not on his affidavit of violation that I can tell. Now, obviously, that's the public defender's responsibility to look at, but I don't see it in there. So if he pled to the Dwillis, it should not be a basis for the violation based on my limited, quick look at the file. Having said that, let me also look at his driving record. Oh, okay. Well, that's a different consideration. Yeah, it will be. But I'm not inclined to give a continuance based on the fact that he's got a pending VOP when the VOP is not impacted. So he's had a previous continuance, I believe, plus the failure to appear. So the motion to continue is denied. It's either going to be a plea or a trial, or at the state's option, a dismissal, a null pros if that's what they chose. And I'm not saying that's what you should choose. I'm just saying he's got two options. You've got your options.
Yes, Your Honor.
So,
Can I talk to Mr. Stubbs for a second?
sure. And in light of his record, I'd be willing to accept an adjudication of guilt in 20 days with credit for 16. You may. Have a good one. Thanks.
Have a good weekend.
You too.
Yes, Your Honor. Mr. Stubbs would like to plead.
All right, so does he need time to fill out a plea form?
Yes, Your Honor.
All right, go ahead and have a seat. And I have Mr. Pius in the video here. Let me let him in. Hi there, yes. Hi, Mr. Pius, one moment. Mr. Stubbs, the offer is an adjudication of guilt and 20 days with credit for 16. Mm-hmm. Mr. Pius, how are you?
Good, Your Honor. How are you?
I'm well.
Good.
No problem. I'm glad you're here. Let me call your client to the video. Pedro Cep, right? Mr. Cep?
Good question.
I mean, that's your client, right?
Yeah, that is it. Yeah, that is right. I don't know how to pronounce his last name.
Guarchag. Yes?
Okay.
One case with the PD's office, I don't know if that was intentional or just wanted to make the court, are they certainly aware?
Let me take a look. Mr. Cep, do you speak English?
No, he doesn't.
Okay, let me get the interpreter real quick.
Okay.
I'm gonna ask, yeah.
Good afternoon, this is Dalia Romero, Spanish interpreter on the line already sworn in today.
Hi, Ms. Romero. We have Pedro Tsip, TZEP, and I'll give you the case numbers in a minute. I want to ask him a couple of questions first.
Okay, thank you.
Why am I hearing feedback, Mr. Pius, on your computer? Are we logged in on more than one?
You know what, Judge, it may be possible. Want me to log out real quick and come back in?
No, that's okay. If you could just turn your speakers down.
Okay. See.
Thanks. Okay, so if the interpreter could ask Mr. Tsip if he can hear her.
Señor, ¿puede escuchar? Yes.
And sir, can you say your name, please? Okay.
Pedro Chap.
And if the interpreter can ask him for his date of birth. Ms. Romero? I lost the interpreter.
I'm here, Your Honor. I'm asked.
I was
wait.
gonna say that we could hear.
Yeah, no, we're on the video feed. I'm sorry.
Okay, thank you.
Sorry.
Is it on Teams, Your Honor?
Yes. No, it's on
No.
I'm on the IA video line.
Oh, okay. Señor, su fecha de nacimiento, por favor. 06/27/90. 91.
Yeah. Okay, so here's what we have. And let me explain it in short pieces so the interpreter can translate.
Bien, esto es lo que tenemos y se lo voy a explicar en partes para que la intérprete pueda interpretarle, señor.
I have 21 CT 2021, which is a charge of DUI.
Tengo el caso 21 CT 2021, que es el caso de manejar bajo el estado de embriaguez.
From July 20th.
Esto es del 20 de julio.
And I also have 21 TR 29681 open container.
También tengo el caso 21 TR 29681 por haber tenido un envase de alcohol abierto.
Now those cases, Mr. Carlos Payas is attorney of record.
Para estos casos, el abogado Carlos Payas, el abogado en actas.
But in that case, the date of birth is 6/28/89.
Pero en ese caso, aparece que su fecha de nacimiento es el 6/28 del 89.
And I have a driving record in the name Pedro Sep Guarchag, 6/28/89.
Tengo un historial de manejar para Pedro Sep Guarchag de 6/28 del 89.
And it has an address of Flying Fortress Avenue.
Can you repeat that for the interpreter, Your Honor?
Flying Fortress Avenue.
Y tiene una dirección de Flying Fortress Avenue.
And then I have another case number, 21 CT 2287.
Entonces tengo otro caso que es 21 CT 2287.
For a charge of DUI.
Que también es una acusación de manejar bajo el estado de embriaguez.
On a different date, August 18th.
Con otra fecha del 18 de agosto.
And that has 6/28/91 as the date of birth, which is the date he gave me as his.
Y ese caso tiene una fecha de nacimiento de 6/28 del 91, que es la fecha que usted me dio.
So, and he also has 21 CT 2363 violation of non-resident requirement.
También tiene otro caso 21 TR 2363 de incumplimiento de requisito de residente del estado.
Not TR, CT.
Perdón, no TR, pero es un caso CT.
And it looks like the public defenders were on that one, but Mr. Pius has recently filed a notice of appearance on that too.
Y pareciera que el defensor público estaba asignado en ese caso, pero el abogado Payas ha presentado documentación de representación en ese caso también.
So my first question to the attorney is, are both of these cases the same person to your knowledge?
Mi primera pregunta al licenciado es si en estos dos casos es la misma persona.
Yes, Your Honor, to my knowledge.
So both
Yes.
Mr. Pius and the defendant said yes.
Ambos, el licenciado y el señor, el acusado, han dicho que sí.
Okay, and I don't know where then the 6/28 date of birth came from. I'm sorry, the 1989 came from.
No sé de dónde salió la fecha de nacimiento 6/28 del 89.
Fueron los oficiales que se confundieron con esa fecha. Yo no tenía mi ID cuando me arrestaron.
It's the officers that got confused with that date because I gave them my ID when I was arrested.
Okay, Mr. Pius, are you intending to represent Mr. Tsep in both different citations?
Yes, Your Honor.
Señor Payaso, ¿es su intención representar al señor Peck en ambos casos? Sí, su señoría.
All right, Mr. Tsep, do you want me to go ahead and remove the public defender from the one case and put Mr. Pius on there as your attorney?
Señor Tepp, ¿usted quiere que yo retire la oficina de defensores públicos del caso que tiene al defensor público y que ponga al licenciado Payás en su lugar?
Sí, que lo hagan juntos los dos casos.
Yes, so that they can put them both together,
All right, so
both cases.
Public defender is withdrawn from 21 CT 2287.
Bien, así que la oficina de defensores públicos se retira del caso 21 CT 2287.
And the offices of Carlos Payas are listed as attorney of record.
Bien, y la oficina del licenciado Payas quedan como los abogados en actas.
Okay, so then we move to, what does the defense wish to do with these cases?
Bien, lo próximo es qué quiere hacer la defensa en este caso.
Okay, go right ahead, sir.
Sorry. There's a pending motion to set bond, a second amended motion to set bond that Your Honor hasn't ruled on. If Your Honor is inclined to decline that or deny that motion.
I'm sorry, Your Honor, but the interpreter is having a very, very difficult time.
I can repeat
There's
it.
a lot of...
I can repeat it. He's on Teams. The attorney's appearing on Teams. That's why.
Okay, thank you.
So he's saying that there's a pending motion for bond.
Bien, el abogado ha dicho que hay una petición pendiente para que se le dé una fianza.
And I'm not inclined to hear a bond motion at this time.
Y no estoy inclinada a escuchar una moción para establecer una fianza en este momento.
Because we're set for pretrial.
Porque estamos aquí para vista previa a juicio.
But I will give you a bond hearing date if that's what you request.
Pero si eso es lo que desea, le puedo dar una fecha para una audiencia de fianza.
Understood, and I'm not requesting that at this time.
Okay, he's saying he's not requesting that at this time.
El abogado está diciendo que no está pidiendo eso en este momento.
So would you like for me to set this for a plea, a trial, or a continuance?
¿Usted quiere que pongamos este caso para una declaración para juicio o para aplazar el caso?
A plea, Your Honor.
I want an offer.
Yes, and your lawyer is asking me to set it for a plea date, sir.
Sí, señor. Su abogado me ha dicho que pongamos una fecha para que usted se declare en una oferta en este caso.
I can set you at the earliest for October 13 at 11:15, or let me know.
Lo más pronto que le puedo poner sería para el 13 de octubre a las 11:15 de la mañana.
I'll take that date, Your Honor.
Está bien para esa fecha, su señoría.
Okay, and you want me to schedule all 4 of these cases for that same time?
No, Your Honor.
¿Usted quiere que pongamos todos los 4 casos para esa fecha? No, su señoría.
So which one would you like to set for plea?
The 21 CT 2021.
El caso que quiere que se ponga para declararse sería el 21 CT 21.
And then what do you want to do with the 21 CT 2287
¿Qué quiere que hagamos con el 21 CT 2287
and the 2363?
y el 2363?
Move to continue that, Your Honor.
Estoy pidiendo que aplace esos casos, Su Señoría.
Okay. So the October 13th at 11:15 day will be the plea on the July 20 citations.
Bien, la fecha del 10-13 va a ser para que se declare en el citatorio que recibió el 20 de julio.
And the motion to continue on the August 18th tickets is granted.
Y la petición para que se aplace el caso del 18 de agosto se le va a dar lugar.
Would you
Se va a
like
aplazar.
one docket or two dockets for the continued pretrial?
¿Quiere que se aplace una o dos agendas?
Two docket continuance.
He said two.
Dos.
So that will be continued to December 15th.
Así que ese otro caso se aplaza hasta el 15 de diciembre.
We will have Mr. Tsep transported from the jail on the 13th for his plea.
El señor Tepec lo van a traer de la cárcel para que se declare el 13 de octubre.
And on the case that's been, the cases that have been continued, the court is going to waive speedy trial.
Y en el caso que se está aplazando, la juez presenta una renuncia al derecho de tener un juicio rápido.
Anything else from defense counsel?
¿Alguna otra cosa del abogado de defensa?
No, Your Honor, thank you very much. I really appreciate your courtesies.
No, su señoría, muchísimas gracias por su cortesía.
We do what we can with what we've got nowadays. We do our best.
Hacemos lo que podemos con lo que tenemos en estos días, lo mejor que podemos hacer.
State, do you wish to be heard at all on any of these matters? No,
Se pregunta si la fiscal tiene algo que decir en alguno de estos casos. No, su señoría.
Okay, thank you.
Gracias.
Mr. Sepp, your lawyer is going to be in contact with you.
Señor Sepp, su abogado se va a comunicar con usted.
Thank you, Mr. Pius. Nice to see you.
Thank you. Have a great day.
Thanks,
Bye-bye.
Ms. Romero. Thank you.
You're welcome, Your Honor. Thank you.
Bye-bye. Megan Valley, we did that this morning. And Natasha Russell. Right, thank you. So I'll come back to her once we finish the other ones that we still have right here. We had passed over Mr. Scotsman and we had passed over Mr. Stubbs. So whoever's ready, I'll take next. No, is Russell downstairs? Did they transport her?
It says transport courthouse.
Can we call downstairs and see? Thank you. Miss Russell may be here, but we're going to check right now. In the meantime, Scotsman or Stubbs? All right, Antonin Scotsman, 21 CT 644, 21 TR 9536. All right, sir, can you please, that's not Mr. Scotsman, that's Mr. Stubbs. Oh, you told me Scotsman. I heard Scotsman. Oh, okay, so Clint Stubbs, 21 CT 551. Sir, please raise your right hand. Do you swear to tell the truth, so help you God?
Yes.
Thank you. Please lower your hand and say your name. Sir, the public defender should have a plea form there with your name on it. Did you sign that?
Yes, ma'am.
Did you read it?
Yes, ma'am.
Do you understand all the rights that are in that paper?
Yes, ma'am.
Do you have any questions?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you feel like anybody forced you to make this decision?
No, I don't.
Are you acting under the influences of any types of medications, drugs, or alcohol?
No.
If you are not a U.S. citizen, entering a plea would be a reason to have you deported. Do you understand?
Yes.
And are you willing today to waive your rights and enter this plea to resolve your charges?
Yes, ma'am.
How do you plead?
Yes.
On February 17, 2021, in Osceola County, Florida, were you driving while your license was suspended, canceled, or revoked?
Yes, ma'am.
Did you know the status of your license? State, could you show that he had previously been convicted of suspended with knowledge?
Yes, Your Honor.
Mr. Stubbs, I find that you are alert, that you are intelligent, that you understand, that your plea is freely and voluntarily entered, and that I have a sufficient factual basis, and I will accept it. Sir, what's your date of birth?
04/01/1991.
Thank you. For the record, the court will take judicial notice of the driving transcript certified by the clerk of court, kept in the normal course of the business of the state of Florida in maintaining driving records, and the name Clint Marshall Stubbs, 4191. I see a conviction for driving with a suspended license, May 24th, 2019, Osceola County, and a conviction for driving with a suspended license with knowledge, January 9th, 2020, Osceola County. Therefore, in 21 CT 551, this becomes an adjudication of guilt, 20 days in the county jail with credit for 16, and it becomes a third within 5 qualifying for an HTO. So you will hereby be revoked as a habitual traffic offender for a period of 5 years. Your court costs are $273 and a $100 public defender lien, and you will have 180 days from the date of your release to pay that off. You have 30 days to appeal your sentence. All appeals must be in writing, and if you cannot afford a lawyer, I'll appoint one if you qualify. Thank you, sir. 273? I know, but I changed their offer. Yeah, I told them I wouldn't accept their offer, and I offered him 20 days, and he said he was going to take it. Yeah. And so, Scotsman, Mr. Scotsman. Okay, sir, can you please raise your right hand for me? Do you swear to tell the truth, so help you God? Thank you. Please lower your hand and say your name. Mr. Scotsman, the public defender should have a plea form there with your name on it. Did you sign that? Did you read it? Do you understand the rights that are in that paper? Do you have any questions?
Yeah, the question is, I was just trying to find out that after the 28th, I said I can't be transferred to right here. That's the case. If January gets you down here, will I be released or last day I come here?
I don't know how to answer that, Mr. Scotsman. I'm sorry, because I don't have anything saying that you are in custody. They transported you because we wanted to resolve your case. But you're still getting your Broward County credit.
Yeah, I understand it because they still own my property and all that stuff. They won't release it over here.
Right, so we're going to send you back. So they loaned you to us so we can resolve your case. Yeah, so what's going to happen, I believe, is once we're done with your plea, you're going to go back to Broward and finish serving your sentence. But you should still be picking up your credit for Broward County while you're here. Okay. Yeah, I don't know how to answer that question. I'm sorry. Do you have any other questions? All right. Because I'm not in charge of the credits. I'm not in charge of who gets what credit when you are also in custody somewhere else. So I can't answer that you're not technically in custody on this case. So do you need more time to speak with your lawyer?
No.
Do you feel like anybody forced you to make this decision? Are you acting under the influence of any kinds of medications, drugs, or alcohol? If you are not a U.S. citizen, entering a plea would be used as a reason to have you deported. Do you understand that?
Yes, ma'am.
And are you willing today to waive your rights and enter this plea?
Yes, ma'am.
On March 1st, 2021 in Osceola County, Florida, were you driving without having a valid license?
Yes, ma'am, for a reason.
Well, if you have a defense, that's something you would present at trial. Any other reason, I wouldn't be able to hear it.
Okay.
So do you want to go to trial and present your defense?
No.
Okay. So I find that you are alert, that you're intelligent, that you understand that your plea is freely and voluntarily entered, and that I have a sufficient factual basis, and I will accept it. Pursuant to the negotiations, the offer from the state, it'll be an adjudication of guilt, 10 days in the county jail consecutive to any other jail sentence being served, court costs of $273 and a $100 public defender lien, payable within 180 days of his release from jail. You have 30 days to appeal. All appeals must be in writing. If you cannot afford a lawyer, I'll appoint one if you qualify. I'm going to dismiss the speeding ticket with a warning. Good luck. Thank you. So is she here?
Yes.
Okay.
She's downstairs.
Do the public defenders have anything else?
No, Your Honor.
All right, thank you for your day, for your time.
Your Honor, can I introduce our new addition?
Sure.
This is Edward Lopez, who will be joining us starting on Wednesday.
Hi, Mr. Montes.
Lopez.
Lopez, the mask. Hi, Mr. Lopez. Welcome aboard. Well, hopefully we'll meet each other on Wednesday in person. Thank you.
We're out of here, but happy anniversary, and I hope you enjoy your weekend.
Thank you. Appreciate it. Have a good one. We could bring her up. Is she on her way? Okay. Hey, Mr. Mullins, we've got Miss Russell coming up.
Okay, she's here in person.
Yes, they brought her.
Good thing I didn't go to the jail.
Right?
She'd be standing at the podium and I'd be over there at the jail.
That'd be funny. Is she here now, like hanging out with us, or is she just on loan from Orange County? For us, okay. She bonded on her Orange County case? Okay.
I don't know if we can address housekeeping matters without my client here.
We can. I mean, I'm happy to discuss with you, as long as the state attorney's here, we're okay to talk about that.
If she admits to the violation of probation, I think the concern was to what extent she had to admit in detail any of the criminal conduct that is alleged in the affidavit of violation of probation. If we were to say that it's, that she would admit that her conduct is such that the state could make out a charge of, or the allegation of, that she violated her probation by the greater weight of the evidence on the DUI, would that be sufficient?
I mean, obviously, if we were all on the same page, it might be sufficient. I don't know that we're all on the same page yet. I mean, I haven't heard from the state attorney's office, but I have a big concern. I was going to tell her when she came up. It was a little confusing the way the paperwork got filed, because in the middle of it, the CDP rejection came after we'd already sentenced her to probation. So I had to dig a little bit to kind of figure out why the violation was a violation, because you asked me to find an on view, and I did, and then probation said, Judge, she wasn't on probation yet, and it was confusing. And that's why I had to kind of really take it line by line and track what was going on.
You can't defer sentencing on a DUI.
I agree, I know that, but because probation was asking questions, I looked at the timeline a little bit closer, and then that's where my concern comes from. I let her out of jail in the morning of July 15th, and by 11 o'clock at night, that same night, she's picked up on a DUI in Orange County. Something's going on there that we need to address. So,
Well, I would assume that they would get to that in Orange County. She's more than likely looking at a probationary sentence there.
yeah, but I don't know what they're doing there, so I can't rely on them to do what I have worries about, unfortunately, because that's fallen apart on me before, where I thought somebody else would take care of it and they totally didn't.
Right.
So, hi, Miss Russell. So we were just talking to Mr. Mullins about the different counties and what's going on in the two different cases to see how we could all get on the same page and if that's possible. So I know that when I originally sentenced her, she had 60 days, and then I put her on 10 months of probation. She now, as of today, has 90 days, so she served another 30 days in between the whole Orange County thing. When you asked me to find an on-view and remand her, I did. So I don't know what the state's position on this is, but my understanding, probation has alleged that the new law violation in Orange County is another DUI.
Yeah,
and other stuff.
There are actually 3.
And other stuff, right, but,
Yeah.
so, I took her plea, as I just said to Mr. Mullins in your presence, I took your plea on July 15th in the morning, and by 11 o'clock at night, you got a new charge in Orange County, so that's where my concern comes from. Now, I don't know the strength or the weaknesses of the Orange County case. I have no idea. Obviously, we 3 know, I don't know how much Ms. Russell knows about it. We know a VOP is a lot easier to prove than an underlying charge in general, because the standard is not the same. But ultimately, Ms. Russell, for a minute, if I assume that what happened in Orange County was a legitimate issue, then I need to know how I can make sure you're safe. If I'm gonna deal with the VOP, I need to know that you're not gonna go hurt yourself, you're not gonna go hurt somebody else, you're not gonna get behind the wheel of a car again. You know, those are things that I have to think about if I'm gonna think about releasing you on anything, on any conditions of any kind. Because those are the very real worries that we all have. And I hope you have them, that you share them too. But I don't know, Mr. Mullins, are you representing her in Orlando?
No.
Okay.
Mr. Guidry has those cases.
Okay, all right. So I'm not going to ask you details about the Orange County case if you're represented by another attorney, but realistically, there's no other violation I can talk about because you weren't on probation long enough to violate any of the other conditions.
Judge, she violated, we would be prepared to admit that she violated a condition of her probation, that she not violate any other laws, in that she was charged with DUI in Orange County, and that the state could prove that case by a preponderance of the evidence to this court that would constitute a violation of probation. But we are not prepared to address the other matters, one of which is a 3-year minimum mandatory possession of ammunition by a convicted felon. So obviously, you know, she's not in a position where she can address that, because that matter is still pending, even though the case, my understanding is, has been no-billed at this time. It could always be refiled. So
The entire case is no-billed or just that charge?
just that charge.
Okay. And she posted her bond on the other charges? She's out of custody on the other charges?
Yeah.
Okay. Do you recall what the bonds were? Do either of you know what the bonds were in those charges? So it was a $7,500 bond, probably. Okay. Okay.
And I haven't confirmed myself that that case was no-billed. I'm just going by what my client told me in terms of that. So in any case, even if it were, if she were to address that and make statements with respect to that charge, they could very well refile it.
Understood.
And she would be in jeopardy of being sentenced on that.
All right, well, State, do you have anything that you would like to say or anything? Because we're just set for a status today. I wanted to be able for all of us to get together and kind of, organize our thoughts so that the path moving forward makes more sense and it's clear to everybody. Regardless of what you want to happen, I just wanted to make sure we're starting on the same page and know what to do from here.
Your Honor, we don't have any, the state has nothing to say at this time.
Okay, well,
They agreed to 90 days.
I'm not going to do a.
And I did, yeah.
Yeah, that ain't going to happen.
So, yeah.
The date of offense for our case was December 1st. Looking at your driving record, December 1st, I see the refusal on here. And I see then in July, the conviction for our DUI. And then July 16th, which is the night that we're talking about with the new law, I see a refusal in Orange County. And obviously that case is still pending, so there wouldn't be any other indicator on the driving record yet. Previous to that, you got a lot of issues with your license plate, a lot of tag charges, but not anything else that is incredibly alarming. Mr. Mullins, I don't have the answer yet with regard to resolving the VOP, but I am inclined to consider conditions of release on the VOP in light of the credit that she's got served and the bonds that she's posted in Orlando. So in other words,
We'll set off the sentencing.
well, we could set off the resolution
Right.
to a later date, but I can tell Ms. Russell that it certainly would play much more to my concerns if that's what she was inclined to do, is if she got herself into some treatment facility. Because the charges in Orlando suggest another DUI, and she just got let out less than 24 hours earlier on my DUI. So it would be a fantastic mitigator, because we know she's going to have to do treatment anyway. I ordered it, and a second DUI, if she pleads to it or gets convicted of it, it's going to require level 2 at minimum anyway.
That's right.
The sooner she gets into this treatment, the more beneficial it is for her. Because at the very least, she's got to finish the treatment I gave her already.
So the way what I'm hearing then is that I should, pending her release from jail, if I can arrange for her to be in a substance abuse treatment program, then the court would consider allowing her to be.
That would be much more mitigating to me, that she will not reoffend, and that she will then finish the rest of the conditions of her probationary term that I need her to finish, so that I know she's not going to get back behind the wheel and hurt herself or hurt somebody else.
Is the court considering allowing her to be at liberty without being yet placed in the treatment program, or is that upon placement in the treatment?
No. If I release her today, which I'm inclined to just like maybe PTR her if they actually I don't know if they'll qualify her. I'll set some conditions of release. I'm not ordering treatment as a condition of release. I don't think that's appropriate. But what I'm saying is, if she were then to choose to do treatment, that is not going to hurt her in any way later when you want to plea bargain this VOP.
I hear, you're coming through, Judge. That's fine. We're communicating. Thank you.
State, in light of the 90 days, the additional 30 that she's done, and the bonds that she set in Orange County, the fact that she has attorneys in both cases, and what she just heard me say, do you have any objection or any position with regard to setting conditions of release?
No position, Your Honor.
Okay. So, Ms. Russell, you've been in jail for a while now. Do you have a job? I can't hear you.
Yeah, I'm a server.
Where? Is that really a good idea in light of everything that you're going through? All right.
But I have my accounting degree and I have a nursing degree actually.
Where'd you get the money to hire your attorneys? So you've got money saved? Okay. Do you live with anybody or do you live on your own? Okay. How long have you lived in the Central Florida area? Okay. I'm picking my questions carefully because Mr. Mullins has known me for a really long time, so he knows I'm not going to do anything that's sneaky or underhanded. That's just not the way I operate. But I still want to pick my questions carefully because I'm not trying to trick you into saying anything. My concern is you hurting somebody or you hurting yourself. I have to look at it for right now, worst case scenario. If I let you out, how am I going to feel comfortable that you're not going to drive because your license is suspended right now? And that you're not going to go out and, you know, do something stupid. I mean, I don't think PTR is going to tell me she doesn't qualify, Mr. Mullins, because they call it legal constraints. Because you've got the open charge in Orlando, they're not going to qualify you for PTR down here.
So it would be a release from the court.
It's going to be a monetary release with conditions, but not supervised by PTR.
Right. And Ms. Russell, you understand that, you know, it didn't take long for you last time to be arrested and back in jail. You don't like being in jail. I think we've established that, right? Okay. Do you understand if you violate the court's order, okay, well, just let me ask you, what do you think happens as a result of you violating court orders? That's right.
And then you're going to revoke my bond and the bond in Orlando. So then you're going to be double whammied.
That's right. Plus, you know, you could end up charged with a new offense. So, you know, I guess what the court is looking for is some assurance that you're going to play in the sandbox very nicely. You're not going to do anything that violates your liberty.
I don't really know you. Well, I don't know you. Not really know. I don't know you, but you seem like a nice person who is maybe going through something right now, and I don't know what that is. Or maybe that nice people make bad choices sometimes. Nobody's perfect. But the problem is your bad choices have gotten you into a lot of hot water. And I don't want you to keep going down in a spiral. And that's what I'm worried about. And that's why I'm so hesitant and I'm talking so much. Because if God forbid something happens, you know, it's our names that are going to go in the newspaper that I let you out and that he's your lawyer and that the state had no position. And it's going to be devastating for you. And nobody wants that. I don't want that to happen to you. And I don't want you to hurt anybody. So if I let you out, you gotta realize that if you mess it up, you're coming back to me, and I'm gonna remember that I gave you this big old speech. So, I'm gonna set bond in this case in light of the things that we have discussed. It's gonna be $2,000. I'm gonna say PTR if qualified, but if not qualified, the conditions remain the same. It's gonna be do not possess or consume alcohol. I don't know how that's going to work with your job, but you may have to figure out what else you're going to do besides bartending. Because I don't want you around alcohol, and I don't want you to possess or consume any illegal substances in any way, shape, or form other than prescriptions that are given to you by your doctor that you take the way the doctor prescribes them and only that way. And you can't drive. You cannot drive. The DMV is not going to give you a license at this point until you jump through all their hoops. So you may not drive at all. You must remain law-abiding, and you must return for all your court dates. Understand? Okay.
Judge, she has an employment in a location where alcohol is served, but she's not working in that capacity. Does that, like if she's doing something else?
Yeah, like if she's in the kitchen or if she's a hostess or if she's valet parking the cars, I don't care. But she's not going to be serving the alcohol, which if you're a waitress then, or a server, I should say, I'm old, I'm sorry, I use old terms, but if you are a server, then somebody else is gonna have to bring the drinks to the table.
You understand? Okay.
I mean, but if you've got a nursing degree and you've got an accounting degree, people are hurting for nurses like crazy right now. So,
That's right. Mhm. Yeah, just,
all right, so we're gonna set this for a VOP status. I'm gonna let you all come back in and let me know each side's progress, and then we'll figure out how to resolve it at that point.
very good, thank you.
So, next status date, and please, no offense, don't let me see you before that, will be November the 4th, and the clerk will tell you what time.
2 o'clock.
At 2 p.m.
So that,
2,000 plus those conditions.
conditions. May I confer with my client?
You can go, yeah. All right, we are adjourned until Wednesday. Wednesday, yeah. The 13th. Well. All right, so this is yours. Ernie, talk to her. Make sure she knows.